Court officer.
Yes, madam. Tuesday. Tuesday ಅಂತ ಹೇಳಿದ್ರು.
Court officer. Court video disable ಆಗಿದೆ.
Demolition without conducting.
I do that.
Lordship, one matter, end of the first half, Lordship, there is a threat of dispossession, Lordship.
In surface matter.
Illa, this is, executing court, it has no jurisdiction, already possession warrant is issued, Lordship. Bailiffs are coming today, Lordship.
Randy Mailer.
Odi.
Please.
Date given matter madam. Date given matter madam.
First-
Final list
first
ಅಲ್ಲಿ ಬಂದಿದೆ ಅದು fresh matter ಅಲ್ಲಿ ಬರಬೇಕು madam. 9/10 fresh matter ಅಲ್ಲಿ madam.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
My lords, one matter at 2:30, lordship.
230 why? ಕೊಡಿ 230.
My lords, one matter at 2:30, my lords. One matter at 2:30, my lords.
Hey.
Installing the high tension power grids, my lords.
ಏನ್
Without,
ಪರವಾಗಿಲ್ಲ ಮಂಡೆ.
my lords, without paying
ನಾಳೆ
the costs.
ಮಾಡ್ಬಿಡ್ತಾರಾ? ಅರ್ಜೆನ್ಸಿ ನಿಜವಾಗ್ಲೂ ತೋರಿಸ್ಬೇಕು.
Carrying out the excavation, my
ಪರವಾಗಿಲ್ಲ.
lordship.
Excavation will be over by tomorrow. Please give it sir.
Lost to the
ಸುಮ್ನೆ
standing.
ಎಲ್ಲದಕ್ಕೂ ಅರ್ಜೆನ್ಸಿ ಸುಮ್ನೆ ತೋರಿಸ್ಬೇಕು. 2:30 there is some sanctity to tell. Extreme urgency iದ್ರೆ ಮಾತ್ರ ಎಲ್ಲದಕ್ಕೂ urgency.
Okay, on Monday, my lords.
ಕೊಡಿ. ಎಲ್ಲ ಮಂಡೆ ಕೊಡಿ. ಯಾವ್ದು? ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲೇ ಬರುತ್ತೆ ಬಿಡಿ, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು? ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ವಾ? ಯಾವ್ದು ಕೊಡಿ?
Lordship,
Tuesday,
so one matter is 2:30, the petitioner working as a
lecture
guest
ಅಲ್ಲ?
lecture.
ಬೇಡ, Monday.
Yeah, today the identical matter, two matters are there. sir.
Leave it. Guest lecturers ಯಾವ್ದು ಸ್ಟೇ ಕೊಡಲ್ಲ. Yes.
My lord,
Total 6 matter, threat of dispossession by the.
Total 6 ಇಲ್ಲ. ಕೊಡಿ.
Please, madam. Do that.
First matter, disqualification.
Monday.
2:30.
Monday, sir. Yes.
Disqualification.
So what? Yes.
at 2:30, my lord, issuance of notice by the DCRE, my lord. Yesterday I had moved a memo.
ಏನ್ ನೋಟಿಸ್?
My lord, under section 35, my lord, DCRE police station, my lord, have issued a notice to me.
Oh, DCRE.
Please, at 2:30, my lord, please. Madam,
We'll decide that.
Please.
Necessary. Yes.
seek an adjourn.
I will adjourn it when it is called. Yes. Call the cases. Advocate session, Bagalkot.
Till number 1.
In being spoken to, why?
My lords, in order sheet, my lords, we have challenged the annexure J, my lords, that is order passed by the DRO. But in order sheet, it is reflected the order of another writ petition which was directed to tagged along with, my lords.
ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ ಯಾವ್ದು? ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ಯಾವ್ದು ಹೇಳಿದ್ರಿ?
107982, my lords.
107?
982, my lords.
ಹಾ.
That writ petition was directed to tagged along with this petition. But the order, writ petition order reflect agide order sheet alli. But the order which we have challenged is annexure J, my lords.
ಎಕ್ಸ್ಪೆಲ್ ಮಾಡಿಲ್ವಾ ನಿಮ್ಮನ್ನ? ಎಕ್ಸ್ಪೆಲ್ ಮಾಡಿಲ್ವಾ ನಿಮ್ಮನ್ನ?
ಅದು ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ರೆಸಲ್ಯೂಷನ್
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಮೇಡಮ್?
ಇದರಲ್ಲಿ ಈ ರೆಸಲ್ಯೂಷನ್ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
I will recall this order, post it on Monday for fresh matters. The learned counsel of the petitioner submits that the order that is printed as an interim order is out of inadvertence and another writ petitions order. In that light, this so and so stands recalled. List the matter on Monday in the fresh matters list. Yes. Next.
Seal number 2, Mantesh Patil.
Hearing for my lord. Petitioner in this respond. There are total connected matters, my lord. 2.1 is the, my lord, main matter, my lord. Lord, in 2.1, my lord, writ petition number 107.
What's the matter, really, sir?
Please, my lord. Inquiry report is challenged before this honorable court, my lord. at
Inquiry report ಗೆ appeal ಇಲ್ವಾ? Appeal ಇಲ್ವಾ?
First matter, but first matter, a representation was given by the petitioner to renew, my lord, the renewal of the license, the license of the petition society. But the authority issued an endorsement that two writ petitions are pending, therefore it can't be noted. Therefore, first it is meant to be, my lord, disposal of. Annexure, my lord,
ಈಗ ಫಸ್ಟ್ ಒನ್ ಯಾವುದು ಮೇಡಮ್?
first one ದಲ್ಲಿ annexure
117087 ಅದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ?
11, it's second one is
endorsement, my lord. Endorsement dated, my lord, 11/3/2019 at annexure H, my lord, page number 74 is challenged before this honorable court, my lord.
here. The officer says the two writ petitions,
Annexure H, page
page 74.
4, my lord.
ಸೆಷನ್ ಉಳಿದ ಹಂತದಲ್ಲಿ ನಿಮ್ಮ ವಿನಂತಿ ಪರಿಗಣಿಸಲು ಆದ ಕಾರಣ ಸಂಬಂಧಪಟ್ಟ ಅರ್ಜಿಗಳನ್ನು ಎರಡು ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Pending ಇದೆ.
So, my lord, writ petition number 107499 of 2018 is.
The next matter, next matter.
2.1.
ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡದ?
Close ಮಾಡಬಹುದು.
Please, my lord, ಯಾಕಂದ್ರೆ 5 ವರ್ಷ ಟರ್ಮ್ ಅನ್ನು ಮುಗಿದ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ ಇವಾಗ.
The petitioner is before this court seeking the following prayer. What is called, heard so and so, what is called in question is the communication dated 11/3/2019, which reads as follows. The said communication, the learned counsel for the petitioner submits that the communication itself has spent itself, the communication has spent itself on the score that the term of the managing committee is already over. Even otherwise, the communication only indicated that two other writ petitions are pending until the petitions are disposed. No further action can be taken. In the light of the aforesaid circumstance, nothing further would survive consideration in the case at hand. Therefore, the petition is to be disposed as having become infructuous, having rendered itself infructuous, and is disposed as having become infructuous.
If, my lord, petitioner succeeded in the second petition, my lord, then, my lord, it is liberty may be given to the petitioner to file a fresh representation. my lord.
That will give.
Please.
ಅದರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. In the, it is open to the petitioner to avail of such remedy as is available in law.
Please, please.
Next.
So far as
ನಿಮ್ದೇನು? 2.1.
But here, 2017, Lord, the board of, Lord, committee of management taken certain decisions without any quorum. They have passed a resolution. Lord, I made, Lord, a representation to the authority.
2017 order ಸರ್ವೈವ್ ಆಗುತ್ತಾ ಇವತ್ತು?
ಇಲ್ಲ 2017. 2000. I made, Lord, a representation to the authority to hold an inquiry, Lord, under section 25. Lord,
ಈಗ ಕಮಿಟಿ ಇದೆಯಾ? ಅದೇ ಕಮಿಟಿ
Lord,
ಇದೆಯಾ?
I will inform. Committee ilri. The, Lord, one submission.
ಹೇಳಿ.
Based on my, my lord, the objection, the entire, my lord, the grounds urged by the petitioner herein, the inquiry officer was, my lord, appointed, and inquiry was conducted, and my grievance have been, my lord, considered by the inquiry officer, my lord, that is third petition. Therefore, the third writ petition, the inquiry was conducted, and the inquiry officer, my lord, passed an order, my lord, directing the committee to rectify the defects and conduct the fresh elections, my lord, wide annexure, my lord, page 94, my lord.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಅದು ಸ್ಟೇ ಆಗಿದೆ. ಆ ಸ್ಟೇ ಅಂದ್ರೆ the stay was granted, not the inquiry report, my lord. The inquiry stay is only in respect of the inquiry report submitted to the DR. DR, what he says, but he accepted and sent the report to the society. That is stayed. Not, it can't be not stayed. The inquiry.
ಸ್ಟೇ 8 ವರ್ಷ ಆಗಿದೆ. ಇವತ್ತು ಏನ್ ಸರ್ವೈವ್ ಆಗುತ್ತೆ ಹೇಳಿ?
ಇದರಲ್ಲಿ
ಮ್ಯಾನೇಜಿಂಗ್ ಕಮಿಟಿ ಇದೆಯಾ ಇನ್ನು?
ಆಗ್ಬೇಕು ಅದರಲ್ಲಿ.
ಅಲ್ಲ, ಇನ್ನೂ ಆಗೇ ಇಲ್ವಾ?
ಆಗ್ಬೇಕು ನೋಡಿ. As per enquiry report, fresh committee has to be conducted.
ಅಲ್ಲ, you will dispose this.
My lord, what
8
happens,
ವರ್ಷ
my lord?
ಆದ್ಮೇಲೆ what survives?
My humble submission before honorable court is, my
ಅಲ್ಲ,
lord,
ಒಂದ್
immediate.
ನಿಮಿಷ ಹೇಳ್ತೀನಿ, ನೀವು ಹೇಳ್ತೀನಿ. Based on enquiry report, the authority, the fresh election has to be conducted.
No, let action be taken by the state in terms of the inquiry report. That's all.
State of the page 94, my lord, page 94.
ಈಗ what is under challenge ಹೇಳಿ sir.
The enquiry report,
4/4/2017 is the inquiry report.
26/10/2018, my lord, at annexure, my lord.
ಯಾವ್ದು?
Page number
ಯಾವ್ದು?
86.
What?
Page number 86, my lord, annexure P, my lord.
Annexure?
Inquiry report, my lord.
Huh.
That is under challenge before this honorable court, my lord.
so
So
last,
what is the next course of action for this?
ಅದರಲ್ಲಿ ಈ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಆದ ನಂತರ then the enquiry officer has to send a report to the DR. DR ಅದರಲ್ಲಿ annexure Q.
ಈಗ ಇದು ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ವಾ?
He forwarded the report to the.
No, first you tell me, even if this is done now, what would become of this order after 8 years? We should not simply pass futile rates for
Fresh
useless
election,
rates.
based on the enquiry report, the election has to be conducted. That is only.
Election to with this Sangha.
Board, yes, ma'am.
Election will be conducted even otherwise. Why? Based on the inquiry report.
But enquiry report, there are certain defects has been notified by the enquiry officer. So that is accepted by the, therefore, the.
State will conduct its elections.
State ಬರುದಿಲ್ಲ, ಇದು Society Registration Act. The
society.
annual general body meeting, the election has to be conducted by the AGM. Fresh, based on the enquiry, for a moment, page 94.
ಒಂದು ನಿಮಿಷ, ನಿಮ್ದಾಯ್ತು.
ಇಲ್ಲ, ಅದು ಅದರಲ್ಲಿ ಒಂದು ಲಾಸ್ಟ್, ಲಾಸ್ಟ್ ಒಂದು ಹೇಳ್ತೀನಿ ಅವ್ರು
ಹೇಳಿ.
ಪೇಜ್ 94 ಮಲಟ್, ಪೇಜ್ 94 ದಲ್ಲಿ ಪ್ರಚಲಿತ, ಪೇಜ್ 94 ಇದರಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆ ಮಾಡಿಕೊಂಡು ಈ ಪ್ರಕಾರ ಕ್ರಮ ಇಡಲು ಸೂಕ್ತ ಕ್ರಮಕ್ಕಾಗಿ ಎಂಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟೆಡ್. Now the annual general body meeting, this report has been sent to the DR. Deputy Registrar just he is not forwarded the report as.
What is the ground on which it was challenged? What is the ground on which it was challenged?
Annexure Q, the Deputy Registrar of Cooperative Society, without considering this enquiry report, he passed an order, Annexure Q. He is simply forwarded the enquiry report to the society. Annexure Q, page 95.
ಅದಕ್ಕೆ ಶಿವರಾಜ್ ಸರ್, ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್, 8 ವರ್ಷ ಆದ್ಮೇಲೆ ಈ ಆರ್ಡರ್ ದ ಎಫಿಕಸಿ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದ್ರದ್ದು enquiry report
ಅಂದ್ರೆ ಫ್ರೆಶ್ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಎವ್ರಿಥಿಂಗ್ ಫ್ರೆಶ್ ಟು ಬಿ ಡನ್. ಇದನ್ನೇ ತಗೊಂಡು ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಇದ್ರ ಎಫಿಕಸಿ ಏನು ಅಂತ
ಹೇಳ್ತೀನಿ. Enquiry report to election ಮಾಡಂದ್ರೆ election has to be conducted. That's only based on the enquiry report.
Yes sir.
As per the enquiry report, my lord, dated 26/10/2018, my lord, Deputy Registrar, my lord, without verifying the enquiry report, simply, my lord, by order dated, my lord, 26/10/2018, on the same day, my lord, he is forwarded the letter, my lord.
ಆಯ್ತು, we'll set that aside and direct the Deputy Registrar to redo the exercise.
Enquiry report ಮಾಡಿದ್ದಾರೆ, but ಇದು ಕರೆಕ್ಟ್ ಇದೆ ಇಲ್ವೋ ಅಂತ ಹೇಳಿ he is not verified, my lord.
That we will direct him to verify and then take further action.
ಅದರಲ್ಲಿ
ಅಷ್ಟೇ
ಅಲ್ಲ, rule 6(8) ದಲ್ಲಿ he is like a postman, my lord.
DR is like a postman.
Just not, he accepted enquiry report, he has to send. ಒಂದು ನಿಮಿಷ ಓದ್ಬಿಡ್ತೀನಿ ನೋಡಿ ಇದರಲ್ಲಿ ರೂಲ್ಸ್. If the enquiry report is accepted, my lord, enquiry report is accepted, my lord, the provision says, on the completion of the inquiry, the registrar or the authorized person shall record his finding and communicate the same to the society. The DR, who is the inquiry officer, he delegated his power to the inquiry officer. He conducted the inquiry and the inquiry report has been forwarded to the society. Society has to conduct the election. This is my submission.
The petitioner is before this court seeking the following prayer. The first petitioner is the president of the third respondent society.
But claiming to be
the president of the third respondent society. Communicates list of office bearers of the petitioners, which is said to have been approved by the second respondent. Respondents 4 to 12 are alleged to have, without notice to the petitioners and other members, created certain documents. The second respondent again conducts second respondent yaru? The second respondent, District Registrar of Cooperative Societies, is said to have conducted an inquiry. And ಯಾರಿಗೆ forward ಮಾಡಿದ್ರು?
Deputy registrar.
The retired deputy registrar of cooperative society is the inquiry officer.
An inquiry was sought to be conducted by in section 25.
Section 25.
A section 25 inquiry was sought to be conducted by the second respondent, but delegates the conduct of the inquiry to an inquiry officer appointed. The inquiry officer appointed submits his report. On the report, the district registrar is said to have communicate
Society.
to the society to hold elections in terms of the report of the inquiry officer. It is at that stage the petitioner is before this court 8 years ago, and the further proceedings have remained stayed. The learned counsel Shivraj Mudhol, appearing for the petitioner, submits that the role of the district registrar on the inquiry report is only like a postman, that he would only communicate the findings to this, communicate the the report of the inquiry officer to the society for further action. The learned counsel, appearing for the respondent, would however refute the submission in contending that the district registrar is required to verify the veracity of the findings in the inquiry officer's report and then communicate whether elections have to be held or otherwise. Therefore, the issue now lies whether the district registrar on the inquiry on the report of the inquiry officer appointed by him is merely a postman to communicate it to the society, or has to consider the findings and then communicate after knowing the veracity of the allegations. The issue lies in a narrow compass. Rule 6 ಯಾವ್ದು ಕೊಡಿ?
Society.
Rule 6 of the so-and-so rules.
Rule 6, 8, Rule 6. 8 subclause 5, my lord. Rule 8 subclause.
ಯಾವ
5.
rules, sir?
Society Registration Act.
Act as?
Rules, my lord. Society Registration rules. ಇದು ಕೊಡಿ.
The relevant rules is as follows. Rule 6 or 8 ಏನಂದ್ರೆ
8, 5, my lord. 8
Rule
subclause
8 reads as follows. Rule 8 deals with the inquiry by the registrar. When the registrar proposes to hold an inquiry under section 25 and either on his own motion or an application, or delegate the holding of an inquiry to another authority, the subrule 5 of Rule 8 indicates that on completion of the inquiry, the registrar or the authorized person shall record his findings and communicate the same to the society concerned. In the case at hand, an inquiry under section 25 is delegated to be conducted by the inquiry officer. Inquiry officer where is the report? Page
86, my lord.
The inquiry officer submits his report. The report is as follows. 86
WP number 107-499.
ಅಲ್ಲ ಕೊಡಿ ಮೇಡಮ್, ಅದು ನಿಮ್ದೇನಾ?
ಇಲ್ಲ ಇವ್ರದ್ದು.
In that
499 ಅವ್ರದ್ದು,
ನಾನು-
ನೀವು ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಬಿಫೋರ್ ಎನ್ಕ್ವೈರಿ ಮೈ ರಿಟ್ ಪಿಟಿಷನ್.
Page
90, page
86. Annexure P, page number 86.
The inquiry officer submits his report and the findings
94 page.
are as follows. Clause 8. The inquiry officer recommends that elections have to be conducted to the society. This is placed before the district registrar. The action to be taken is under subsection 5 of section 8. The district registrar communicates it to the society. Adyavadu? Page
95, my lord.
95 annexure Q.
Annexure Q. And he narrated as Rule 8, 5.
one ನಿಮಿಷ.
Page 95.
90?
95. Please.
The communication under subrule 5 of Rule 8 by the district registrar is as follows. The issue now would be whether, as observed herein above, the district registrar under the scheme of the statute cannot act as only a postman. The rule is unequivocal. The rule indicates that on completion of inquiry, the registrar or the authorized person shall record his findings and communicate the same to the society. If the finding of the district registrar, as quoted herein above, is considered on the bedrock of the mandate of the rule, it would undoubtedly fall foul of the same, for the reason that the district registrar the order of the communication of the district registrar does not indicate even a semblance of application of mind. What has come from the inquiry, he has enclosed it and sent it. But the rule is indicative of the fact that the authorized person shall record his findings and communicate the same to the society. There is not a line of finding recorded by the district registrar while communicating the same to the society. Therefore, the action of the district registrar is in a violation of sub-rule 5 of Rule 8. The district registrar shall now redo the exercise on receipt of the inquiry report and communicate the same to the society if need would still subsist. For the aforesaid reasons, the following order. The writ petition is allowed in part. So and so the district registrar stands quashed. The matter is remitted back to the hands of the district registrar to consider the report of the inquiry officer dated.
Dated, my lord, 26/10/2018, my lord.
Dated 26/10/2018 and pass necessary orders communicating it to the society, bearing in mind the observations made in the course of the ordered accordingly.
One submission, my lord, in this writ petition, my lord, ಅದು ಶಿವರಾಜ್ ಮುದೋಳ್ ಅವ್ರ ಪಿಟಿಷನರ್ ಅಂತ ಆಗಿದೆ, ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿ ನಾನ್ ಪಿಟಿಷನರ್ ಅಂತ ಆಗಿದೆ.
ಆಯ್ತು, ಅದೇ ಮಾಡಿ.
ಪ್ಲೀಸ್
ರೋಲ್ ರಿವರ್ಸ್ ಮಾಡಿ. ಎರಡು ಕ್ಲೋಸ್ ಪ್ಲೀಸ್, ಬೋತ್ ಸೇಮ್ ಆರ್ಡರ್.
ಇನ್ನೊಂದಿದೆ
ಇನ್ನೊಂದು ಯಾವುದು?
3 ಕನೆಕ್ಟೆಡ್ ಪಿಟಿಷನ್ಸ್.
ಅದೇ ನಿಮ್ದೇನು ಅದರಲ್ಲಿ?
ಇಲ್ಲ, ಅದ್ರ ಇನ್ನೊಂದು ಅವ್ರದ್ದು.
2.1 for the reasons indicated in 107-499 of 2018, the writ petition 107-116 of 2018, which was filed anterior to the report of the inquiry officer or the order of the district registrar, also stands disposed. Yes, anything else?
Please.
Pawan B. Thodati.
Please, yesterday's matter, lords.
Please.
ನಿನ್ನೆ ಇದೊಂದಿತ್ತಲ್ಲ, ಸಂದೀಪ್ ಪಾಟೀಲ್ ಯಾವ್ದು? ಬುಲ್ ರೇಸ್
ಇದೆ ಸರ್.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ? ಏಜ್ ಬರ್ತಾರೆ, ನೀವೇ ಮಾಡ್ತೀರಾ?
ನಾನೇ ಮಾಡ್ತೀನಿ.
ಒಂದೇ. I'll take it at 11:30.
Yesterday's matter, lords.
ಏನ್ ಪವನ್ ಇದೆ?
Circular was asked to produce.
What circular?
Survivor certificate. What is the course?
Yes, correct.
First and second param, lords.
That he has no jurisdiction.
No.
The petitioner is before this court seeking the following prayer. The heard so and so. The petitioners, permanent residents of Edahalli village, Mudhol Taluk, Bagalkot district, apply on the death of their father, apply for a survivor certificate. The survivor certificate is granted by the competent authority. Yarada? Tahsildar alla?
Please.
By the Tahsildar, the second respondent, who challenges it before the assistant commissioner.
Lords, respond number 5 to 8.
The fifth respondent calls the survivor certificate, challenges this grant of survivor certificate before the assistant commissioner. The assistant commissioner, entertaining the challenge, remits the matter back to the hands of the Tahsildar for reconsidering the issuance of survivor certificate after hearing all the parties all over again. This is what is called in question by the petitioner in the subject petition. The learned counsel Pawan Thodati, appearing for the petitioner, submits that the assistant commissioner in the scheme of the act or the circular does not have jurisdiction to touch upon the survivor certificate issued by the Tahsildar. But if there is any dispute with regard to the said survivor certificate, remedy would be to approach the competent civil court. The learned counsel, appearing for the respondent who approached the assistant commissioner challenging the survivor certificate, would however seek to defend the action of the assistant commissioner, contending that it is only a remand order and the assistant commissioner has not dealt with any of the issue on the merit. The learned AGA also would toe the lines of the counsel Pranav, who appears for which respondent here?
4
As per
to
number
8.
5 to 8.
Respondents 5 to 8.
Please.
I have given my source. The aforenarrated facts are not in dispute. The issue lies in a narrow compass. The issue is whether the assistant commissioner could entertain a challenge to the survivor certificate granted in terms of law to the applicant by the Tahsildar. Submission of the learned counsel for the petitioner that it is without jurisdiction merits acceptance, more so in the light of the fact that the government itself has issued a circular on 12/3/2008. Yavad paragraphs?
Paragraph 1 and 2, my lord.
And the relevant clauses of the circular reads as follows. The circular is unequivocal and is indicative of the fact that a succession certificate issued by the Tahsildar cannot be questioned before the assistant commissioner, but only before a competent civil court. In the light of the said circular, which is in tune with the Indian Succession Act, the order of the assistant commissioner is rendered unsustainable. The submission of both the learned counsel appearing for respondents 5 to 8 and the learned AGA is that it is only a remand order. If the court does not have jurisdiction, it cannot touch the file even, whether it is a remand order or any finding on its merit. As an answer to a jurisdiction is always, answer to a question regarding jurisdiction is always either yes or a no, and can never be a maybe. Therefore, the order being without jurisdiction, the proceeding itself being without jurisdiction, any kind of order that is passed is a nullity in law. In that light, the order dated so and so stands quashed. The parties are at liberty to avail of such remedy as is available in law.
My lord, already civil suit is filed. It may be subject to result of this.
The learned counsel for the respondents 5 to 8 have now would now submit would now submit that civil suit is already filed by
Petitioner.
by the petitioner. Therefore, all the proceedings would remain subject to the OS 132 of 2016.
Please.
132 of 2000.
No, no,
OS
242.
46 of
242.
2021.
Please.
Lords, one more submission, lords. They had also challenged the death certificate also.
Succession and death certificate.
Please.
Please.
Thanks.
Number 4. Avanshi MV.
Observation apply ಆಗಿದೆಯಾ ಇಲ್ವಾ? Learned HCGP is directed to accept notice for all the respondents, madam. Forest Department. List in the first week of January. Next.
Cell number 5.
Same. First week.
Cell number 6. MB Hiremat.
Please.
B Hiremat. Please.
Here for the fourth respondent.
ಆಯ್ತು ಕೊಟ್ರ ಎಲ್ಲ? ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ I have to take it after appraising from the proper gold valuator, my lords. Since there are golden ornaments and silver ornaments.
Day before yesterday, the lordships are directed to be handed over. Yesterday they could have got it appraised. The reason is
There
this.
are more.
The reason is this: from 2017, the offerings of the gold by the devotees is unaccounted. He has to give every details. From 2017, he has been here. The records I have got it. He has been in charge in 2019. There is also already an order.
Appropriate orders.
He has given along with the list.
List on Tuesday in the fresh matters list. In the event the order would not be complied, appropriate orders would be passed directing the Commissioner of Charitable Endowments to be present before.
Make one submission, your lordship.
ನಿಮ್ದಾಯ್ತಲ್ಲ ಬಿಡಿ ಸರ್.
ಅಲ್ಲ, as per records, my lord, the.
ನಿಮ್ದಾಯ್ತು ಮುಗೀತು ಸಾಕು. ಎಷ್ಟು ವರ್ಷ ಇರ್ತೀರ ಅಲ್ಲಿ?
17ರಿಂದ ಇರೋದೇ records
My lord, the petitioner is, my lord, the.
Forget about the petitioner,
Hereditary
sir.
and always.
Petitioner ಯಾರಾದ್ರೂ ಆಗ್ಬೋದು.
Please.
This man cannot stay there for long. How can ಏನ್ ಇಷ್ಟೊಂದು ಇನ್ಫ್ಲೂಯೆನ್ಸ್?
ಅಲ್ಲ, ನಾ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ, ಎಲ್ಲ ಹ್ಯಾಂಡ್
ಅಲ್ಲ
ಓವರ್ ಮಾಡಿದ್ದೀನಿ.
ಅಷ್ಟೇ ಅಲ್ಲ, ಈಗ ನಾವು
But
today
real fact is, my lord, the some articles also, my lord, in the custody of the, my lord, the petitioner.
ಅದು ಏನಾದ್ರೂ ಆಗಿರ್ಬೋದು. This man cannot stay there. He is not fit.
ಅಲ್ಲ, already hand over
He is
charge.
not suitable to hold the post in terms of law, and you hold him for 8 years? No, sir.
I already hand over my all
Charge is
documents.
handed
No,
over.
if he is still wanting, I will direct suspension.
ಅಲ್ಲ, ನಂದು ಏನಿಲ್ಲ, ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ.
Revoke.
ಅಲ್ಲ, ನಾ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ ನಂದೇನಿಲ್ಲ.
Yes, yes.
Please. kindly record that.
ಏನ್ನ
Already handed
ನೋ
over.
ನೋ ನೋ ಪೂರ್ತಿ
ಇಲ್ಲ
ಬಂದಿಲ್ಲ
ಮಾಡಿಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ, ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ.
ಗವರ್ಮೆಂಟ್ ಹೇಳಿ ಎಲ್ಲ ಇದೆ ಅಂತ ಆಮೇಲೆ ರೆಕಾರ್ಡ್
Please.
Cell number 7.
Instead of Malad Tuesday, Wednesday Malad.
ಆಯ್ತು ವೆನ್ಸ್ಡೇ
Please.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
7, Shekhar Gadu.
Please,
Chetan.
Taking for a mandamus, my lords, land is acquired in the year 2012, no
In three
compensation
cases,
is awarded.
in three cases, already my lords, 19-1 notification has been issued and the process of award is under, process of issuance of award is under process.
ಇದು ಚೇತನ್ ಇದು ಆಲ್ ತ್ರೀ ನಾ
There are 4 petitions. Notes in 7, 7.1 and 7.3. Final notification under section 19 is issued.
ಈಗೇನು ಮ್ಯಾಂಡಮಸ್ ಏನು ಕಾಂಪನ್ಸೇಷನ್
Award,
To pass award.
ಪಾಶಾ
Allah, to pass award.
these petitions
notification.
These petitions seek the petitions are preferred by the respective petitioners seek on a singular voice of seeking passing of an award for grant of compensation. The learned counsel Chetan Monalli appearing for the respondent would place on record that in writ petition ಯಾವುದ್ರಲ್ಲಿ ಚೇತನ್
7, 7.1 and 7.3.
7, 7.1 and 7.3 numbers ಹಾಕ್ಬಿಟ್ಟು the passing of an award is under process as section 19(1) notification has already been issued on 9/6/2025 and the award would be passed in within
SLO has to.
SLO is not a party here.
He is a party.
He is a party.
He is a party.
Please,
Government.
Please, your lordship, will.
8 weeks.
3 months,
weeks.
please.
Within 12 weeks from the, the learned counsel Chetan now submits that the SLAO will have to pass the award as the notification is issued and all the documents necessary for passing of the award is already with the hands of the SLAO. The SLAO is the state. In that light, I deem it appropriate to dispose the subject petition with a direction to the state to pass an award and in accordance with law within 12 weeks, within 4 months from the date of receipt of the copy of the order, if not earlier, in the contempt act.
Please, your lordship.
7.2, my lords,
7.2 ಅಲ್ಲೇನು under process.
Under process was 19(1).
Separate order ಬರ್ಕೊಳ್ಳಿ. The learned counsel, the petitioner is before this court seeking the following prayer. The learned counsel Chetan Monalli representing the respondent submits that the passing of a notification under section 19(1), i.e. the final notification is under process and will be passed in is under process and the moment the notification is issued, further process would be taken to communicate the documents to the SLAO to pass the award. Recording the said submission, the petition stands disposed, reserving the liberty to the petitioner to approach this court in the event of need or in the event of need of an award not being passed by the respondents or the award being delayed by the respondents. Yes, not being passed but delayed by the respondents. All right,
please.
next.
Great.
8. Sunil Desai.
This is, yes, all the administrative post of KIMS, my lord, were being
Lordship,
filled up on in charge
Let
basis.
the
Your lordship
respond
says
number
direct.
3 may be served, your lordship.
Hello?
KIMS. I will get information, your lordship. I have already processed. It is under.
They served unrepresented. Why you want?
KIMS, ಯಾರು
CEO,
ಇದ್ದಾರೆ?
CAO,
ಯಾರ್ KIMS
KIMS.
ಅವರಿದ್ರೆ ಒಳ್ಳೇದು ಇದಕ್ಕೆಲ್ಲ. ಯಾರ್ notice
But the appointments was to be by them.
Even
what's the issue? Tell me.
My lord, all the posts.
ಎಲ್ಲ
of-
in charge ಇದ್ದಾರೆ ಅಂತ.
In charge
Yes,
ಇದ್ದಾರೆ.
yes, madam.
ಅಲ್ಲ ಅದಕ್ಕೆ
And principal post, my lord, from last 20 years it has been in
if the
in charge.
council on KIMS will be present, your lordship, it will be easy. Because as
ನೀವು-
per my instructions, your lordship, many posts are filled ಅಂತ ನನ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ
ಅದೇ ಎಲ್ಲ ಫೀಲ್ಡ್ ಆಗಿದೆ,
For that-
in charge ಆಗಿದೆ ಅಂತ.
In charge ಅಲ್ಲ.
Regular ಇದೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರಿಗೂ ಅವರು ಇದ್ರಲ್ಲಿ
Direct action to be taken by the medical council.
it was
If you don't fill up posts, ಎಲ್ಲ in charge ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ.
your lordship,
And
respond
NMC
number,
guidelines.
let the respond number 3 be present.
ಜೆ ಅನಿಲ್ ಕುಮಾರ್ ಸರ್ವ್ ಮಾಡಿ.
ಅಲ್ಲ ಜೆ ಅನಿಲ್ ಕುಮಾರ್ ಅಲ್ಲ.
ಪಾಟೀಲ್ ಅಂತ.
KIMS ಯಾರು ಸರ್?
ಕಿಮ್ಸ್ಗೆ ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಅಪೇರ್ಸ್.
ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಜೆ ಅನಿಲ್ ಕುಮಾರ್.
ಜಿಡಿ ಪಾಟೀಲ್ ಅಂತ
ಇಲ್ಲ ಇಲ್ಲ
ಜಿಡಿ ಪಾಟೀಲ್ ಅಂತ
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರ ಅಬ್ಬಯ್ಯಾಗ ಅಪೇರ್ ಆಗಿರೋದು. ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಅಪೇರ್ಸ್.
ಇಲ್ಲ ಗೋಪಾಲ್ ಪಾಟೀಲ್ ಅಂತ ಯಾರು?
Gopal Patil last date appears for the candidate So in that case, transfer case.
ಯಾವ್ದಲ್ಲ ಕರೆಕ್ಟ್.
So
ಅದರಲ್ಲಿ ಫೈಲ್ ಸಂಶಯ ಗೊತ್ತಾಯ್ತು.
Arvind is there, my lord. In that case, he has given NOC.
ಆಯ್ತು, ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಇದ್ದಾರಾ? Learned counsel. Arvind Kulkarni is directed to accept notice for the respondent, Karnataka Institute of Medical Science and Research Center. The petitioner to serve set of papers upon the aforesaid counsel forthwith in the light of the fact that that who is to answer is the KIMS, answer KIMS with regard to the in charge arrangements being made for ages of the posts that are in KIMS. List the matter on 12th in the fresh matters list. Yes, next.
Till number 9, Chin Koda Reddy. PS Kamte.
Your Lordship, I seek a 2 days of time, Your Lordship, to place the
I
judgment.
no grant 2 days time. What's the matter?
Your Lordship, that is
Oh,
with
ida?
regard. Yes, Your Lordship. 2 days time, on Wednesday, Your Lordship.
List next Friday. Fresh matters, next.
10.
BS Kamte name has been removed.
The register to delete the name of BS Kamte is appearing for the respondents.
Name has been removed.
Removed?
Has.
ಇಲ್ಲೇ ಇದೆ, ಅದಕ್ಕೆ ರಿಮೂವ್ ಮಾಡಕ್ ಹೇಳಿದೆ. ಇರ್ಬೇಕಾ? ಬೇಡಲ್ಲ.
Till number 10, HM Dharwad.
Per petition. Matter pertaining to dispute in charge principal.
Yes, sir.
Two dates. Second of
minutes,
June.
Take 20
Two dates,
minutes.
two dates.
2 dates.
2nd of June 2009, I came in as a grantee need.
2/6/2009.
9. 3/3/2013, he comes.
ಯಾವಾಗ?
3/3/2013. Earlier, he was working as a part-time. Earlier, after he comes in grantee need. My lords, as per seniority list, I am senior. Even till date. That seniority is not challenged, not reversed, nothing. Lords, thereafter, he comes before this honorable court, and on 28/2/2022, my lords, he secures an order directing to consider his representation. My lords, that order considers earlier 2010 writ and SLP, but what it misses is, my lords, the further developments that have taken place. Please, my lords. My lords, there was an enactment in 2014. In fact, this is declared as unconstitutional. Yes, but the appeals are pending. The writ appeals are pending before, and my lords, it came before my lords, and my lords have passed several orders. But those orders are with respect to the payments. The contempts to alter the seniority lists are kept in abeyance. No actions. And the seniority list shows that I am the senior. The senior most holds the principal in charge. My lords, I am disabled to challenge he securing the higher pay than me. My lords, I cannot have an objection. I admit to the lower pay than him, my lords. But my lords, as please, as I hold the senior post,
free ಕೂತ್ಕೊಂತೀರಾ?
my lords, as I hold the higher position in the seniority list, my lords, I am enabled. And after that, after the 28/2/2022 order, again he approaches this honorable court, and this honorable court directs him to approach the competent forum under 94. That was the direction. He again came back to this honorable court. And once it is held not maintainable,
94 maintainable ಅದು.
Yes, appeal. A seniority list has to be altered.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
My lords, the
Section 94 of the Education Act ತೆಗಿರಿ.
Reduction in ranking.
You remove that C 94. ಅದ್ರಲ್ಲಿ maintainable ಅಂತ ಹೇಳ್ಬಿಡಿ.
My lords, the ranking.
ಹೇಳಿ ಸರ್.
Reduction of ranking is, my lords.
Oh, yes. Who is reduced in rank now?
He has to come up above me in the seniority list. I stand senior first.
Can a seniority list be challenged under section 94, you tell me?
It amounts.
Can a appeal be filed before the EAT under section 94 challenging a seniority list?
My lords, it amounts to reduction.
What amounts ಏನೋ ಬರ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು ಬೆಂಚ್ ಹತ್ರ last time? ಯಾವುದು?
I was not a part.
94 ಕಳಿಸಿದ್ದು ಎಲ್ಲಿ? Which order is that?
It is
along with my
vacating stay.
Vacating
9
stay.
and 10.
That is, my lord, the order passed by the deputy commissioner. The
Same order.
He said coordinate bench sent you to 94. ಎಲ್ಲಿ ಅದು?
Statement is
9
vacating
and 10,
application.
my lords, along with vacating stay.
Justice Indresh ಅವ್ರದಾ?
Please. This is subsequent to the 2022 order. And now the order is also passed in the same language, and my lords, everything is same. The reliefs claimed are same. prayer is identical.
ಆಮೇಲೆ
Only those two contentions, my lords, because the seniority has to be altered and that amounts to reduction in
No.
ranking. That's my contention.
by way of an competent ಏನ್ ಬರ್ದಿರೋದು ಹೇಳಿ ಇಲ್ಲಿ?
My lords,
ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಹೇಳಿ? ಏನ್? ಅಯ್ಯೋ, don't beg the question, read.
the order passed by the third respondent is an appealable order under the provisions of the
Ah.
Karnataka Education Act.
ಹೌದಾ?
Yes.
94 ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
That provision is not.
94 ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
I admit that.
130 ಲಿ ಹೋಗ್ಬೇಕು ಬಿಫೋರ್ ದಿ ಕಾಂಪೆಟೆಂಟ್ ಅಥಾರಿಟಿ. 94 ಲಿ can you set aside a seniority list?
No.
ಏನ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Again, the similar order is passed.
What similar order?
Let
is
him
passed?
go in 130, my lords.
No, no. Two wrongs will not make a right, sir. Whoever commits, I may commit, you may commit, somebody else may commit.
But my lords, across state, my lords, the seniority lists remain unaltered, my lords, and the
That's a
contempts are
different,
getting
you
up.
come on merits. Don't tell section 94 li seniority list can be challenged. To say the least, it is preposterous.
These two are my only contentions.
ದಾರಿಗೆ ಹೊಂಟ್ರೆ ದಾರಿಗೆ ಬನ್ನಿ.
Please.
ಹೇಳಿ.
The appointed in the year 1993 as a temporary teacher. His post is approved in the year 1995. The service is regularized in the year 2013.
Regularized.
Regularized service 2013. Then he approached his honorable court. The request the respondent to count his past service from the date of initial appointment till approval. That is ordered by this honorable court annexure H.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ?
annexure H ಮಲಾಡ್.
ಪೇಜ್
41. page 37 ಮಲಾಡ್.
ಕೊಟ್ಟು ಆಗಿದೆಯಾ ಅದು?
ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದೇ ಸೇಮ್.
para 4 ಮಲಾಡ್.
ಅನ್ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ರೆ.
Subsequent based on malad that is upheld by the malad the apex court also malad.
ಆಮೇಲೆ
Therefore malad he is most senior in the malad institution. He is appointed in the year 2013 as a in charge principal. That order not at all questioned by the malad.
Who is appointed?
The petitioner.
No,
2013 itself.
Please.
2013 itself.
Lala, when did you become principal, sir?
Never. All the orders came before my lords and he was directed to competent authority, never handed over the charge.
Sir, 2000 management in charge principal.
No, why are you before the court, sir?
He approached the malad the authority.
Now the order directs.
The authority now mal pass an order. Promote the malad the respondent as a in charge principal.
Promotion alla ಅದು
in charge principal
recommends the
annexure A malad.
ಆ ರೆಕಮೆಂಡೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ?
Yes. Last time also.
Without hearing the petitioner. Petitioner already in charge principal in from 2013. Without hearing the petitioner.
ನೀವು ಯಾರು ಸರ್?
And the management lords.
Who is principal?
The present predecessor the principal was principal.
You want to become principal?
I always wanted to, my lords, never became.
You always wanted. Law is coming in your way.
Never, my lords. The orders are in my favor. My lords have directed.
Is in your favor, sir.
The last order, 28/2/2022, same order was challenged, and my lords, he was directed to approach the competent court. He never approaches. Neither the charge is
Then how
handed
did he
over.
continue?
That is withdrawn. That is withdrawn subsequently. Government withdrawn that order.
Again, a fresh order is passed. Same order.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner, the fifth respondent, appoints the petitioner as a temporary as a lecturer on temporary basis on 5/7/1993. His appointment comes to be approved by the state on 19/1/1995, and in the year 2013 is said to have been regularized in the cadre of lecturer by an order dated 13/3/2013. This remains the service record of the petitioner. The contesting respondent, you have respondent name?
6.
The contesting respondent number 6 enters the institution on 4/12/2013.
26/2013.
9.
29.
Please. 2/9/2013.
26/2009.
9.
9. Yeah, euro.
Yes.
2/6/2009. The claim of the sixth respondent is that he should be appointed as principal on in charge basis, as in charge principals in all these institutions are appointed on seniority basis. As the sixth respondent had entered service on 2/6/2009, his claim always subsisted. The petitioner then submits a representation to the state to consider his case for, to take his service, past service, for the purpose of, for all benefits, right from the date of his entry into service, that is 5/7/1993, or from the date of approval, as the case would be, on 19/1/1995. The said request is acceded to by the state in the light of the judgments rendered by this court, by the coordinate benches of this court, affirmed by the division bench, and an SLP against which comes to be turned down. The learned counsel for the sixth respondent now seeks to distinguish the same, contending that it was the judgments were rendered only on pay, pension, and all other terminal benefits, and an act that was and an enactment that was brought in 2014 is held to be unconstitutional, and appeals against the said order is pending. The seniority issue, or the taking the past service into consideration for the purpose of seniority and all other service benefits, is not the one that is rendered in the act, nor while annulling the act by the coordinate bench. The said submission of the sixth respondent is unacceptable for the reason that the enactment, the coordinate bench holding the act to be unconstitutional comes about in the year 2016. The petitioner's right did not flow from the said enactment. It flew from the judgments that were rendered by this court in the year 2009-10, the division bench judgment later, and the Supreme and the apex court turning down the SLP. All that led to the enactment of 2014. Therefore, the right of the petitioner was not in terms of the enactment of 2014, but prior to the said enactment. Whatever has happened prior to the said enactment have all been protected by the judicial orders passed when the constitutional validity of the Act of 2014 was called in question. In that light, the petitioner's service being taken into consideration for all purposes with effect from 19/1/1995 cannot mean that the sixth respondent who comes into service of the institution in the year 2009 could claim seniority over the petitioner for the post of appointment of for appointment to the post of in-charge principal. The in-charge principal, as observed here in above, is appointed on principal on in-charge basis made to officiate on seniority. If it is on seniority, it cannot be said that the sixth respondent is senior to the petitioner. However, all the rights of the parties would be governed by what the division bench would hold while answering the annulment, answering the order of the learned single judge which held the Act 34 and Act
2014,
Act 7 of 2014 to be unconstitutional.
Yes.
With the aforesaid observation, in the light of the aforesaid observation, the impugned order dated 4/8/2025 is rendered unsustainable. The unsustainability of it would lead to its obliteration. In that light, allowed, quashed, the petitioner shall be entitled to all consequential benefits. It is however, the parties would be governed by what the division bench would hold in the writ appeals pending against
Rate appeal number 2476 of
2476 of
2015.
2015. Yes.
Very great.
11.
For the respondent.
Yes, sir.
My lord,
So what, madam, here?
my lord, there's a reason, that's what I wanted to submit.
Rate of
My lord,
interest.
the rate of interest, my lord, what is happening is this judgment is affecting the cases in principal court, my lord. That's one of the reasons, my lord.
I'm taking it.
Yes, my lord.
Yes.
My lord,
Already
the-
there, covered on that.
My lord, the only issue is, my lord, whether it is 9% or 6% on leave encashment.
Because division bench has said 9%, is it?
My lord,
Lord.
I'll take your lordship to that, my lord. I have produced all the.
Yes, what's the
But
matter?
the coordinate bench has granted 9% interest.
Interest on what?
Interest on belated payment of leave encashment.
Only
benefit.
leave encashment or anything else?
Only leave encashment.
Only leave
Yes.
encashment, all right.
Lord, the corporation has filed writ appeal. 65 writ appeals.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು?
9%.
ಆಯ್ತು. ಕಾರ್ಪೊರೇಷನ್ ಫೈಲ್ಸ್ ರಿಟ್ ಅಪೀಲ್.
Writ appeal. Lord, in writ appeal, the corporation has agreed to pay 7%.
7%?
Yes. And employees in writ appeal, my lord, accepted the same.
All right.
Lord, another coordinate bench has granted 9% interest on all terminal benefits.
All
Gratuity, leave encashment.
ಈ ಇಷ್ಟು ಮ್ಯಾಟರ್ ಇಶ್ಯೂ ಲೀವ್ ಎನ್ಕ್ಯಾಶ್ಮೆಂಟ್ ಮಾತ್ರನಾ? ಆಯ್ತು.
And the corporation has filed writ appeal. Writ appeal came to be dismissed. Against which,
So,
my lord,
9%?
9%.
And the matter has reached finality because we filed an
Good,
SLP.
good. Oh, it
SLP,
was.
yes,
SLP
SLP is
dismissed.
rejected, my lord.
They have filed review also dismissed.
Dismissed in limine.
Yes.
My lord, before that, my lord, the order of the division bench, my lord, I have filed statement of objection. Page 47, my lord, in page 47, my lord. In the statement of objections. And kindly come to, my lord, page number 50, my lord. 51. 50 and 51, my lord. And conclusion para is para 5. Another contention of the corporation, your lordship, is that the government has issued some order whereby rate of interest is prescribed. And DS Nakara judgment is, which has no application.
ನಕಾರ ಇದಕ್ಕೆ ಏನು ಸಂಬಂಧ?
My lord, now, my lord, all these judgments, my lord, the financial aspects of the corporation was not placed, my lord. None of the matters, my lord, and I would only, my lord, I'll be taking your lordship to the annexures and also the judgment of the apex court covering this issue, my lord. The financial aspects, if I'm able to show that I'm not a profit-making organization.
Yes,
and
madam. Corporation is profit-making organization.
Okay, kindly come to annexure R1. Kindly see annexure R1, my lord. Annexure R1, may I take your lordship to annexure R1, page 7, my lord. This is the balance sheet, my lord, for all the years for 2019-20, 2021, 21-22, 23.
And last ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ತೋರಿಸಿಲ್ಲ, loss ಏನೆ. My lord, minus 157. My lord, this was during, the first column is during COVID period, my lord. The second,
correct. It began with COVID.
yes, my lord. And so the second column, my lord, is again, my lord, strike. This also second COVID, second wave, my lord, of COVID-19, and also, my lord, strike period, my lord, which I'll be then 22, my lord, 23 up to 22, my lord. The government was granting, was paying me the, my lord, sanctioning grant for payment of salary, which I have produced. All these facts was never produced before in the earlier proceedings, my lord. This, my lord, kindly come to annexure R2, my lord. In annexure R2, my lord, the state government, my lord, passed an order, and at page number 10, my lord, before that, my lord, if your lordship could see the preamble, my lord, kindly come to annexure R2, only one paragraph, my lord. November, second paraದಲ್ಲಿ, ನವೆಂಬರ್ 24 ಮಾಹೆಯ ಅಂತ್ಯದಲ್ಲಿದ್ದಂತೆ 4 ನಿಗಮಗಳಲ್ಲಿ ಭವಿಷ್ಯ ನಿಧಿ, ನಿವೃತ್ತಿ ನೌಕರರ ಉಪಧನ, ರಜೆ ನಗದೀಕರಣ, ದಟ್ ಇಸ್ ಲೀವ್ ಎನ್ಕ್ಯಾಶ್ಮೆಂಟ್, ಇದ್ರ ಎಲ್ಲ ಸೇರಿ ಹೊಣೆಗಾರಿಕೆ 6,330.25 ಕೋಟಿ, 6,330 crores was the, my lord, in page number 10, my lord, the government by order dated 31/12/2024 had permitted all the 4 corporations, my lord, to avail loan from the financial institutions to, my lord, to pay the gratuity and the leave encashment benefits, my lord, and which is, and also by taking loan from the financial institutions. But the loan that I have raised from financial institution, the interest I am paying is much more than 9%, my lord. This is one aspect, my lord. And kindly come to annexure R4, my lord. R4 is page 13. My lord,
Page?
R4, my lord.
13.
13. My lord, in this, my lord, I have given that the details of the, my lord, the benefits, my lord, that I am giving, my lord. Kindly come to student pass, my lord. There's a concession pass from 1 to 3 for freedom fighters, my lord. This full amount is full free, my lord. Then blind, physically handicapped, widow of freedom fighters, senior citizens, dependents.
23 ಆದ್ಮೇಲೆ ಏನು ಹೇಳ್ಬೇಡಿ.
ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ 2,375 crores.
ಅಲ್ಲ ಆಯ್ತು, 23 ಆದ್ಮೇಲೆ ಏನು ಹೇಳ್ಬೇಡಿ.
ಇಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ.
ಇಲ್ಲ ಮಾಡಿದೀರಾ, 23 ಆದ್ಮೇಲೆ ಏನು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ, ಅದು ಲಾಸೇ ಆಗದು.
Everybody knows. My lord, then this is the why I produced all these things, my lord, to show that it's not a profit-making organization. And there are concessions, my lord, that is being given, my lord, to the oppressed classes and student and women. And kindly come to page annexure R5, my lord. In annexure R5, my lord, the state government from 24/7/2020 onwards, my lord,
R5 page, madam.
gave me, my lord, page number 25, my lord.
Ah,
In, my lord, about the state government, my lord, by order dated, which is at page number 26, 24/7/2020, my lord, released, my lord, for the month of June 20 and July 20, 426 crores, my lord. And in that, there's a
ಅದು
condition.
COVID time ಅಲ್ಲಿ.
COVID time ಅಲ್ಲಿ. Kindly see page 27, my lord. In page 27, condition number 4, my lord. ಗಳಿಕೆ ರಜೆ ನಗದೀಕರಣ ಹಾಗೂ ತುಟಿ ಭತ್ಯೆ ಹೆಚ್ಚಳವನ್ನು ಪಾವತಿಸತಕ್ಕದ್ದಲ್ಲ. ಇನ್ ನಂಬರ್ 1, my lord, what he said is, ಮೇಲೆ ಬಿಡುಗಡೆಗೊಳಿಸಲಾದ ಅನುದಾನವನ್ನು ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ಮೂಲ ವೇತನ ಹಾಗೂ ತುಟಿ ಭತ್ಯೆಯ 75% ವೆಚ್ಚವನ್ನು ಭರಿಸಲು ಬಳಸಿಕೊಳ್ಳುವಂತೆ ಉಳಿಕೆ ವೇತನವನ್ನು ಸಾರಿಗೆ ಸಂಸ್ಥೆಗಳು ಸ್ವಂತ from their own resources, they have to pay 25%, and the government, my lord, gave grant of 75% to disperse salary, my lord. That too, the salary was being dispersed during this period, my lord, with only basic pay and DNS allowance and without any allowances, my lord. These are the orders, my lord, which I have produced from up to, my lord, that is July 21, my lord, July 22, my lord. I was given, my lord, support to run the establishment. One more thing happened, my lord. The SOP, my lord, was issued immediately after the COVID lockdown was lifted. It so happened, my lord, there was, in terms of the SOP, I could only permit, my lord, one seat, one person, my lord, for one seat, one person, my lord, was traveling.
Because of COVID.
There was heavy loss because I was running buses with a limited number of passengers, my lord. The same amount of expenses I would incur, but less number of. So this is one aspect. And as I was then in December 11th, 12th, and 13th, my lord, there was a snap strike by the entire state, my lord, by the employees. Again, my lord, the graph went down. Added to this, my lord, in April 4th, my lord, April 7th, the strike was called till April 7, 2021 to 24/4/2021 for about 21 days, my lord. It came to a standstill, my lord. There, the graph went zero. Then, my lord, immediately was the second wave, COVID, my lord. And after that, my lord, till today, the corporation has not recovered from its losses. And these are the facts, which was not brought to the notice, my lord, and which was not argued, my lord, before the earlier bench, my lord.
Why you don't do that?
My lord,
seriously don't understand. If you have some case, you should.
Yes, my lord.
ಇಲ್ಲೇ ಆಗಿರೋದಾ ಇದು?
ಇಲ್ಲೇ ಆಗಿರೋದು. My lord, kindly come to annexure R9, page 37, my lord. My lord, the state government.
ಇವರು ಅಲ್ಲ. ನಿಮ್ ಹಿಂದೆ ಇರೋರ ಅಂತ ನೋಡಿದೆ ಅವರು. ಪ್ರಶಾಂತ್ ಉಸ್ಮಾನಿನೂ ಅಲ್ಲ. Yes.
My lord, page 37.
Because generally he will.
This is the order.
Lords, Justice Kamal, my lords, some points were not in this detail, but some points were argued, my lords. And therefore, my lords.
COVID-19 is argued.
6% was granted.
6% was granted at that point of time.
And they have paid the 9%.
My lord, there was even for that 6%, the corporation challenged, my lord. There was a clause there. So, I mean, default clause was there, my lord. Failing which to pay 9%, they ended up paying 9% because.
9% ಕೊಟ್ಟರು.
9% ಕೊಟ್ಟರು, contempt ಹಾಕಿದ್ರು.
ಅಲ್ಲ ಅದು SLP ನಲ್ಲಿ. I think probably in SLP they should have taken the extension of time. Probably they did not think of it. My lord. My lord, in annexure R9, which is considered, my lord, by the division bench in para 5, my lord, the order is at page 37, my lord. The division bench was pleased to observe.
Division bench.
Yes, my lord. I read it to your lordship, my lord.
37.
Kindly, at page 51 of the division bench order, there is a reference to the government order, my lord.
ಅಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರಲ್ಲ
ಅದರಲ್ಲಿ ಒಂದು
ದೀಕ್ಷಿತ್ ಸರ್
page 51 para 5. Idrili, another contention of the corporation is that government has issued some order whereby rate of interest is prescribed at 5.54%. However, the learned counsel is unable to place on record the said order is able to answer to as to under which statute such order is passed by the state. Kindly come to annexure R9, my lord. My lord, I'm page number 37. In page 37, my lord. My lord, the state government, my lord, the corporation, my lord, in the absence of any rules, my lord, for leave encashment, there are no rules, my lord. So in the absence of any.
How are you paying leave encashment?
My lord, that is in, sorry, to pay interest, my lord.
Interest rules or no rules?
Anyway, my lord, My lord, what has happened in such circumstances, wherever there is no such provision is made, my lord, in the corporation, with regard to the interest, we adopt the
Yes,
state
yes.
government. Well, kindly come to page number, para 2 of page 37, my lord. It says, my lord, ಇತ್ತೀಚಿನ ವರ್ಷಗಳಲ್ಲಿ ಮುಂಚೆ 8% ಇತ್ತು. 8% ನ my lord, ಇದರಲ್ಲಿ in terms of reference number 2 dated, order dated 21/8/2003, my lord, the rate of interest prevailing was 8%. In para 2, my lord, ಇತ್ತೀಚಿನ ವರ್ಷಗಳಲ್ಲಿ ಅನೇಕ ಕಾರಣಗಳಿಂದ ಆರ್ಥಿಕ ಕ್ಷೇತ್ರದಲ್ಲಿ ಬಡ್ಡಿಯ ದರವು ಇಳಿಮುಖವಾಗಿರುತ್ತದೆ. ರಾಷ್ಟ್ರೀಕೃತ ಬ್ಯಾಂಕ್ಗಳಲ್ಲಿ ನಿಶ್ಚಿತ ಠೇವಣಿಯ ಮೇಲಿನ ಬಡ್ಡಿ ದರವು ಗರಿಷ್ಠ 5.4ರಷ್ಟು ಹಾಗೂ ಜಿಪಿಎಫ್ ಬಡ್ಡಿ ದರವು 7. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಿಳಂಬವಾಗಿ ಪಾವತಿಸಲ್ಪಡುವ ನಿವೃತ್ತಿ ಮರಣೋತ್ತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ ನಿಗದಿಪಡಿಸಲಾದ ವಾರ್ಷಿಕ ಬಡ್ಡಿಯ ದರವನ್ನು ಪರಿಷ್ಕರಿಸಲು ನಿರ್ಧರಿಸಲಾಯಿತು. 8% my lord was reduced. So this is the basis, my lord. Probably it was not read out to the division bench, my lord. Probably, my lord, in its context. The context is, my lord, the state government took into consideration the prevailing FD rate. Assuming for a moment I pay him, my lord, the amount, what is the prevailing FD rate? So taking into consideration, my lord, the 5.48, my lord, it was read. Therefore, it was argued, my lord, by the corporation, on behalf of the corporation, that the interest rate on all the terminal benefits should have been 5.58%, my lord. Keeping this, my lord, in view, my lord, I have already given the judgment of the judgments, my lord. I've shared it with him. But,
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
judgment, yes, ಕೊಟ್ಟಿದ್ದೀನಿ. And the order, my lord, passed in AR 2021 SC 2669. My lord, in this case, my lord, what has happened? The gist is only this, my lord. During COVID time, the state government passed an order, my lord, stating that the salary, my lord, was denied to the certain class, my lord. It was for the IAS category, my lord.
IAS?
ಅಲ್ಲಿಂದ ಶುರು ಮಾಡ್ತಾರೆ. Kindly come to the second page, my lord. There shall be 100% deferment in respect of this honorable CM, honorable ministers.
ಅಲ್ಲ ಅದು ಗೊತ್ತು ಬಿಡಿ.
ಇದೆಲ್ಲ ಹಾಕೊಂಡು, my lord,
ಅದು ಅವ್ರಿಗಾಯ್ತು. ಪೂರ್ ಪೀಪಲ್ ಎಲ್ಲಿಂದ ಡೆಫರ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
My lord, in respect of 4, my lord, in respect of 3, there shall be 50% deferment in respect of all government employees, including work charged. Clause number 3, my lord, 3 and 4. My lord, the matter, PIL was filed, my lord. The matter was taken, my lord, before the High Court. The High Court was pleased to order, my lord, there was a first direction was issued to pay forthwith whatever the difference in amount. They paid, my lord. After that, 12% was levied, my lord. And kindly see para 9, my lord. On the above premises, the High Court directed payment of the deferred salary for the months of so and so, together with interest at
12% 6% ಗೆಲ್ಸಿದ್ರು.
Yes, my lord. And also, my lord, one aspect is important, my lord. Para 15 ಅಲ್ಲಿ, what they say, my lord, is last ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ, having regard to the rate of interest, that is having regard to the prevailing bank interest. The rate of interest from 12% is fixed at 6%, my lord. This judgment was not cited, my lord, because now I'm placing reliance on this judgment with reference to all the annexures, my lord, which I have placed. There also, my lord, in fact, my lord, in this case, in para 12 and 13, the court, the apex court, my lord, also takes note of the financial position, my lord, during COVID, and comes to the conclusion that it was not a deliberate intention of withholding their salary. So when the court, my lord, the important aspect is much more than terminal benefit is salary. Salary itself, my lord, should have been, it's a livelihood of a person which was denied. For that itself, the court has, the apex court has reduced the interest from 12% to 6%, my lord. Therefore, under such circumstances, the interest, my lord, I am pressing for 5.48, my lord, but I would.
ಇದೊಂದೇನಾ ಜಡ್ಜ್ಮೆಂಟ್?
But one more is there, my lord. That is state of Uttar Pradesh versus Virendra Pal Singh, my lord. The same aspect, my lord.
ಕೋವಿಡ್ ಏನಾದ್ರು?
My lord, if your lordship could come to
16.
para 8, my lord, 10% per annum was
The capacity of the employer.
Yes, yes. And then, my lord, and if I'm permitted, my lord, I'll cite the judgments of the other high courts, my lord. It's a persuasive, that's a division bench judgment by the High Court of New Delhi, my lord. The para 17, my lord, is a directly on the point, my lord, para 17. The respondents are directed to pay interest at the rate of 6% to the petitioner for the delayed payment from the date when the amount under the leave encashment became due to the petitioner, para 17, my lord, till the actual date for the same.
ಈಗ 6% 9% ಅಷ್ಟೇ ತಾನೇ ಇರೋದು.
My lord, the other judgments, my lord, are High Court of.
ಈಗ 6% ಇಂದ 3% ಗ್ಯಾಪ್ಗೆ ಎಷ್ಟಾಗುತ್ತೆ, ಎಷ್ಟು ಕೋಟಿ ಆಗುತ್ತೆ?
My lord, it runs to crores, I'm told, because otherwise, my lord, I would have. It makes a lot of difference, my lord, for the and this is by the Madras High Court, my lord, on the same point.
But division bench.
My lord, one more thing, my lord. My lord, the issue is, my lord, that all these facts, my lord, with regard to the financial aspects, my lord, with reference to the judgment of the apex court, my lord, in state of Andhra Pradesh, was not brought to the notice of the court, my lord. Probably I would have been in a better position, my lord, because I have shown the loss even to this day, my lord. I have given the balance sheet of 25, sworn to an affidavit, my lord. Even on 25, my lord, I am running under loss. Therefore, I'm not a profit-making organization, and I'm even to pay leave encashment benefits.
Statutory organization.
My lord, correct, my lord, but the rate of interest could not be, my lord, much more than what is prevailing in the bank rate, my lord. That's my submission.
ಬ್ಯಾಂಕ್ ರೇಟ್ ಎಷ್ಟಿದೆ ಈಗ?
My lord, but when the state government at the prevailing point of time, my lord, 5.58. Ade avrige kodbekagiro time alli
5.58%.
That's one aspect, my lord. And
6%.
Yes, my lord. And the second aspect, my lord, if your lordship division bench judgment.
But division bench 9%
I appeared,
SLP
my lord, in
dismissed.
fact,
also dismissed.
my lord, I in fact I appeared, my lord, and I tried to argue, my lord, the division bench was already made up its mind that by way of settlement we should pay 7% to put an end to it. Kindly see, my lord, the terms and settlement, my lord, of which I have.
Settlement. Settlement ಅಲ್ಲಿ 7% ಒಪ್ಕೊಂಡ್ರಾ?
Which, my lord, we have said that without prejudice to our contention, my lord. If your lordship could see.
Para 4.
Well, kindly see para 4, my lord. Learned Counsel for the NW would submit. Nane attend agiddidu. That the settlement is being entered in the light of the peculiar.
Treated to be a precedent in other matters.
In fact, my lord, I appeared through VC, my lord, in this case, and I submitted to the court that we would settle this case, my lord, because at that point of time, my lord, we, in fact, my lord, to make it more clear, my lord, I did not have any even an idea of, my lord, presenting this case in this way, my lord. As on the date we appeared before the division bench, my lord. Subsequently, when all these things were examined, my lord, we thought we'll place it before your lordship, my lord, and to apprise, my lord, the facts and to take a different view. My lord, I'm only praying, my lord, to take because these facts, my lord, were definitely was not brought placed before the division bench, my lord.
ನೀವೇನೋ ಹೇಳ್ಬಿಡ್ತೀರಾ, take a different view ಅಂತ.
ಇಲ್ಲ, ನಾನು only I'm.
But
I know, my lord, but the special.
But you must also be aware that northeast. You must also be aware that northeast is a beautiful place.
My lord,
different view. Adu different.
What happens, my lord? Northeast judgment also have produced.
Adalla madam. Different view ತಗೊಂಡ್ರೆ division bench Supreme Court ಗೆ. Northeast is a beautiful place.
My lord, in fact, my lord, your lordship judgment in Gramina Bank, my lord, I had this morning only I saw, wherein your lordship was pleased to order for 6% interest, my lord. Gramina Bank case, my lord. But
leave encashment at stay agide.
Encashment where?
Regulation 61 of the Gramina Bank.
The reported judgment, my lord. So therefore, in fact, your lordship has taken a view that it is 6%, my lord.
No, but division bench.
But the factors which could be taken into consideration, my lord, in the present cases, none of this, my lord, I don't think my learned friend would.
23 ಆದ್ಮೇಲೆ you are still under loss, huh?
Yes. My lord, kindly see, my lord, annexure for a minute, my lord. Annexure R1, my lord. The last column, 23, 24, my lord. Minus 295. It's increasing, my lord.
And loss increasing or profit increasing?
Loss. Minus, my lord. It's minus. Minus 295.43 is the loss, my lord.
Effect of freebie.
Probably, yes, my lord.
ಕೊಡಿ ನಿಮ್ಮ ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ. DS ನಕಾರ ಯಾಕೆ ಕೊಟ್ರಿ ಅದರಲ್ಲಿ?
My lord, 65 writ
Same
appeals.
ಇದೇನೆ.
ಅಲ್ಲ,
ಮೇಡಮ್ ಕೊಟ್ರಲ್ಲ ಈಗ ತಾನೆ.
My lord, in fact, ಅವ್ರೇನು
65 writ appeals were,
My lord,
my lord, settled. They are
65 writ appeals were settled this way, is it? 7%.
and my lord, kindly see annexure
7%.
R11, ನಾನೇನದು kindly see annexure R11.
Karnataka Council is appeal.
R11 ಅಲ್ಲಿ ನಾನೇ ಹಾಕಿದ್ದೀನಿ ಜಾಯಿಂಟ್ ಮೆಮೋಗಳು. My lord, yes, my lord, we had not, because once we lost in the Supreme Court, my lord, we were settling, and most of the matters were being settled at 6%. Even in Bangalore also, my lord, we are settling wherever they come forward for 6%, my lord, without prejudice to our contention. Though we say it is 5.48%, my lord, we have settled. But now these judgments are stating, my lord, that we have difficulty there, my lord. So I thought we'll
see.
request your
ಬೇರೆ
lordship
ಏನಿದೆಯಾ ಜಡ್ಮೆಂಟ್ಸ್? ಇಂಟ್ರೆಸ್ಟ್ ಆನ್ ಡಿಲೇಟ್ ಪೇಮೆಂಟ್ ಎಸ್ಕೆ ದುವಾ ಅವೆಲ್ಲ ಕೊಡಿ.
It was considered by the earlier bench.
ಎಲ್ಲ ಆಗಿದೆಯಲ್ಲ? ನಂದೇ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
My lord, none of the, my lord, I have placed it on affidavit, my lord. None of the documents showing, my lord, the financial aspect, it was only pleaded. Nothing was produced, my lord.
ಇದು 9% ನಾನೇನೋ ಬರ್ತಿದ್ದೀನಿ ಇಲ್ಲಿ. Following the division bench.
That was complied immediately. In lieu of default one.
ಅದೇ 12% ಅಂತ. 18 ಬರ್ತಿದ್ನಾ?
I don't know that.
ಪ್ರಶಾಂತ್ ನೋಡಿ.
I was there.
ಇದು ಅವಾಗ.
Yes.
Last thing here.
My lord, after this, we have settled cases for 6%, my lord.
ಅಲ್ಲ, let's we'll see.
And Justice MGS Kamal, my lord, I have passed an order for 6%.
Where is that order? Now, issue is not interest or no interest, 6% or 9%?
That's all, my lord. I'm not arguing, my lord, I'm not arguing, my lord. Your
You're not
lordship
for a moment saying you will not pay interest.
No, my lord, that's not my submission.
Whether it is 6% or 9%?
I was, my lord, on 5.48%, but I would argue that, my lord, in a different case, my lord, not in this.
We'll see.
Probably for gratuity case, my lord, because that would help for me.
Para 17 then.
6%.
6%.
In fact, my lord, following this, 65 cases, my lord, were disposed of. I appeared, my lord.
That's 7% ಅದು.
ಇಲ್ಲ, 6%.
ಯಾವುದು MGS Kamal ಅವರು?
6%.
6%.
But why delayed ಎಲ್ಲದರಲ್ಲೂ?
My lord, I read it to your lordship, the condition, my lord, when the government gave me money, my lord, to pay salary, it made it clear, my lord, that this money
It should not be used for leave encashment.
ಇವಾಗ ಏನು immediate ಏನಿದೆ ಅದನ್ನ ಮಾಡಿ salary ಇರೋದು, because the livelihood, my lord, it was in such a condition, it was a chain of event, my lord. Probably from COVID, we could have, my lord, done better, but after the strike, my lord, strike hit a lot, 480 crores, my lord, was the loss. In fact, not 4,280, we have filed a suit, my lord, making all the 4 unions as party, my lord, for recovery.
ಆಯ್ತು, ಮೇನ್ ಪೆಟಿಷನ್ ಯಾವ್ದು ಮಾಡಿದ್ರಿ ಈಗ
First
ಆರ್ಗ್ಯುಮೆಂಟ್?
case, my lord, we have filed objections in the first case.
ಯಾವುದು 106898 ಅದಾ?
Yes.
Yes. Heard, reserved. ಅದು ತಗೊಳ್ಳಿ. ಕಂಬಾಲ.
Film 34.
ಸಂದೀಪ್ ಪಾಟೀಲ್ ಇದಾರಾ? ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ. ಎಲ್ಲ ಪೆಟಿಷನರ್ಸ್ ಇದೆಯಾ?
It's appear for petitioner in 34.
Who is appearing from the car?
So I apologize, my lord.
I will not permit your event if you argue from the car.
No, my
Yes, I am not interested in seeing your car, sir. Yes, government.
The latest
ರೈತರ ಜಾನಪದ ಕ್ರೀಡೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದಾರೆ ಈಗ ಇವರು?
They have conduct, my lords. Now the, my lords, deputy commissioner has issued a, my lords. Latest development is that, my lords.
ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
Notice ಕೊಟ್ಟಿದೆ police.
ನೋಟಿಸ್? ಏನ್ ನೋಟಿಸ್?
My lords, to the, my lords, the parties, my lords, last occasion, yesterday, my lords, they served on.
ಕೊಡಿ.
They can conduct without any violence and without any race. And we have no objection for that. Even Deputy Commissioner has, my lords, recommended to seeking relaxation of the, my lords, circular. My lords, only their grievances, yesterday what they have submitted, grievances with respect of serial number 13.
Gangadhar.
Oh.
ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಪರ್ಮಿಷನ್ ಈಗ ಇದು ಬುಲಕ್ ಕಾರ್ಟ್ ಇರೋದು, ಬುಲಕ್ ಅಂಡ್ ಬುಲಕ್ ಕಾರ್ಟ್. ಅನಿಮಲ್ಸ್ ಯೂಸ್ ಮಾಡಬೇಡಿ ಅಂದ್ರೆ ಹೆಂಗೆ? ಈ ಕಡೆ ಕೊಡ್ತೀರಾ, ಈ ಕಡೆ ತಗೊಂತೀರಾ?
One second. No, I request this honorable court kindly take annexure B.
You will direct them not to indulge in violence to animals. If there's any loss, they will.
One factual submission. Annexure B. This is a notification which we have issued under the Animal Cruelties Act.
Absolutely.
They requested for permission to conduct the sports activity. We said you comply the condition under annexure B. That they have not complied.
Which condition?
No. The prior, now the strike is going on second pair. Before that, kindly take annexure B. ಅವರು ಎತ್ತಿನ ಓಟ ಮತ್ತೆ ಇದಕ್ಕೋಸ್ಕರ they have sought permission earlier. We said we'll give the permission, follow these are the guidelines.
ಅದೇ ತೊಂದರೆ ಇಲ್ಲ, they will follow everything.
No. They wanted to relax this condition. We said this is a statutory condition, we can't relax it. Now, against the non-relaxation of this condition, they wanted to go on strike.
Against non-relaxation strike?
They wanted to protest for non-relaxation of this condition. Our representation annexure D.
They will not protest.
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬೇಡನಲ್ಲ. ಮತ್ತೆ ಅವು ಎತ್ತು ಆಕಳ ಎಲ್ಲ ತಗೊಂಡು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಗೇಮ್ಗೆ ಕೇಳ್ತಾರೆ, ಪರ್ಮಿಷನ್ ಕೇಳ್ತಾರೆ. We said we'll comply it. We'll give the compliance, we'll give it.
ನಿಮಿಷ, ನೀವು ಕಂಬಾಲ, ಜಲ್ಲಿಕಟ್ಟು ಇದೆಲ್ಲ ವಿತೌಟ್ ಅನಿಮಲ್ಸ್
ಇಲ್ಲ ಈಗೆಲ್ಲ ಕೊಡ್ತಿದೀವಿ ಸ್ವಾಮಿ, ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾ ಇದೀವಿ. ಬಟ್ ಈ ಕಂಡೀಷನ್ ಫುಲ್ ಶಿವಮೊಗ್ಗದ ನಿನ್ನೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೊನ್ನೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ they should comply the condition under annexure B. They don't want to comply these conditions.
Which conditions?
ಈಗ annexure B ಅಲ್ಲಿ ಸ್ವಾಮಿ kindly see
ಕುಮಾರ್ ಕಂಡೀಷನ್ ಇದೆ. ಯಾವ
ಅಲ್ಲ ಅವ್ರು ಗೇಮ್ ಮಾಡ್ಬೇಕಪ್ಪ ಅಂದ್ರೆ ಇವೆಲ್ಲ ಕಂಡೀಷನ್ ಫುಲ್ ಸ್ಟ್ಯಾಟ್ಯೂಟರಿ ಕಂಡೀಷನ್ಸ್ ಮೇಲೆ ಅಡವಲ್ಲ. ಅವ್ರಿಗೆ ಈಗ ಗೇಮ್ ಬೇಡ, ಆ ಕಂಡೀಷನ್ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡೋಕ್ಕೋಸ್ಕರ ಸ್ಟ್ರೈಕ್ ಮಾಡ್ತಾರೆ.
ಒಂದ್ ನಿಮಿಷ.
Yes, I will submit. Lord, this circular was in force from 2022.
All right.
18 conditions are there. We said you have started implementing or compliance of these conditions from this year onwards. That is when we saw all these conditions, we were not aware. We have already given 2 or 3 representations to all the concerned that out of 18, 5 has to be modified or relaxed to certain extent.
Which are the 5? Which are the 5?
That kindly have a look at our representation, Lord. At page 26, annexure C. Condition number 3, 8, 13, 15 and 17. These we have already represented to the government as well as the in-charge minister and deputy commissioner as well.
So we will only follow the constitution and judgment of the apex court and permit.
And all
game they wanted to done strike for non-relaxation of this condition.
Non-relaxation of these. One nimsha, Sandeep Patil. If you want it for the game, I will permit you in terms of what the apex court has held. If you want it for something else, then yes, you will consider it. ಯಾವತ್ತು 7th ಇರೋದಿದು? ನಾಳೆನಾ?
ನಾಳೆ ಸ್ಟ್ರೈಕ್
ಸ್ಟ್ರೈಕ್ ಯಾಕೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Lord, all that we are saying is we have already waited almost for 2 months after giving representation. Nobody from...
1 minute, sir.
Please.
Sandeep, what do you want?
Lord, I just want tomorrow these...
Relaxation of conditions, huh?
This is
for what purpose?
This is what
purpose?
Lord,
for what purpose you want relaxation?
Lord, these conditions, according to me, for example, I'll just take a moment. Cruelty or prevention of cruelty or animals. There is one condition which says whoever treats animals cruelly.
Sandeep, I am asking a simple question.
Yes.
Why do you want relaxation of these conditions?
Lord, that's exactly what I'm answering, Lord. One of the condition
ನೀವು
is,
ಕ್ರೂಯಲ್ಟಿ ಅದೆಲ್ಲ ಬಿಡಿ ಸರ್, ಸ್ಟ್ರೈಟ್ ಆನ್ಸರ್. ಈ ಜಲ್ಲಿಕಟ್ಟುಗ ಕಂಬಾಳಾಗ ಏನಕ್ಕೆ ಬೇಕು?
ಅಲ್ಲ ಇದಕ್ಕೆ ಹೋರಿ ಹಬ್ಬ ಅಂತ, ಹೋರಿ ಹಬ್ಬಕ್ಕೆ
ಮಾಡಿ
there are two ways to look at
ಮಾಡಿ.
it.
In strict consonance with what the apex court or coordinate benches have held, we will permit you. ಅದಕ್ಕೆ ಅವ್ರು ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಸ್ಟ್ರೈಕ್ ಎಲ್ಲ ಬೇಕಾಗಿಲ್ಲ.
Tomorrow to draw
If
the
you want
attention.
if there is something else beyond this, then tell me.
No, there is nothing else, Lord. This is all we want. Lord, this is
ಹೋರಿ ಹಬ್ಬ ಪರ್ಫಾರ್ಮ್ ಮಾಡಕ್ಕೆ ನಿಮಗೆ ಬೇಕಲ್ವಾ?
Yes,
We
condition.
will permit it strictly in consonance with what constitution bench has held in Jallikattu's case.
Yes, Lord. Two parts we have asked for, Lord. Two parts. Kindly bear with me. One.
In 20 minutes, I will grant.
Yes, Lord. One, when one village is celebrating the festival, during the Deepavali and onwards, we celebrate this festival. Kindly relax. We should not be permitted, or we should not be forced to take any permission to celebrate the function or celebrate the festival. Lord, that is one part. The other part is when two or
Without
more
permission,
villages.
one minute. Sandeep, 1 minute. Without permission, you can't do anything that way. State is responsible for the law and order. You can't, without permission, you can't do. How you will do, we will pass an order.
Lord, to that extent, if your lordships, we just wanted to draw the attention of the government that this is what we are facing. So therefore, tomorrow at 11 o'clock, we had called for a protest. This is all we were requesting. And they have also said that tomorrow we will permit you to protest, but don't bring the cattle. That's their only condition. All that we are saying is, if at all I treat the animals cruelly even tomorrow, you can always book me under the law. But you cannot ask me not to bring the animals at all, not to bring the bulls, because protest is all about showcasing the bulls.
The bulls and cows, you keep it wherever they are. We will permit you to whatever habba they want to celebrate in accordance with what Supreme Court and division benches have held.
Lord, to that extent, I am ready, Lord, but these conditions.
Protest ಯಾಕೆ ಮಾಡಬೇಕು?
ಅಲ್ಲ, ಇವರು ಇಲ್ಲಿ ಅಲೋನೆ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ ಇಲ್ಲಿವರೆಗೂ.
ಈಗ ಏನು ಅಲೋ ಮಾಡಲ್ಲ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನೂ ತೊಂದರೆ ಇಲ್ಲ.
ಪ್ರೊಟೆಸ್ಟ್ ಏನ್ ಮಾಡಲ್ಲ, ಯಾಕೆ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಅದಕ್ಕೆ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. ಪ್ರೊಟೆಸ್ಟ್ಗೆ ಅವ್ರಿಗೆ ಹಬ್ಬ ಮಾಡಕ್ ಬೇಡ, ಹಬ್ಬ ಮಾಡೋದು ಬೇಡ ಅಂತ ಅವ್ರು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಕ್ಕೋಸ್ಕರ ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ರು.
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಲ್ಲ, ನೀವು ಹಬ್ಬ ಅವ್ರ ಮಾಡ್ತಾರೆ
ವಿತ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಪ್ರಕಾರ, ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ.
ಏನ್ ಪ್ರೊಟೆಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ ಅಲ್ವಾ?
ನಾಳೆಗೆಲ್ಲರೂ ಹೇಳಿದ್ದಾರೆ, ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ ಇನ್ ಕನ್ಸೋನೆನ್ಸ್ ವಿತ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್, ನಾಟ್ ಅಗೇನ್ ದೇ ಶುಡ್ ನಾಟ್ ಸೇ adhere to the circular. ಅಲ್ಲ, adhere to the circular ಅಂದ್ರೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
Yes, the petitioner is before this court and you shall not cause any hindrance except in terms of the directions of the apex court. Yes.
For conducting festival.
Yes, festival. The petitioner is before this court in political overtones ಇದೆ.
ಏನಿಲ್ಲ, ಒಂದು 4 ತಿಂಗಳ ಕೆಳಗಡೆ 4 ಜನ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಇಂತ ಹಬ್ಬ ಮಾಡಕ್ ಹೋಗಿ. We are not implemented 2012 guidelines. After death, there is a lot of pressures why you are not implementing this 2012 guidelines.
Apex court considers everything.
Please.
And passes an order.
Please.
In terms of the judgment, I will pass an order.
Yes.
The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus for permission to conduct a rally with bull and bullock carts. Yes. We heard the learned counsel Sandeep Patil appearing for the petitioner and the learned additional advocate general Gangadhar appearing for the state. The petitioners are Akhila Karnataka Raitara Janapada Kride Hori Habba Horata Samiti, hereinafter referred to as the Samiti for short. The Samiti wants to conduct Hori Habba. Elli ಮಾಡಬೇಕು ಅಂತ.
In the district of Haveri. In the district of Haveri.
In Haveri district. The state, when they sought permission to conduct the festival, is said to have projected a notification dated 18/12/2022 to contend that permission would be granted only in terms of the notification and the conditions fulfilled therein. The learned counsel for the petitioner submits that the said notification lied in cold storage till today and it is now sought to be implemented. The learned Additional Advocate General would refute the submission, contending that the notification is still in subsistence. When it can spring is when such requests come about. Be that as it may, the representation is for the festival Hori Habba, as could be gathered from the representation to the powers that be. The state, as observed, is wanting to project the notification which concerns bull race, bullock cart race, or any kind of festival that would be performed with the help of animals, or the festival is about the animals. Therefore, the notification indicates that if there is non-fulfillment of the 18 conditions, action would be taken in terms of the Cruelty and so and so Act. The issue whether permission should be granted to such festivals or not need not detain this court for long or delve deep into the matter. The apex court answering the festivals of Jallikattu and the Constitution Bench of the apex court. In 2023 9 SCC, page 322, the apex court permits with certain conditions. The conditions are as stipulated in 3 of the paragraphs of the judgment of the apex court, in para 35, 45 to 48. Following the said judgment of the apex court, the division bench of this court, a little earlier to the judgment of the apex court, the division bench in writ petition 10530 of 2021 has considered the issue of bullock cart races, permitting them on certain conditions. The division bench, and in a public interest petition, has held as follows, para 5 to 10. In the light of the judgment of the apex court and the judgment of the division bench as quoted supra, the permission that is to be granted to hold the race should be in strict consonance with what the apex court has held, not on the conditions that are stipulated in the notification. However, making it clear, as held by the apex court or the division bench, that one untoward incident in the said festival would undoubtedly incur the wrath of the Cruelty Act. What is that?
Prevention of Cruelty Act on animals.
Prevention of Cruelty Act.
Cruelty of
So,
prevention of cruelty to
very
animals.
good. Yes. In the light of the issue standing answered by the apex court and that of the division bench of this court, the permission that is to be granted strictly in consonance with the conditions stipulated by the apex court with regard to the safety and the participation or usage of animals, which would, however, should not come in the way, should not become contrary to the Prevention of Cruelty to Animals Act. With the aforesaid observations, the petition stands disposed with a direction to the state government to permit the Hori Habba to be held on the date that it is to be held, in consonance with the observations made herein above.
Grateful.
Ordered accordingly.
Annexure D is not for the Hori Habba, it is for the strike.
Annexure D. In the communication, the communication was sent by the petitioners to the state, to the respondent state, that they would protest as 2 months passed by on the representations for relaxation of the conditions of the notification dated 2/12/2022 had not been taken up. Now that the order is passed, the learned Counsel Sandeep Patil would submit that no protest would be required, and if the Hori Habba is permitted in accordance with law. The said submission is placed on record. In that light, the answering Annexure D is unnecessary.
Please.
Answering Annexure D, a request to hold the protest with the help of animals is unnecessary.
Please. Yes. Grateful.
Grateful.
The authorities of the area, Haveri, the authorities of the police or the district authorities of Haveri district shall oversee that no complications would happen during the festival.
Obliged.
Ordered.
Grateful.
The protest were
I'm glad,
yes.
my lord. I'm glad we ended before your lordships.
Okay, over, yes.
Obliged.
Bill number 12, Praveen Tarikar.
ಗಂಗಾಧರ್ ಅದಷ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಏನ್ ತೊಂದರೆ ಕೊಡಕ್ ಹೋಗ್ಬೇಡಿ.
For petition, my lord, my apologies, my lord. Annexure C is not produced in entity, my lord. Only 2 pages of
Serial number?
annexure. 12.
Annexure C, yeah.
Annexure C is compromise petition, my lord. It
Not produced.
Not produced in entity. Only 2 pages are produced, my lord.
ಮಾಡಿ. Without pad, you have come to play cricket?
Sorry.
Yes.
I seek on Tuesday, my lord.
Tuesday, fresh match.
Yes, obliged.
13, Kavya Eligi.
For the petitioner, your lordship, we are challenging endorsement, your lordship, issued by the
Endorsement.
respondent. Endorsement, your lordship. Challenged by the, issued by the respondent.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Your lordship, we are,
HCGP is directed to accept notice for the respondent.
Only
respondent,
ಅದೇ ಒಂದು
only
respondent.
respondent.
To the respondent, list on 12th fresh matters list. Next. Copy ಇದೆಯಾ madam? Copy ಇದೆಯಾ?
Dish Patil.
My lords, serial number 14, my lord, I'm appearing for the petitioner. My lord, in this matter, my lord, we have filed an application for the stay. My lord, that application is not put up. Could I request my lords to kindly have it on Monday, my lord? Along with the application.
Registry is directed to put up the application seeking application for stay said to have been filed by the petitioner. ಏನ್ ಗಿರೀಶ್?
Monday, my lords.
Tuesday, fresh matters, yes.
Please, my lord, please.
Anand Kumar Emagdum. Shiv Sai M. Patil.
This case,
Yen
my
madam
petition
idu?
is sought for mandamus, my lords,
For
for consideration, my lord, wherein petitioner
For
is
respond number
claiming,
2, my lord.
petitioner is claiming that
ಹೇಳಿ ಮುಗಿಸ್ಲಿಕ್ಕೆ.
seeking for interest on delayed payment as well as 10% has been deducted in the compensation amount, my lord, which is at
ಸುಮಾರು
annexure.
ಮ್ಯಾಟರ್ಗಳು ಇದಾವಲ್ಲ, ಇದೊಂದೇನಾ ತುಂಬಾ ಇದೆ ಕೇಸಸ್?
ಇದ್ರಲ್ಲಿ ಬಂದಿದೆ.
ಒಂದೇನಾ? Yes.
Appearing for respond number 2. I seek 1 week's time, my lord.
List the the land council. Notice ಆಗಿದೆಯಾ?
Notice ಆಗಿದೆ.
List at the request of your Rakesh Bilki.
Rakesh Bilki.
At the request of Rakesh Bilki, list the matter on 12th.
Yes.
Fresh matters list.
16, Santosh Kumar B.
Please, here for petition. Compromise entered before the Lok Adalat is challenged before this court. My lord, it is annexure B, page 11.
Compromise is 14/8/2021, sir.
Without suit for partition, without making all sharers as parties. Page 29 is the legal.
Petitioner shall serve on the respondents by way of hand summons and file an acknowledgement of such service, apart from taking out steps to serve them by first emergent notice. Emergent notice, apart from taking out steps to serve them, petitioner is able to serve by way of hand summons. List the matter on 18th.
Compromise mistake. Revenue interest change ಮಾಡ್ತಾರೆ. 14/8/21.
Yeah, sir. Yes.
ಅಲ್ಲ compromise.
Suraj Matpal.
4 ವರ್ಷ ಆಗಿದೆ ಸರ್.
ಅದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅದನ್ನು.
ಎಲ್ಲರೂ ಹಿಂಗೆ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ? You are not parties at all.
I were not parties to the process.
Yes.
Legal is without making us as parties. Revenue interest change ಮಾಡ್ತಾರೆ. That is the difficulty.
Status quo quo, the properties which are the subject matter of compromise, we maintain till the next date of hearing.
Please. Obliged.
17,
My lords, writ of mandamus, my lords, seeking to register the FIR, lordship.
Take this.
ಯಾಕೆ ಕೋರ್ಟ್ ಬರ್ಬೇಕು?
First time notice, sir.
ಏನು ಅಸಾಲ್ಟಾ?
Yes, my lords, assault between the 2 family members, my lords, over
Family
the
members, sir.
2 family members, my lords.
Who assaulted you?
My lords, that another family, my lords, over the organization of the village fair, my lords. They have registered the complaint, my lord, it has been
ಅವ್ರು
registered.
ಮಾಡಿದಾರಾ?
ಆಗಿದೆ, ಅವ್ರದ್ದು register ಆಗಿದೆ.
ಕೌಂಟರ್ ಕೇಸ್ ಮಾಡ್ತಾ ಇಲ್ವಾ?
My lords,
ಕೌಂಟರ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾ
ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇದು ಮಂಡೇ ಟೇಕ್
Tuesday.
ಕೌಂಟರ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
Tuesday.
ಯಾಕೆ ಅವ್ರದ್ದು ಮಾತ್ರ ಕ್ರೈಮ್?
I'll take this.
Yes. Tuesday, fresh matters.
Already heard on 3rd, my lords.
The learned AGA, as a last chance list on 3rd, the learned AGA to secure instructions as to why a crime is registered against these petitioners on the complaint being registered by the respondent, by the different accused, while the counter case is refused to be registered. Appropriate orders will be passed if no instructions come about on the said date. Yes.
Grateful.
18, Girish S. Sirema. Prashant Osman.
Petitioner is challenging this transfer order, my lords. He was reinstated on 5/7/2020.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
My lords, he was dismissed from service. Then, my lords, he filed KID. KID was also dismissed. Filed a writ petition. The writ petition, my lords, is Justice Sanjay Gowda's. He was a trainee, so he was equated to, my lords, by virtue of the Honorable Justice Sanjay Gowda's order. Trainee was equated to an employee, and my lords, he was directed to be reinstated. Reinstatement, we have transferred him to Sirsi, Ankola.
Sirsi? You want Sirsi? Sirsiನೇ ಬೇಕಾ?
Sirsi division, Ankola. Now transfer ಮಾಡಿದ್ವಿ, ಅಲ್ಲಿ transfer ಮಾಡಿದ್ವಿ ನಾವು, my lords.
Now he is in Hubli division, my lords.
ಎಲ್ಲಿಗೆ ಬೇಕು ನಿಮ್ಗೆ?
Hubli, only 3 months, my lords, there. It's very difficult, practical problem.
3 months?
On 5/7/2025, my lords, he was reinstated, my lords. After that, on 5/7.
Reinstatement order ತಗೊಂಡ್ರಿ ಅಂತ ಕೋಪಕ್ಕೆ ತೆಗೆದ.
5/7
What has happened, my lords? We had asked him to report to his original. He was dismissed in 2004. ಅದು ಎಲ್ಲ ಇದು litigation ಆಗಿ ಇಲ್ಲಿ ತನಕ ಬಂತು. Then, my lords, he was asked to come and submit his documents. That is not reinstatement in strict sense. Then, looking at the availability,
The petitioner is before this court calling in question an order dated 25/9/2025, which transfers the petitioner from, which reinstates the petitioner to the transferred place hyphen ಎಲ್ಲಿ ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ದೀರಾ ಪ್ರಶಾಂತ್? ಅಂಕೋಲಾ. ಸಿರ್ಸಿ ಡಿವಿಷನ್ ಅಂಕೋಲಾನಾ?
Please, Sirsi division.
Sirsi division Ankola. The petitioner, Herdsmans, the petitioner is appointed 2004 appointee na?
Please.
2013 ಅಂತಿದೆ.
2007, my lords.
2007, my lords.
2007.
Petitioner is appointed as a trainee driver cum conductor in the year 2007, and owing to certain omissions and commissions, he is dismissed from service.
2014.
In 2014, correct, in 2014. This is called in question before the industrial tribunal. The industrial tribunal dismisses it. The dismissal was challenged before this court. The coordinate bench of this court by the following order. Oh, ellardu seri alla. By the following order directs, sets aside the removal and orders reinstatement. Order by the following order, page 147. The petitioner then reports to duties for, in terms of the order passed by the coordinate bench. An endorsement is issued on 5/7/2025 asking the petitioner to submit documents and report to duties at Ankola Sirsi subdivision. The petitioner, being aggrieved by the said order, is before the court saying that he wants Hubli. Why?
No, my lords. He was appointed in Hubli, my lords.
Oh, he was appointed in Hubli. Therefore, he should be posted back to Hubli on reinstatement. The submission of the petitioner on the face of it is unacceptable. He is reinstated into service. That would not mean that he would choose the place of work. He is now asked to work at Ankola. Work at Ankola subdivision, Sirsi subdivision. There is no prejudice caused to the petitioner on account of the direction to work at Sirsi subdivision Ankola. It cannot be, as observed here in above, the employee cannot choose that he would want to work at a particular place unless the transfer is in violation of the operative guidelines or any statute governing the issue. Finding no merit in the petition stands rejected. Next.
19, Anand Arpalli.
Second round of litigations, my lords. Here, my lords, I made a representations.
Learned HCGP is directed to accept notice for the respondent 1 to 3. 1 to 3. DUDC name, madam. District Urban Development, sir. 1 to 4, 5 emergent notice returnable by 18th fresh matters.
Only sought against directions against the respond number 2.
ಈಗಲೇ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ, ಅವ್ರು ನೋಡೋದು ಬೇಡವಾ?
Number 20.
Ma'am, on earlier round of litigations, my lords, Vidyavati madam is appearing.
Yalli sir.
Chief officer.
Yaudralli?
In the earlier round of writ petitions, my lords, serial number 19, my lords. Standing counsel is appearing.
5th respondent.
Yes, my lords.
Oh, sir. Learned Counsel, Vidyavati M. Kottur Shetty
Yes.
ಅವರಾ?
No, Vidyavati Iyer, my lords.
So and so
V Vidyavati.
appearing,
K Raghavendra Rao.
accepts notice for R5, ಆಮೇಲೆ
ಅಷ್ಟೇ.
18th,
Please. The fresh list.
fresh, yes.
20.
ಎಲ್ಲ classification ತೆಗೆದ್ಬಿಡಿ, ಬರೀ fresh.
It's a DLT matter.
ಅದು 2010 final hearing ಇದ್ರೂನು fresh. Yes, because ಇಲ್ಲೆಲ್ಲ ಟೈಟಲ್ ಮೇಲೆ ಹೋಗ್ತಾರಲ್ಲ.
My lord, it's a DLT matter. Your lordship directed to us to
Yes.
serve the copy of to the standing council. But the standing council is residing at Bangalore. Yesterday has sent
ಮೇಲ್
through the
ಕಳಿಸಿದ್ದೀರಾ? ಸೋಮವಾರ ತಗೊಂತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
urgency ಅಂದ್ರೆ ಪೊಸಿಷನ್ ತಗೋಬಹುದು ಅಂತ.
ಎಷ್ಟಿದೆ?
33 ಲಕ್ಷ ಇದೆ. ಪಿಟಿಷನರ್ ಹಿಯರಿನ ಗ್ಯಾರಂಟರ್ ಮೈ ಲಾರ್ಡ್.
ಎಲ್ಲ ಒಂದೇನೆ.
ಡೆಪಾಸಿಟ್ ಏನು ಸ್ವಲ್ಪ.
The petitioner is before this court calling in question the order of the learned magistrate under section 14 of the Surface Act 2002. The petitioner is said to be the guarantor. Though the petition would not be entertainable and the petitioner has to be driven to the debt recovery tribunal, the learned counsel of the petitioner submits that substantial payment would be made and the house property should be protected. In the light of the said submission, ಎಷ್ಟು 10 ಲಕ್ಷ?
5 ಲಕ್ಷ.
In the light of said submission, the respondent shall not take any precipitative action qua the order of possession, qua the property of the petitioner in terms of the order of the learned magistrate, subject to the condition that the petitioner would pay 5 lakhs on or before the 18th of December 2025. In the event the petitioner would not pay the said amount, not only the interim order would be vacated, but the petition also would run the risk of getting dismissed.
Time 8 weeks. 8 weeks.
Huh?
Time 8 weeks deposit.
8 weeks ಯಾಕೆ? ದುಡ್ಡು ಕೊಟ್ಟಕ್ಕ?
ದುಡ್ಡು ಕಟ್ಲಿಕ್ಕೆ.
DRT ಹೋಗ್ಬಿಡಿ. Yes, 18th December in the fresh matters list. Yes, please.
21. Sadiq Goodwala.
Petitioner.
ಏನು?
Rowdy sheet.
A grade, B grade, C grade?
One case is pending.
Under C grade. Yes. The petitioner is before this court seeking the following prayer. Representation ಕೊಟ್ಟಿದ್ದೀರಾ?
Representation, they have issued endorsement saying that if the court asks, will furnish ink page 10.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ರೀಸನ್, ಕಾರಣ ಬೇಕಾ?
Information. ಎಷ್ಟು ಕೇಸ್ ಇದೆ ಅಂತ ಕೇಳಿದ್ವಿ.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
ಇಲ್ಲ, ಒಂದೇ ಕೇಸ್ ಇದೆ. ಅವ್ರು they say that there are many cases. Lordship may direct me to give my lord.
Representation ಕೊಡಿ first. The petitioner is before this court seeking the following prayer. The learned heard sounds. The petitioner is said to have got himself embroiled in a crime which is pending consideration before the concerned court. Offense
147, 107.
Offense is punishable under 147, 107.
283, 290, 291.
ಅದೆಲ್ಲ ಕಾಮನ್ ಬಿಡಿ. Yes. So he is now before the court taking deletion of his name from the list of rowdies maintained at the 4th respondent police station. The learned counsel for the petitioner submits that he doesn't even know why his name is being drawn in the list of rowdies. As the indication is, there are many cases pending, but there is only one case pending which is within the knowledge of the petitioner. In that light, the petitioner is at liberty to submit a representation to the respondent. Third respondent,
third respondent.
To the third respondent, who shall consider the representation in strict consonance with the law laid down by the coordinate bench of this court in B.S. Prakash for the state of Karnataka, 4504 of 2022, disposed on 22nd April 2023. Adon Charitable haki. So the action shall be taken within 8 weeks, 12 weeks from the date of receipt of the copy of the order. The petitioner shall submit a representation within 6 weeks from the date of receipt of the copy of the order. In the event such a representation would come about, the third respondent shall consider the same and pass necessary orders in accordance with law within 8 weeks thereafter, ordered accordingly. Yes.
Please.
22.
Next.
Shivraj Paduri.
Petitioners, my lords, are the president and vice president respectively, my lords, of the Savarda Society. My lords, consumer complaint is filed, my lords, against the society. Liability is saddled on the petitioners, my lords.
Emergent notice to the respondent.
Respondent.
On the respondent, petitioner to serve, is at liberty to serve the respondent by way of hand summons. List on 9th January, there shall be an interim order of stay spread for till the next day. Next.
But serial number 30 is also identical. Both can be connected, my lords.
Tag along with 30 same order.
Please, please.
23, MR Hireman.
Seek instructions, my lords. Yet to seek instructions.
No instruction.
No instructions.
Monday fresh, Tuesday fresh matters.
Please.
Yes, next. At the
24.
request of learned AG.
Is it 23, my lord? My lord, in this case, I wanted to file a pleading. Your lordship just recollect, the similar matter was posted last week. In that, my lord, I have stated that, my lord, now in pursuance of the expiry of the committee, new committee has been given up and which has been approved. Taking note of that, your lordship has directed them either you amend or file a fresh writ petition.
Oh, da.
Yes, now without making us as a party, now they have filed.
Ida,
Yes, 23.
implementing application ellida.
Lord, I am
List the
filing.
matter on registry lakpade. List the matter.
Please.
No representation by of the petitioner. List the matter on Tuesday in fresh matters list. Application put up ಮಾಡ್ತಾರೆ.
Please.
ಅವರು ಇಲ್ಲದೆ ಅಲೋ ಮಾಡುತ್ತೆ. Yes.
24, Abhinandan V. Hireman.
Lordship, this is the matter where
Where?
elections have been held and results have not yet been declared. Kumta Fisheries Cooperative Societies matter, my lord.
Results ಯಾಕೆ ಡಿಕ್ಲೇರ್ ಮಾಡಿಲ್ಲ?
Since the
ಏನಿಲ್ಲ.
two petitions were pending, my lords,
Yes, sir.
among them one.
ಸ್ಟೇ ಏನಿಲ್ವಲ್ಲ?
Proxy consent, my lords.
ರಿಸಲ್ಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಲಿ. ಎಲೆಕ್ಷನ್
not
ಆಗೋಗಿದೆ. Justice Shyam Prasad or order.
Please, my
Please.
lords. Since in
Same
one
order.
petition stay was there, hence it was not declared. Now
Justice
that
Shyam
petition
Prasad.
is disposed.
Next.
Please.
25, Praveen Terikar.
Writ of mandamus, my lord, directly respond 2 to 4, my lord, to consider my representation, my lord. As to my date of birth is shown as 1/6/1996, my lord, to show it in accordance with the birth certificate, my lord.
ಎಲ್ಲಿ who has to show it?
2 to 4, my lord.
Who are they? Contract basis clerk.
Please, permanent, my lord. Earlier I was contract, my lord, later I became regularized, my lord.
ಯಾವಾಗ ಸರ್ವಿಸ್ ಸೇರಿದ್ ಯಾವಾಗ?
My lord, another 7 months are remaining of my service, my lord.
Emergent notice to the respondent.
1 to government, my lord, 3 Santosh Mane.
1 and 2 government. 2.
Government. 1 and 2 government, 3 Santosh Mane, my lord, and 4 is Sanjay Chinnan.
ಬರ್ಕೊಂಡ್ರಾ? Yes. So and
Please.
so accepts notice. HCG copy ಕೊಡಿ.
Please, code.
Copies to be served on all the councils. Yes, next.
Please.
Madam guest.
26, VN Mulimani.
VC ಇಂದ ಆಚೆ ಯಾವಾಗ ಬರ್ತೀರಾ ಅಂತ ಗೊತ್ತಾಯ್ತು.
I seek my excuse for not having ability to hear so I sit in the.
Oh, sorry.
I didn't that's why I am not coming. In the open court I cannot.
Yes.
And in case of any inconvenience, I regret.
ಆಯ್ತು ಏನ್ ಚಿಂತೆ ಇಲ್ಲ ಹೇಳಿ. I did not know that.
No.
ಇವರು ಹೇಳಿಲ್ಲ ಅದನ್ನ.
ಕೇಳೋದು ತಪ್ಪಾಗತ್ತೆ.
ಹೇಳೋದು ತಪ್ಪಾಗುತ್ತೆ. ಆಯ್ತು ಈಗ ಏನ್ ಕೇಸ್ ಏನು?
In identical matter, my lord. Already.
ಟರ್ಮಿನೇಟ್ ಆಗಿದ್ದೀರಾ ನೀವು?
No, he's still in service, my lord.
Still in service ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗಿ.
Your Lordship, recruitment examinations are concluded and counseling is.
Till you recruit them, madam, ಅಷ್ಟೇ.
Counseling ಆಗಿದೆ. Counseling ಆಗಿ ಫೈನಲ್ ಆಗಿಬಿಟ್ಟಿದೆ.
ಆಯ್ತು ಅದು ಅವ್ರು ಬಂದು ಜಾಯಿನ್ ಆಗೋವರೆಗೂ ಇವ್ರು ಇರ್ತಾರೆ ಅಷ್ಟೇ.
ಅವ್ರು ಜಾಯಿನ್ ಕೌನ್ಸಿಲಿಂಗ್ ಮುಗಿದಿದೆ, ಜಾಯಿನ್ ಆಗಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ. ಇವರಲ್ಲ, ಇವರು they were not at all in the eligible list.
The petitioners are guest lecturers. They are seeking their continuance in the respondent. Learned HCGP submits that the recruitment process is over and the new lecturers have already come and taken charge. In the event the new lecturers have not yet assumed charge and the petitioners are continuing, they shall continue till the new lecturers will assume charge.
For the academic year.
For the academic year 25-26. In the event the new lecturer, in the event the recruitment is not taken to its logical conclusion, the petitioner's services for the academic year 25-26 shall not be disturbed till the new appointees would assume charge.
ಇನ್ನೊಂದು Your Lordship, the present
My lordship.
Respondent number.
In the previous circumstance,
13
this court allowed the MPhil qualification as valid, and in spite of that, my qualification.
Whatever the.
List the matter on 19th.
Please.
Yes, please. 18th ಅಥವಾ 19th ಯಾವ್ದು ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ?
19th.
19th.
27,
Both same. Both are same.
Same.
28, Shiv Sai M. Patil.
Daughter has filed for maintenance against.
Daughter has filed.
Against father, madam. She is working as a software engineer.
ಯಾರ ಡಾಟರ್ ಅದು ಮೇಂಟೆನೆನ್ಸ್ ಬೇಕಂತ.
We could not get an authentic document, but in the Facebook it shows he is working in Accenture company.
Facebook. Yes, emergent notice to the respondent. There shall be an interim order of stay spread for till the next date. Yes, next.
29, Shivraj Balloli.
Tuning annexure A.
Maintenance.
No, my lords. Discrimination, my lords, of the petitioner and like by the government. My lords, annexure.
FC antida?
FC.
Allala, sorry, 29.
Sorry, my lords. My lords, petitioner, my lords, is my lords professor with the university.
Which university?
My lords, horticultural university. Now, my lords, the government
What
has
is discriminatory?
my lords, the government has issued, my lords, a circular granting benefit, my lords, to its employees whose recruitment process started, my lords, prior to 1/4/2006, but were, my lords, due to some litigation appointed after 1/4/2006, extending, my lords, the benefit of old pension scheme. My lords,
NPS,
OPS. Now, my lords, these benefit. My lords, I've been appointed on one in the year 2008, but the appointment process started in the year 1998.
Final select list ಯಾವತ್ತು?
2008, my lords.
Appointment process start ಆಗಿರ್ಬೋದು. Final select. When do you get a right?
No, but my lords, their own circular says.
When do you get a right?
My lords, I get a right, my lords.
On the select list?
But my lords,
Semblance of
selected 1998, my lords, but it was confirmed, my lords, in the year 1998.
ಅದನ್ನ ಕೇಳ್ತೀರಾ?
Sorry, my lords.
Arts sir. So litigation ಇತ್ತು ಅಂತ
2000 appointment order is issued in the year 2008. Selection, my lords.
Invited in the year.
No, my lords, university recruitment, my lords.
Notification in the year 98. Notification 98.
Selection also 1998, but appointment order was passed in the year 2008.
Because of litigation.
Because of the litigation. And, my lords, their own circular says that, my lords, in such cases, my lords, OPS is to be granted. But now annexure A is issued, saying that, my lords, the benefit extended is only for government employees and would not come, my lords, to employees, my lords, under university.
As simple as that. Sir,
And-
ಮಾಡಿ, we'll close
Please,
it
my
next time.
Please, 1 and 2, my lords, government, AGA.
1 and 2 AG.
AGA, 3, my lords, DGS, Venkatesh Karvi.
3 Venkatesh.
Venkatesh Karvi.
4, 5.
4, my lords, Ramchandra Mali.
4, 5.
5 and 6, my lords, Mr. Ravi Balikai, my lords.
ಎಲ್ಲ ಬರ್ಕೊಂಡ್ರ? Your petitioner. Yes. The petitioner is before this court on a demand for bringing him under the OPS, the old pension scheme. While the impugned endorsement rejects the claim on this score that it is only for the government employees. The selection to the post the petitioner is holding began in the year 1998. The select list was of the year 1998. For litigations pending for 10 years, the appointment orders could not come about. Finally, the petitioner and the like succeeded in getting the appointment in the year 2008. In all this process, there is no fault of these petitioners. It was due to litigation. The apex court in plethora of cases has considered the fact that the petitioners should not be petitioners like the petitioner in the case at hand should not be put to disadvantage due to the litigation pending and finally get appointment. Therefore, the prima facie, the petitioner's claim for OPS is to be considered, subject to, however, the state bringing out something else. List the matter on the 15th in the fresh matters list.
Please. Oblige.
31, AC Chaklabi.
In this case, the endorsement issued by the respondent number 1 has been challenged also, wherein we have sought for the fixing the amount for government rate also.
The learned AGA is directed to accept notice for the respondents, all respondents.
Please.
19th, yes.
32, Tushar NK.
And for the petitioner. Annexure A is under challenge. The order of recovery has been passed against the petitioner. Earlier also, my lordship, the same order was passed. I approached this honorable tribunal and your lordships have remanded back. Nimde order.
ಏನ್ ಮಾಡಿದ್ರಿ ಈಗ?
Once again, they have passed the impugned order as annexure A. my lordship. Without considering the reply, my lordship, submitted by the application, they have just made a cursory note that the petitioner has.
Leonard, ಮುಂಚೆ ಯಾರಪ್ಪ ಕಾಮಟೆ ಅವರ?
BS Kamte.
Leonard
Respondent number 1.
BS Kamte is directed to accept notice. ಶಿವರಾಜ್ ಮುದೋಳ್ ಇದ್ರ ಮುಂಚೆ
ಇಲ್ಲ, ಈಗ KPTCL BS Kamte.
ಸೊ ಮುಂಚೆ ಯಾರು ನೋಟಿಸ್ ಆಗಿರ್ತದೆ ಪೇಜ್ 60-61 ಅಲ್ಲಿ. The petitioner was before this court calling in question the order of the departmental inquiry. The report had exonerated the petitioner. However, the recovery is now directed without considering the reply as was directed. In that light, there shall be an interim order of stay as prayed for.
I'm not seeking any stay, my lord. Already I have suffered the order.
Suffered? Oh, long back suffered. Yes. List the matter on 18th, 12th in the fresh matters list. Sir, ಮಾಡಿ ಇವತ್ತು. Yes.
2 to 6 ಚಂದ್ರಶೇಖರ್ ಹಿರೇಮಠ್, my lord.
ಅನೂಪ್ ದೇಶಪಾಂಡೆ ಅಂತಿತ್ತು.
Please.
ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಕೊಡಿ ಪೇಜ್. ನೆಕ್ಸ್ಟ್.
Bill number 33, Joshna P.
Petitioner, my lords. Respondent has published the advertisement for retail of outlet dealership, my lords. In pursuant of said advertisement, petitioner has applied, my lords, and petitioner was qualified for the retail outlet dealership, my lords. And annexure G was challenged, my lords. That is page number 24, my lords.
Now what is the problem?
No, my lords, that is a candidature stands cancelled, my lords. Petitioner was cancelled, my lords, because, my lords, petitioner has not timely uploaded the all the documents, my lords. That is page number 24, my lords, annexure G, my lords.
SV Angadi na CV Angadi, madam?
CV Angadi, my lords.
Senate Council CV Angadi is directed to accept notice for the respondent. List 12th fresh matters.
Obliged.
Yes, next.
35.
Petitioner to serve set of papers immediately. Yes, next.
Chur Sudhakar.
35.
KSRTC employment.
ಏನಿದು?
Dismissal of a KSRTC employment.
ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು? Labor court.
I was informed later.
The petitioner calls in question an order of dismissal of a workman of the corporation which ought to have been preferred before the concerned tribunal. Reserving such liberty, the petition stands disposed. Yes, next.
36, Vidyavati Mukhopadhyay.
Please. I prefer petitioner. Yesterday matters, my lord.
Yesterday
Seeking a
matter.
mandamus to pass and consent award as per the government order.
Same order.
Annexure D, my lord.
Same
It is
order.
Anil Kaled ಇದೆಲ್ಲ ಅದೇ ತರ. Yesterday.
ಅನಿಲ್ ಕಾಳೆ ಅವ್ರದ್ದು
106191 of 2020.
06191 same disposal.
Seeking a mandam and appearance date may be kindly be there. Before the concerned is
appearance
ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ.
ಅಲ್ಲೂ ಹಾಕ್ಬೇಕಾದ್ರೆ.
Please, my lord.
Appearance date, madam.
If amount is not taken.
ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿರುತ್ತೆ. Appearance date only if amount
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡೇ ಇಲ್ಲ ಇದರಲ್ಲಿ.
Appearance date will be 22nd December.
ದೂರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೈ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ
ಎಲ್ಲ ರೆಡಿ ಇದೆಯಾ?
ಎಲ್ಲ ರೆಡಿ ಇದೆ, ಎವ್ರಿಥಿಂಗ್ ಇಸ್
ಎಲ್ಲ ತಿಳ್ಕೊಂಡು
ಇವ್ರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟ ಮೇಲೆ ಅವ್ರು ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡೋದು.
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಅಲ್ವಾ?
ಪ್ಲೀಸ್
15 December.
ಪ್ಲೀಸ್ ಅಫಿಡೇವಿಟ್ ದೇ ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಅನ್ ಅಫಿಡೇವಿಟ್.
ಅದು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ, ಅದನ್ನು
ಪ್ಲೀಸ್
ಮಾಡಿಫೈ ಮಾಡಿ ಡೇಟ್ ಹಾಕ್ಬೇಕಾದ್ರಲ್ಲ 22nd. 15 December. ಸಾರಿ
ಪ್ಲೀಸ್.
37,
22 ಆದ್ರೆ it will be convenient, your lordship.
ನಂಬರ್ 5 my lord ಮುನೋಳ್ಳಿ
ಶಿವರಾಜ್ ಮುದೋಳ.
ಚೇತನ್ ಮುನೋಳ್ಳಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದರ್ my lord government advocate has to take notice.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? ಅದೇ ಸೇಮ್
ಈಗ ಫಸ್ಟ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದು ನೋಟಿಸ್.
ಅದರಲ್ಲೂ ನೋಟಿಸ್ ಕೊಡ್ತೀವಲ್ಲ ಹಂಗೆ.
ಇಲ್ಲ ಅದು ಓಲ್ಡ್
ಆಲ್ರೈಟ್. 1 to 4 HCGP, 5 ಚೇತನ್ ಮುನೋಳ್ಳಿ.
ಅಲ್ಲ 1 to 4 and 6, 7.
1 to 4, 6 and 7
government. 5 is Chetan.
5 Chetan.
Please.
Yes, disposed.
37, HM Jarigo.
The petition, please challenge the final gradation list, the annexure N, without considering the objection filed by the petitioner.
Staff nurse.
Please.
Staff nurse.
Please.
1, 2,
1 to 4, my lord.
4 HCGP, 5 KIMS, the Arvind Kulkarni.
Arvind Kulkarni, 5 and
Arvind
6.
Kulkarni, 5 and 6.
For entry, my lord.
Final gradation list, no? The
Like,
final
I-
gradation, select list,
The gradation list.
Final gradation list shall remain subject to the result of the petition. Yes.
38, Girish Yadav.
In the identical matter, ಮಲ್ಲ similar ಮಾಡಿ ಕೊಪ್ಪಳ ಮೆಡಿಕಲ್ ಮಲಾಡ್ದಿ ಅಲ್ಲ ಕೊಪ್ಪಳದೊಂದು ಹಾಕಿದೆ ಅದರಲ್ಲಿ ನಾಟ್ ಟು ಪ್ರಿಸಿಪೇಟ್ ಮಲಾಡ್ದಿ ಬೇಸ್ಡ್ ಆನ್ ಮಲ ಗ್ರೇಡಿಯೇಷನ್ ಲಿಸ್ಟ್ ಅಂತ ಆಗಿದೆ.
ತಪ್ಪದು. ಫೈನಲ್ ಗ್ರೇಡೇಷನ್ ಲಿಸ್ಟ್
ಅಲ್ಲ ಈಗ ಪ್ರಮೋಷನ್ ಕೊಟ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ ಅದು.
ಸಬ್ಜೆಕ್ಟ್ ರಿಸಲ್ಟ್ ಎಲ್ಲ
ಪ್ಲೀಸ್
ಅದ್ಯಾವ್ದು ಕೊಪ್ಪಳ ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಕೊಡಿ.
ಆಮೇಲೆ the issue is different ಮಲಾಡ್ದಿ.
ಮತ್ತೆ ಬಿಡಿ. ಎಸ್.
38,
Challenging the compromise decree, my lords.
Compromise decree ಇಷ್ಟೊಂದು. Suit for
Suit for partition and separate possession, my lords. There is already a suit decreed in favor of me, my lords, for
compromise
specific performance.
13,925.
Please, ma'am.
You are not made parties?
No, no, my lords. There is already a decree in favor of me for
2, 3.
specific
A
performance.
petitioner shall serve on the respondents by way of hand summons and file an acknowledgement of such service by the 15th of December. List the matter on 18th in the fresh matters list. Further proceedings pursuant to the compromise shall remain state till the next date. Yes,
Nice, ma'am.
next.
39, Vidyavati.
This
ಇದು
is
ಅದೇನಾ?
also same matter, but consent award, quashing of consent award.
ಮೇಲೆ ನೆನ್ನೆ ಮಾಡಿದ್ದೇವಲ್ಲ ಅದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿಲ್ಲ. Will not come in the way.
Yes, my lord.
ನಂಬರ್ ಕೊಡಿ.
101,288 of 2024.
01,288 of
2024.
ಆಗಿದೆ ರವಿ.
Please, my appearance, my lord, 15th.
ಎಲ್ಲರೂ 15th
Please,
ಹೋಗ್ಬಿಡಿ ಒಟ್ಟಿಗೆ.
Government advocate to take
ತಗೊಂಡ್ಬಂದ್ಬಿಡಿ.
Please, take notice.
ಯಾರ್ಯಾರಿಗೆ ಹೇಳಿ?
One, same. 5 is Chetan Munolli.
5 ಒಂದು ಚೇತನ್ ಮಾಡಿ ಮಿಕ್ಕಿದೆಲ್ಲ ಮುಂಚೆ ಮಾಡಿದ್ರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ನೆಕ್ಸ್ಟ್
Please.
Section 55 of Karnataka Police Act.
Externment?
Externment.
Surat Sahib order covered, disposed. Yes.
41,
Same, yes, both disposed.
The order is passed by Chief Secretary under section 64. He has no authority. 64 is by the
Chief Secretary?
Chief Secretary of the Department of Industry and Commerce.
Principal Secretary, sir. Chief Secretary ಒಂದೇ ಇರೋದು government ಗೆ.
Sorry, madam.
ಏನೋ ಒಂದು ಹೇಳ್ತೀರಾ.
Industry and ಕೈಗಾರಿಕಾ ಇಲಾಖೆ.
Chief Secretary Department of Cooperation ಅಂತ ಯಾವ ಪೋಸ್ಟ್ ಇಲ್ಲ.
ಸರ್ಕಾರದ ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ.
ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ ಅಂದ್ರೆ ಏನ್ ಸರ್?
Principal. 64 says, my lords, it's
ಮುಖ್ಯ
registrar.
ಕಾರ್ಯದರ್ಶಿ Chief Secretary, sir. ಏನ್
Sir.
ಕಮೆಂಟ್ ಮಾಡಿ.
Yes.
There is only one Chief Secretary, one department ಗೆ ಅಲ್ಲ.
I'll do. 64 says, my lords, it's a registrar. Registrar is defined, my lords, under clause 2, my lords. It doesn't include any.
Permitted to take notice, my lords.
Learned AGA is directed to accept notice of the respondent. We'll take it on Monday. Monday fresh matters. Entry ಮಾಡಿ ಅವತ್ತೇ ಕೊಡುವ.
Please.
Monday fresh matters. Look into it and yes, next. Entry ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ 70 ಇದೆ ಅಷ್ಟೇ.
Cell number 43, Mrutyunjay Salikeri.
I seek for short accommodation of time, my lords.
2 weeks time to do the needful.
The writ itself does not survive, my lords, because he has sold the suit property.
ಏನಿದೆ? What's the matter?
There was a compromise between the petitioner and respondent herein.
List after vacation. Entry ಮಾಡಿದ್ಯಾ?
Entry ಮಾಡಿದೆ.
No entry ಮಾಡಿ.
I have filed a statement of objection also. It will
Rest
take on
immediately after
Monday or
vacation.
Tuesday.
Huh?
Tuesday or Wednesday.
Yes, next.
44, Santosh Narwan.
Yes, Your Worship. This matter concerns running a business bank account under the technical freeze. The petitioner's bank account is under technical freeze, Your Lordship, and an interim order permits.
Freeze ಮಾಡಿದಾರಾ?
Yes, Your.
Account freeze ಮಾಡಿದ್ದಾರೆ. ಕಾರಣ? Yes, government.
Please. Statement of objections already filed, my lords.
They already filed their counter also.
List on
No,
Monday in preliminary hearing.
No, Your Lordship, kindly permit me to submit the final hearing.
Monday preliminary hearing. Yes.
Or any other date. I have to come from Visakhapatnam for this.
You come from Vizag for
Yes.
this? Tell me. Yes. What's the matter? Tell me.
It's a show cause notice issued by the second respondent, that is CTO Vijaypura, for the amount of 89 lakhs 1,763. And the auditor of the petitioner also issued an elaborated reply which was filed an Annexure B. In that we clearly stated about the auditor officer and the adjudicating officer are the same. And as per the circular, CBSE circular, kindly see the Annexure O, your lordship.
Annexure?
Annexure O.
Annexure O.
Yes, your lord.
O. Page.
Page number 88.
Ah.
Yes, in that clearly state that is the superintendent of central tax or the commissioner is the authorized person to issue. Is the authorized person to issue the show cause notice as well as the adjudicate for the purpose
Who
of
has issued now?
C2. C2 is the second respondent C2 issued the show cause notice, but it has to be approved by the commissioner of the commercial tax.
It is not approved.
Not. That's what our context is.
All right.
And for
Ashte alla? Ante.
no, if I have to submit further also. Thank you.
Sir. Yes.
I don't know Kannada, so.
You don't know Kannada? What do you know?
Telugu.
What did I say now? Inke munde. Yes.
I will submit on Monday, my lord.
I want submit on Monday. Ashte jurisdiction idya ilva?
Only one submission. Due to this existence of lease, your honor, the salaries and vendor payments and statutory rules are also getting stalled.
All right, wait. Yes. You today made submission.
Please. I will submit on Monday. Monday I will.
Ashte jurisdiction unda leda? Monday.
No, not Monday.
Appear online. Yes.
45, Chair Kambiava.
Second case.
107 appeal is dismissed on the ground of delay.
107.
Yes, madam.
Second case.
Yes. Your lordship, seeking quashing order.
You should not give it in the left hand. You should not give it in the left hand. Right. When you pass on something to the court, you should not give it in the left hand.
Yes.
Same order. Yes. Next. Disposed.
Grateful.
6, third party.
My lords, in this matter, I appeal for the petitioner, my lords.
Sharp
My lords,
watch. Matte yaak bantu?
Please, my lords. My lords, on the previous occasion, if your lordship remember, my lords, your lordship was pleased to hear the matter and I directed the respondent to open the financial bid, my lords. Now my instructions are that, my lords, the financial bid is...
Sir, I represent the respondent 3 and 2. Sir, I represent respondent 2 and 3, sir. I have preferred appeal against the order passed on the last date, sir.
Oh, division bench ಏನಾಯ್ತು?
Sir, I have preferred appeal, sir, before the division bench.
Preferred.
Against the order.
Yes, what happened before the division bench?
Sir, it is pending, sir.
There is an interim order.
Yes, against the interim order, I prefer the appeal, sir.
Sir, division bench stay ಮಾಡಿದೆ ಈ order ನ?
ಇಲ್ಲ, sir. Stay ಆಗಿಲ್ಲ, sir. Stay ಆಗಿಲ್ಲ. Last time I have preferred. Last time I have filed the... Yes, sir.
Next time there is no stay andre I will allow the petition.
Yes, sir. I will get stay, sir.
Tuesday, fresh matters. Yes.
Grateful. My lord, the interim order may kindly be extended, my lords.
Interim order subsisting would continue till the next date of hearing. Yes.
Grateful, my lords.
47, St. King.
ಹೌದಾ? Current counsel respondent submits that the petition is rendered infructuous due to a flix of time. The petition is disposed as having become infructuous. Next.
48,
Milord.
Sajid Ahmad Godwala.
My lord, the petitioner is seeking for mandamus, directing the respondent authorities to reinvestigate the case in CC number 1554 and
Why,
to
sir?
change the investigation.
Karana?
My lords, in further statement of the petitioner, the petitioner stated that 9 accused persons have assaulted the petitioner and his mother. The PSI, who is the investigating officer, instead of adding the accused person as accused, has added 7 of them as witnesses, my lord. Sakshidarar anta hakbitar. My lords, may kindly see at page 72.
ಏನು ಟ್ರಾನ್ಸ್ಪೋಸಿಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ
My lords, kindly see the, my lords, in page number 191, the complaint which was given.
List in the fresh matters on, you take notice.
Yes, I'll take notice.
DGA is directed to accept notice for the respondent.
All the respondents.
All the respondents. Offense ಏನು?
My lords, 307. Earlier occasion, my lordship, the petitioner had preferred WP, wherein my lordship has directed the respondent authorities to arrest the accused persons.
Oh, ಇದೇನಾ?
That matter,
case.
please.
ಅದೇ ಫಾರ್ಮರ್ಸ್ ಗಲಾಟೆ ನಡೀತಾ ಇತ್ತು
ಹೌದೌದು.
ಮಾಡಿರ್ಲಿಲ್ವಲ್ಲ
Complaint is.
ವಿಟ್ನೆಸ್ ಮಾಡ್ಬಿಟ್ರ ಅವ್ರನ್ನ
ಅಲ್ಲ. ಇಲ್ಲ.
Other accused.
Other accused. They have, my lords, add some more accused. And the 7 accused which were, my lords, they were arrested, my lords. Their names are.
ಡೈರೆಕ್ಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬೈ ಸಂಬಡಿ ಎಲ್ಸ್ ಡೆಫಿನೆಟ್ಲಿ ಬೈ ಸಂಬಡಿ ಎಲ್ಸ್
Kindly out next week I will.
ಬಿಕಾಸ್ ಈವೆಂಟ್ಸ್ ದಟ್ ಹ್ಯಾವ್ ಹ್ಯಾಪೆಂಡ್ ಅರೆಸ್ಟ್ ಮಾಡದೇ ಇರೋದು ಇದೆಲ್ಲ ವಿಲ್ ಡೂ ಇಟ್. ಎಸ್. ಈಗ learned AGA to secure the investigation papers in crime number in CC1. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಆಗ್ಲೇ?
Charge sheet ಆಗಿದೆ.
Charge sheet ಆಗಿದೆ.
ಯಾವಾಗ ಹಾಕಿದ್ರು?
My lords, on
ದಿ ಕಂಪ್ಲೀಟ್ ಪೇಪರ್ಸ್ ಇನ್ CC ಇಲ್ಲ ಇದೆಯಾ ಹಂಗಾರೆಲ್ಲ?
already I have produced.
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
Sorry,
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
crime register, my lords.
Learned AGA is directed to accept notice for the respondent. List the matter on Thursday 10th in the fresh matters list.
Please.
Thursday 11th.
Thursday, yes.
Yes.
My sincerest apologies, my lords, my sincerest apologies.
48 office objection overruled. Yes, next. ಕಿಣಿ ಅವರೇ ಅದೇನೋ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ. ಕಿಣಿ ಅವರೇ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ ಅಂತ ಶರದ್ ಮಗ್ದಮ್ ಹೇಳಿದ್ರು ಕರೆಕ್ಟಾ?
Alala, despite that, my lords were pleased to direct the KSFC not to precipitate by giving or issuing a sales certificate or confirming the same on the last occasion. My dear friend, learned friend Sharad Magdum, he informed
ಟೆಂಡರ್
that.
ಮ್ಯಾಟರ್ ಸರ್ ಇದು.
Alla, auction. KSFC auction.
KSFC da ಇದು.
My learned friend Sharad, he informed me that no participation was done in the auction. Nobody participated.
ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner, the learned counsel for the respondent corporation submits that on the intended date of auction, the auction has not taken place. Therefore, the date of auction has spent itself. In that light, the learned counsel submits that nothing further would survive for consideration. The counsel for the petitioner would accept the same. However, while issuing any other notification for auction, the payments made by the present petitioner shall be taken note of by the respondent. With the aforesaid observation, petition stands disposed. Next.
Deeply obliged, my lords. My apologies again.
Sir.
Deeply obliged.
No problems.
Yes. The first respondent, lords.
ಯಾವುದು?
49.
Lord,
We have filed an application for vacating stay. Lord, what is challenged before my lords is, Lord, registration of the society, first respondent society. Lord, after lapse of more than 4 years and 5 months. Lord, the issue is, Lord, if my lords please turns to.
We'll take it on Wednesday. Fresh matters on Wednesday. Yes.
Your lordship, there is an interim order.
Interim bulk grant leaves. ಮನ್ಮೋಹನ್ ಯಾರಿಗೆ?
First respondent.
ಆಯ್ತು. On Wednesday, we'll take it in fresh matters. Next.
Petitioner. Pertaining to the appointment of Gram Sahayak.
I am the respondent, my lords. I left on Monday, my lords. ನಿನ್ನೆ ವಕಾಲತ್ ಹಾಕಿದೀನಿ. Please, Monday. Fresh matters.
Wednesday, fresh matters.
Please.
Your lordship, as per earlier direction, your lordship, the respondent has already joined the work, your lordship, on 17.
ಸಂಜಯ್ ಗೌಡ್ರ ಒಂದು ಆರ್ಡರ್ ಇತ್ತು ಅದಾಯ್ತು.
Please, ಸಂಜಯ್ ಗೌಡ್ರ.
ನಿಯರ್ ಬೈ ಎಲ್ಲಾರು ಕೊಡಿ ಅಂತ.
First, she has been appointed, your lordship, and subsequently.
Is Marathi language, Marathi language.
No. Third language is Marathi. Is incorrect statement. Both candidate are third language Marathi and they know the Marathi. And surrounding area is Marathi, my lords. ಆ ಏರಿಯಾ 9 ಹಳ್ಳಿ ಇದೆ ಎಲ್ಲ ಮರಾಠಿ ಲ್ಯಾಂಗ್ವೇಜ್.
ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಒಂದು ರಿಜೆಕ್ಟ್
ಮಾಡಿದ್ದಾರೆ. ಲ್ಯಾಂಗ್ವೇಜ್ ಇಸ್ ಕನ್ನಡ.
Marathi same day Marathi rejected the application on the ground that Marathi studied Marathi language. In this case Marathi appointed is very same day.
Right. Please. Wednesday.
Please.
51 Sabil Ahmed.
My lordships, I appear for the petitioner in this matter, my lordships. May I seek weeks accommodation, my lords, in this matter.
Let's start. AV. Interim order ಇದೆಯಾ?
ಇಲ್ಲ. My lord, there is no.
No IVO.
52.
Please, my lords.
Interim order ಇದೆಯಲ್ಲ ಇದೆಲ್ಲ.
Interim order may continue extended.
ಏನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ?
No, it is not for judgment, my lord.
Reserved, my lord.
Yes, Srirang.
No order is passed yet. Appeals are reserved for orders.
Leonard,
Uh,
the counsel
only
for the petitioner submits that the judgment in writ appeal number so and so is
526 of
reserved for its
2024.
is reserved for orders. Therefore, the parties are at liberty to move the matter once the division bench would pronounce the orders.
Please,
Subject to the aforesaid interim orders signed section. Next.
Please,
Next.
53. Manasi.
May it please your lordship. Challenging Annex B, my lordship. Preliminary notification. Portion of my land was sought to be acquired under preliminary notification dated 19/12/2023, my lords. Now, my lords, Annexure F may be kindly seen, my lords. That is the portion, the marked portion is sought to be acquired, my lords. Till today, there is no final notification nor award has been passed. Excavating activities.
ಎಲ್ಲಿ AGA? ಆಗಿದೆಯಾ ಅದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆಯಾ ಇಲ್ಲ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲ ಲೆಟ್ ಹಿಮ್ ಕಮ್
Please.
ಇಂಟರ್ ಆರ್ಡರ್ ಇದೆಯಾ
ಇಲ್ಲ ಇಲ್ಲ no we
not carry out ಅಂತೆಲ್ಲ ಇದೆ yes
protection may
ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ AV IO
please
yes ಗೊತ್ತಾ ಏನು
54.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಂಟರ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ಸ್ yes
Ganapati Bhatt.
Permitted to take notice, my lords, and
first time
this
shall not
GA
assume
served
charge
and
if he has not assumed charge idenantala list on Tuesday yes
last time it was a direction for BTDA to sort for directions whether there are excavating activities are carrying or not, my lords, but there was no interim order had been granted in this.
Then Tuesday fresh matters.
Please.
Sanjay barli.
Meanwhile,
Tuesday
status.
fresh matter. 50?
54.
52.
Eva 54.
Learned AGA is directed to accept notice for the respondent in voting.
1 to 4 and 6.
1 to 4 and 6. Oh, yes.
Please.
Emergent notice to the remaining respondents. Yes, next.
55.
Lord, this matter was listed day before yesterday. I'm seeking, challenging the transfer order.
But R2 Manada, I have taken notice on 2 and 3.
Lean.
Eska Manada, Kamtesar Esar Tosila.
ನೀವು ಯಾರಿಗೆ
KPTCL. But transfer order was made based on the letter written by the Lokayukta, the criminal, the case is pending against her. And only within the Malad, the Hubli city only, the transfer is. Alle Samipa idella.
My lord, the difficulty is, my lord, the stigma attached to the transfer order, my lord.
Oh,
because
ಲೋಕಾಯುಕ್ತ ಹೇಳಿದ್ದಾರೆ ಅಂತ.
Please,
Obviously.
my lord, the
FIR
Lokayukta,
register ಆಗಿದೆಯಾ ಇಲ್ವಾ? ಮತ್ತೆ
I don't deny, my lord. My lord, the Lokayukta, though the stay is granted by this honorable court, coordinate bench, instead of seeking for vacating of stay, they have passed this order, my lord.
Yes, sir.
They are not interested in.
ಲೋಕಾಯುಕ್ತ ಯಾರು?
My lord, Lokayukta are not made as party here.
Make them a party. The petitioner to implead the Karnataka Lokayukta as a party respondent. Counsel Anil Kale is directed to accept notice for his petitioner to serve set of papers upon the aforesaid counsel.
Please.
The petitioner, if he is not relieved as on today, shall not be relieved till the next date. List on Tuesday in the fresh matters list.
Lord, for respondent number 4, my lord, Kamte sir may kindly be directed.
Yes, Kamte.
Escom.
R4. Yes.
Please. Great.
So ಈಗಲೇ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಲೋಕಾಯುಕ್ತ. ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೆಯೋದಲ್ಲ ಇಲ್ಲಿ ಬರ್ಲಿ ಹೇಳಿ. Yes.
Please.
Admission matter Silma 56. Bharat A.
My lord, so I'm for the petitioner.
ಕೇಶವ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
I checked with the court master. Notice has been served, my lord.
ಸರ್ವ್ ಆಗಿದೆಯಾ? ಯಾವತ್ತು? It's served recently, 4/12. We'll take it next week then, finally. List the matter on 12th, finally. In the event there will be no representation, this court will be constrained to pass necessary orders.
Can I request for 13th, my lord, because I'm coming from Pune.
13th, I don't come Saturday, second Saturday.
I'm so sorry.
Yes. When do you want?
Yes, for 12th. Yes, much of had a matter in Bombay High Court on 12th.
On 13th?
On
second Saturday, sir.
No. On 12th.
On 12th. When you want 11th, you can appear online.
But online, my lord, physical is more effective, I suggest. Even for your,
one counsel who says that, yes.
On 11th, my lord.
11th.
Much
11th fresh matters next.
57, Shinande Pachapure, Girija Hiren,
50?
57.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಇಲ್ಲ. ಮೇಡಮ್, ಅಡಿಷನಲ್ SPP ನೀವೇ. SAG ಏನಿದು?
Please, minutes offense under section 465, 460, and 420 IPC. Now the charge sheet is filed.
9th January IO till then. ಕೊಟ್ಟಿದ್ದೀನಿ ಆಲ್ರೆಡಿ. ಎಸ್.
58 AM Gundwade,
ಅದು ಅಷ್ಟೇ ಸೇಮ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ಸ್.
ಬರ್ಡ್ಸ್ ಆಕ್ಟ್ ಡಿಫ್ರೀಸಿಂಗ್ ಆಫ್ ದಿ ಅಕೌಂಟ್.
ಅದು ಕರೆಕ್ಟ್, ಅದು ಕ್ವಾಶ್ ಆಗಿದೆಯಲ್ಲ.
Yes.
ಮತ್ತೆ the petitioner is before this court seeking the following prayer.
And clarification, my lords, only with respect to Birds Act is confirmed by the apex court.
The 420 is
420 is there.
but free ಎಷ್ಟಿದೆ ಅಕೌಂಟ್ ಅಲ್ಲಿ ದುಡ್ಡು?
Totally 37 accounts have been freezed as per the application made.
You should seek proper, it will lead to problems. List on Tuesday in admission. Wednesday. Correct instructions ತಗೊಂಬನ್ನಿ. Yes.
In fact, this case, your lordship may see, the Birds Act has been quashed based on our submission. I think we made a wrong submission in Supreme Court, my lord.
ಮತ್ತೆ ಅದನ್ನೇ, how can you make that? I had rejected it. ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೆ ಅಲ್ವಾ ಅದನ್ನ?
ಇಲ್ಲ.
Birds Act
ಕ್ವಾಶ್ ಆಗಿದೆ.
ನಾನು ಕ್ವಾಶ್ ಮಾಡಿದ್ನಾ?
ಹೌದು.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has confirmed it?
Confirmed. I produced both the orders.
That's because your lordship, I made a submission last time, my lord, that our SLP, we made a submission to the court that we don't have jurisdiction.
ಮತ್ತೆ
based on
ಏನ್ ಮಾಡೋದು?
Subsequently, there are two judgments of this court, my lord, which clarified this issue.
Then you just ಇದು enlighten ಮಾಡಿ ಆಮೇಲೆ. I will take it on Wednesday. Wednesday ಆಗ್ಬೋದಾ ಜಗದೀಶ್ ಸರ್?
Yes, my lord. Yes, my lord.
Yes.
For further hearing, my lords.
Wednesday ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ, ಎಲ್ಲೂ ಹೋಗಲ್ಲ.
ಅಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ, ಅದೊಂದೇ ಭಯ.
ರೀಚ್ ಆಗಲ್ಲ, ಎಲ್ಲ ಆಗುತ್ತೆ. ಎಸ್
ಪ್ಲೀಸ್. ಮತ್ತೆ
18th ಹಾಕ್ಲಾ? ಬೇಡ, ಇದು ನನ್ನ ಹತ್ರನೇ ಬರ್ಬೇಕು. ಇಲ್ಲಿ
ಹೌದು. Wednesday.
Wednesday.
Please.
Please. 498.
498.
Second petition on same cause
Earlier
of
petition has been it has been withdrawn.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು.
ಮತ್ತೆ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಮೇಂಟೈನಬಲ್. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ ಮೇಲೆ ವಿಡ್ರಾನ್ ಮಾಡಿದ್ರು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ ಮೇಲೆ ವಿಡ್ರಾ ಮಾಡಿದ್ರು. ಇಲ್ಲ, ಫಸ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೇನು ಸರ್?
ಚಾರ್ಜ್ ಶೀಟ್
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
The change of circumstance here is that the divorce petition filed by the husband has been allowed on the ground of cruelty by the wife.
That is already stayed by the division bench. Stays there.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಅದರಾಗ. ಎಲ್ಲಿ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆ? ನಾನು I have produced the order copies, earlier order copy.
Divorce petition.
Divorce petition allowed ಆಗಿದೆ.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ ಕೇಸ್ ಎಲ್ಲಾಗಿದೆ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ ಹೇಳಿ.
ಇಲ್ಲ, MFA ದಲ್ಲಿ already stayed, my lord. That they have also appeared in that matter.
So my submission is, your lordship,
no change circumstance.
ಇಲ್ಲ, my submission
ಮಾಡ್ಕೊಳ್ಳಂಗಿದ್ರೆ.
ಇಲ್ಲ sir, my submission here is that when a petition for divorce has been filed by the husband, that is the petition number 1, she has filed for contra blush, she filed this complaint, no problem, and it is there. And the Honorable Apex Court has held in Dharalakshmi case. So idu hingagide sir, same, it is same facts. The omnibus allegations have been made, and she was left the house in 2018.
You have to convince on second petition.
I'll convince you, just
not today. Yes. What is the next date? 12th, list on 12th in for admission.
Please.
Yes, next.
So interim order in respect of petition number 2 and 3 may be extended.
In-laws kidiya?
In-laws.
Interim order subsisting in the form that is subsisting shall continue to the next date of hearing. Yes, next.
In this case, I for the petitioner. Page number 88, my lord, annexer K, the government issued an endorsement stating that, my lord, to stop the construction of the biodiesel plant on the ground that, my lord, the guidelines issued by the Union of India is under consideration. Now, my lord, along with the memo, I have filed the, my lord, the notification.
We will consider. The petitioner is before this court seeking the following prayer. Heard, so and so. The petitioner is a company. The petitioner is a company incorporated under the provisions of the Companies Act. The issue in the list is with regard to the petitioner being permitted, ಏನಿದು? To sell biodiesel B-100 in a retail outlet. The learned counsel for the petitioner submits that the permission to sell the said biodiesel is not being granted despite the representations being submitted. The learned counsel would further, by taking this court through the documents appended to the petition, prima facie demonstrate that there is no impediment today for grant of permission for selling biodiesel B100 in a retail outlet. The learned counsel appearing for the learned AGA submits that if reasonable time would be granted, the representation of the petitioner would merit consideration and appropriate orders would be passed for the reason the representation is submitted. In the light of the said submission and the subsequent development, the impugned orders as a matter of form would stand quashed. The petition stands disposed with direction to the respondent 2 to 4 to consider the representation of the petitioner and pass orders in accordance with law within an outer limit of 8 weeks from the date of receipt of the copy of the order, if not earlier.
My lord, one request, my lord. In terms of my lord, the notification issued by the government of India.
Date?
22, my lord. I've produced the my lord along with a memo.
In terms of the notification dated, date ಹೇಳಿ. Representation to be considered in terms of the notification dated, so and so. Yes, next.
61, Girish V. Bhatt, Petition Relocan.
Dated 15/6/22.
15/6/22.
Seek for short time, my lords.
Short time.
We have not received any instructions, my lords.
What is the issue?
Refund of commutation amount. Refund of.
The learned, we stayed. List the matter on 9th
Commutation.
January. Interim order subsisting will continue to the next date. Yes,
It's
next.
like Mrityunjay Tatapangi, Rajshekhar Burji.
They're seeking for appointment on compassionate grounds.
Hmm.
Because my lord, the father passed away in 2011.
ಯಾರು ಕೊಡ್ಬೇಕು?
ನೀರಾವರಿ
ಯಾರು? ಚೇತನ್ ಮನೋಳಿ?
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಬುರ್ಜಿಗೆ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
Rajshekhar Burji.
ರಾಜಶೇಖರ್ ಬುರ್ಜಿ.
No representation, we have the respond. ಹೆಸರು ತೋರಿಸಿಲ್ವಾ?
ತೋರಿಸಿದ್ರು.
No heard the learned counsel Mrityunjay Tatapangi appearing for the petitioner. There is no representation, we have the respondent. In mandamus ಮಾತ್ರ.
Post mandamus.
Tuesday fresh
No,
matters.
there is a decree in my favor.
Tuesday fresh
Please.
matters. Yes.
Bill number 63, Rohit.
My lord, compassionate appointment. My lord, the father of the petitioner dies in the year 1985, and in the year 1985, the mother of the petitioner writes an representation to the Niravari Nigam, stating that she is uneducated, and once her son attains age of majority, he may kindly be given appointment. In the year.
When did the employee die?
1985, your lordships.
40 years ago.
Please, your lordships. In the year 2000, your lordships, he attained the age of majority and he makes a representation. In the year 2003, your lordships, he made a requisition to reconsider the same, but it remained unanswered. Till the year 2025, your lordships, it has remained unanswered, your lordships. In the interregnum, my lordships, Annexure F, it came to be issued by the principal engineer to the chief engineer, your lordships. A report came to be issued.
ಏನು ಕೊಟ್ರು?
Please, your lordships. The communication between the chief engineer and the principal engineer is that, as per the rules, the petitioner has not submitted his application in
Within
time.
1 year.
Yes, and that he was minor. His application cannot be, he is declared ineligible. But nowhere it is stated that.
Sir, appointment ಕೊಡ್ಲೇಬೇಕು. ಹಂಗೆಲ್ಲ ನೀವು can't deny. The petitioner is before this court seeking the following prayer. The mother, who was the employee?
My lord, father of the petitioner.
The father of the petitioner.
One submission. My lord, as per Annexure F, he was declared ineligible, your lordships.
Sir, orders passed by this court should not become a mockery.
But nowhere in the application, your lordships,
No problem.
it's being,
No problem. The petitioner is before this court seeking the following prayer, heard so and so. The father of the petitioner is said to be an employee of Karnataka Neeravari. ಅವಾಗ
ಅವಾಗಿಲ್ಲ
ಅವಾಗ
1996
ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
ಕರ್ನಾಟಕ ಗವರ್ಮೆಂಟ್ ಇರಿಗೇಷನ್
The
ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
irrigation department of the government of Karnataka. The father of the petitioner dies in harness on 8/5/1985.
January
ಇಲ್ಲ
1985.
31/1/1985.
31/1/1985, close to 41 years ago. It is at that point in time the petitioner was a minor. Minor would mean a 1-year-old child, as he is now 42 years. The petitioner then stakes his claim for compassionate appointment the moment he, not at the moment that he attains majority.
In the year 2000, he has made us a representation.
All right. In the year 2000.
When he attained the age of
All right.
majority.
In the year 2000, submits a representation on his attaining majority. The representation goes unheeded. The petitioner forgets it. Later in the year 2025, wakes up from deep slumber and seeks to resurrect a claim that had already died in the year 2000 when he submitted his representation.
2003 makes a reminder, your lordship.
And the learned counsel for the petitioner submits that there has been persistent demand by the petitioner right from 2000 till today for consideration of his case for appointment on compassionate grounds, but has not approached any court of law from 2000 till today seeking a direction for issuance, for direction for consideration of his case. This is the first petition preferred on 24th November 2025. Today, we are, as observed, we are in 24th November December 2025. The death of the sole breadwinner of the family has taken place 41 years ago. If after 41 years, this court would direct consideration of the application of the petitioner for compassionate appointment, it would be stretching compassion to an extent that is impermissible in law. Therefore, any direction being issued now to consider the case of the petitioner for appointment on compassionate grounds, as observed 41 years after the death of the sole breadwinner, would run foul of the judgment of the apex court in the case of State of Jammu and Kashmir versus Sajjad Ahmad Mir, 2005, 6 SCC, page 766, paral 12 to 15, extract ಮಾಡಿ ಮೇಡಮ್. In the light of the claim being 41 years, in the light of the death happening 41 years ago, and the judgment of the apex court which directs that appointments of even 17 or 18 years should not be considered, the case would not merit any consideration. The petition does not deserve any indulgence. Next.
Publish.
ಸುಮ್ಮನೆ ಹೋಪ್ ಯಾಕೆ ಕೊಡೋದು, ನೋಟಿಸ್ ಮಾಡಿ. ನೋಟಿಸ್ ಅಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಕೊಡಿ.
64, Venkateshan Harvi, KL Patil.
Regarding appointment of the Melords in Siddharwad Matta, so regarding the appointment already interim made by the Siddharwad Matta Trust Committee, Melords. Last time, this Honorable Court direct to file interim application that amendment.
ಸ್ಟೇ ಇರಲಿಲ್ಲ ಅಂತ.
ಕಾಪಿ ಸಿಕ್ಕಿ ಪೆಟಿಷನ್ ಕಾಪಿನೂ ಸಿಕ್ಕಿಲ್ಲ ಒಂದು.
And left Wednesday or press meet ಅಲ್ಲಿ.
ಅಲ್ಲ, one submission. Senior does not appear for the Matta Milords because he is a trustee. My name and my senior colleague SS Beturmat's name.
ಸರಿ, so and so.
And we don't appear for R2.
ನೇಮ್ ಎಲ್ಲ ಕೊಡಿಸ್ತೀನಿ ತಾಳಿ.
ಅಲ್ಲ, R2 ನಾವು appear ಆಗೋದಿಲ್ಲ. ಸಂಸ್ಕೃತ್ ಯೂನಿವರ್ಸಿಟಿ will have to take notice.
ಯಾರು appear ಆಗ್ತಾರೆ?
ಅನೂಪ್ ದೇಶಪಾಂಡೆ Melords. ಅನೂಪ್ ದೇಶಪಾಂಡೆ.
ಅನೂಪ್ ದೇಶಪಾಂಡೆ R2, ಆಮೇಲೆ ಸೌರಭ್ and
3 and 4.
So and so 3 and 4, one HCGP. If the petitioners order on IA ಅಂತ ಮಾಡಿ. If the petitioners are working as on today.
On working, my lords.
Not they are not working.
Interview ಆಗಿದೆ, appointment letter ಕೊಟ್ಟಿಲ್ಲ 2018 ಇಂದ.
ಇಲ್ಲ interview ಆಗಿಲ್ಲ.
Interview ಆಗಿದೆ madam. That is not dispute is annexed D. Interview ಆಗಿದೆ annexed D.
Previous round of litigation is there. Interview process was conducted which was found to be illegal. So we wrote to the Sanskrit University.
Counsel for the respondent seeks a week's time to secure instructions and make his submissions. 12th.
12th press matters.
Yeah, application ಏನಕ್ಕೆ ಸ್ಟೇ ಆಗಿದ್ರಲ್ಲ ಮತ್ತೆ?
ಅಲ್ಲ amendment ಕೇಳಿಲ್ಲ,
Even
ನಾವು
it
interim
appears
prayer
it is
ಕೇಳಿಲ್ಲ.
premature because
Interim
the Matha has wrote to the university, which is now under challenge. University has to take decision even as per previous Red Court's order.
They have not forwarded the, ಅಲ್ಲ ಯೂನಿವರ್ಸಿಟಿ ಕಳಿಸಲೇ ಇಲ್ಲ ಅವ್ರು.
12th ಮಾಡಿ.
Not on
It's
12th,
fresh matter,
some other.
that application.
ಮುಂದಿನ ವಾರದಿಂದ ಎಲ್ಲ ಫ್ರೆಶ್.
ಅಲ್ಲ interim
ಏನ್ ಬೇಕು interim?
application for interim order.
ಇಂಟ್ರಿಮ್ ಮಾಡ್ರಿ ಏನ್
Amendment ನಾವು ಹಾಕಿಲ್ಲ, ಕೇಳಿಲ್ಲ. It is not
ಅಮೆಂಡ್ಮೆಂಟ್ ಗ.
It is not incorporated in the petition. Interim prayer ಹಾಕಿಲ್ಲ.
ಪ್ರೇಯರ್ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ಕೊಟ್ಟರು ಏನು ಉಪಯೋಗ ಇಲ್ಲ, ಇದು ಇರ್ಲಿ ಬಿಡಿ. ಅಪ್ಲಿಕೇಶನ್ ವುಡ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ದ ಮೇನ್ ಮ್ಯಾಟರ್.
Please my lords. ಅಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತ ರಿಪೋರ್ಟ್ ಫೈಲ್ಡ್ ತಗೊಳ್ಳಿ.
During the course of the day.
ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ.
On 15th, it will be better.
No, 12th.
Or 11th, my lordship.
Oh, 15th fresh matters.
Please, my lordship.
All right.
Submission.
Reporting settlement ಅಂತಿದೆ.
Serial number 65 and 67. Matter is settled, but party is not appear. On 12th afternoon it may be kept.
12, 2:30, 65, 66.
In first matter, there is stay, lordship.
Interim order subsisting in
In
any of
first
these,
matter.
any of these cases shall continue to the next date of hearing.
Yes.
Yes. ಆಮೇಲೆ 2:30. ಬೆಂಗಳೂರು ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ.
Matter pertains to principal bench, serial number 1, Hari Prasad MB.
Appearing for the petitioner, my lords, a week's time may be granted in this manner to complete the office objection. Only
Counsel
2
seeks
objections is there.
Counsel seeks a week's time to comply with the office objections. It is sought for the third time. Therefore, finally, a week's time is granted. List the matter on 9th January. In the event office objections are not complied, the petition will be dismissed for non-prosecution. Yes, next.
Serial number 2.
Much obliged, my lords.
List on 9th. Yes.
Serial number 3, Subair KM.
Your Honor, appearing for the petitioner.
Same. List
Your
on
Honor,
9th. Interim order. Yes.
Interim order is there, Your Honor.
ಇದೆಯಾ?
Interim order ಇದೆ ಸ್ವಾಮಿ.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Much obliged.
Serial number 4, Vaidya Reddy.
List on 9th. Interim order subsisting would continue to the next date.
Serial number 5, S.D. Rajendra Reddy.
My lord, I seek leave of the court to appear for the respondent number 2, my lord.
Learned counsel, ಯಾವುದು ಸರ್? 5.
Balram ML. I'm appearing for the, I'll seek leave of the court to.
Learned counsel undertakes to enter appearance for the second respondent. So and so, register to print the name of someone who is appearing for the second respondent. 5th January. Subsisting will.
Balram ML.
Appearing. Yes, sir. Balram. Next.
Much obliged.
Same, 9th January, IO.
My lord, my lord, 5th, serial number 5th, could it be on 12th, my lord? My mother's ceremony is there. My mother's ceremony is there on the 9th. Could it be on 12th, my lord?
5th January, sir.
Much obliged, my lord. I'm sorry, my lord.
Yes.
My lord, sir. Serial numbers.
Sorry, 7.
My lord, serial number 7 is covered by decision, my lords. It is regarding 7. It is a BMTF filing the my lords, the FIR and the complaint. And
Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
List on 5th January, interim order subsisting will continue to the next date of hearing. Next.
Serial number 8.
I appear for petitioner in this case, my lord.
Same. Interim order subsisting will continue to the next date of hearing, 5th Jan. Next.
In this case, there is no interim order, my lord.
In which case, sir?
Criminal petition 1461.
Yo, ಎಲ್ಲದರಲ್ಲೂ ಇದೆ, sir. Yes, 9.
Serial number 9.
Interim order subsisting will continue to the next date of hearing. List the matter on 9th. Yes, next.
Serial number 10,
The lordship, for the respondent. Can I seek for a pass over? Your lordship, we are being led by a senior.
Yes, we'll pass it over. 2:30.
Grateful, your lordship.
Total 6 list ಕರ್ ಯಾವತ್ತು ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಎಲ್ಲಿದೆ? ಟೋಟಲ್ 6 ಎಂಟ್ರಿ ಮಾಡರ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಎಕ್ಸಲೆಂಟ್ ಟು ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು ಅರ್ಜೆನ್ಸಿ ಯಾವ್ದು 2:30 ಹೇಳಿದೀವಲ್ವಾ? ಅಷ್ಟು ಮುಗಿತು. ಎಸ್ ಸಂದೀಪ್.
Lord, one clarification, Lord.
After the judgment, I went through the amendment and and the interim orders passed in the division bench. The division bench as well as the Jallikattu order says the amended act of Karnataka of 2018 will hold the field, which has in effect, it says such other conditions. It may be permitted. Kambala and bull cart or bull race will be permitted and exempted from the from the various of PCA Act, but subject to such conditions. Now they will again say the circular of 2022 is admittedly under that amended act, and therefore 18 conditions.
Ask Gangadhar to come. Then 2:30 no. Yes.
Please.
My lords, regarding salaries, my lords. Yes, yes, my lords. By today evening, they'll be credited in the accounts of the petitioners.
ಅಂತ ಯಾರು ಹೇಳಿದಾರೆ ಆಗ್ಲೇ?
I've received instructions from the
Process
client.
was issued.
ಎಲ್ಲ full.
Full ಆಗಿದೆ. From
2025, April 2025.
From April 5.
April 25 ಆಗಿಲ್ವಾ ಇನ್ನು?
ಅಲ್ಲ, from that moment till now.
ನಾನು ಲಾಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ ಫ್ರಮ್ 25 ಏಪ್ರಿಲ್ ಟಿಲ್ ವಿಲ್ ಪೇ ನೌ ಬಟ್ ಅರ್ಲಿಯರ್
ಅದಕ್ಕೆ ನಾನು ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ ಇನ್ನು ನಿಮ್ಮ ಎಕ್ಸ್ಟೆನ್ಷನ್.
ಆ ತರ
ಬಿಡ್ಲಿ ಅಂತ.
ಇಲ್ಲ ಕೊಟ್ಟಿದೆ. ಫ್ರಮ್
ಬರ್ದೇ ಹೋದ್ರೆ ಬೈ ಯು ಟೆಲ್ ಮಿ.
ಅದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಮೌಂಟ್ ಮೊದಲಿನ ಅಮೌಂಟ್ ಅನ್ನ 9th ಜನವರಿ
ಅದು ಹಾಕಿದ್ದೀನಿ ಆಲ್ರೆಡಿ. ಟು ರಿಪೋರ್ಟ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತಾನೆ ಹಾಕಿ.
ಹೌದು ಅದನ್ನ I'll file memo along with that document from present amount.
Obligation.
Lords, may I make a submission?
Yes, sir.
Lords, serial number 57, I beg your lordship's pardon, engaged in other court, all lordship. There's an interim order, lordship.
That will continue.
Please, lordship.
Interim order ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Acha.
One submission, serial number 64, 12th ಗೆ 15th ಇರಲ್ಲ ನಾನು.
ಆಯ್ತು 12th.
I intimate.
ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
serial number 64, 12th.
ಯಾವತ್ತು ಬೇಕು?
12th.
ಆಯ್ತು 12th.
57 ಅಲ್ಲಿ my
ಅನುಪ್
name
ದೇಶಪಾಂಡೆ 11th. He is not in town on 11th.
my name may be deleted, your lordship.
ಅದ್ರಲ್ಲ ಯಾಕೆ?
57 ಅಲ್ಲಿ
57 ಯಾಕೆ ಗಿರಿಜಾ
additional SPP ಅಂತ
ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಾ?
ಪ್ಲೀಸ್ your lordship.
ಅಡಿಷನಲ್ SPP ಇರ್ಲಿ ಬಿಡಿ ಮೇಡಮ್.
Court officer, madam. Court officer, ma'am. No response, no?
But notification, the notification is in terms of the amendment act. ಅಲ್ಲ ತಾವು ಒಂದೇ ಒಂದು ಯಾವ್ದು ಡಿಲಿಷನ್ ಕೇಳ್ತಾರಂದ್ರೆ ಇವತ್ತೇ ಅವ್ನು ಕ್ವಾಶ್ ಮಾಡ್ಬೋದು ಬೇಕಾರೆ. ಅವ್ರಿಗೆ ಮೆಡಿಕಲ್ ಏಡ್ ತಗೊಂಡು ಕಿಟ್ ಇಡ್ರಿ ಅನ್ನೋದು ತಪ್ಪು ಅಂತ ಬಂದಾರ.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅದನ್ನೆಲ್ಲ ಆ ಕಂಡೀಷನ್ ತಾವು ಒಂದು ನಿಮಿಷ ನೋಡ್ರಿ, 5 ಇವತ್ತೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡಿ 5 ಕಂಡೀಷನ್. ಅವನು ಬೇಡ ಅಂತಂದ್ರೆ ಪೇಜ್ 20 ಮೇಲೆ ಪೇಜ್ 20 ಮೇಲೆ 21 ಮೇಲೆ ಕಂಡೀಷನ್ ನಂಬರ್ 8
ಕ್ರೀಡೆಯನ್ನು ಯೋಜಿಸಿ
ಅವ್ರ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು, ಅದು ಎತ್ತು ಆಕಳುಗಳದ್ದು ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕಾಗುತ್ತೆ. ಅದೇನು 13 ನೋಡಿ ಸ್ವಾಮಿ, 11-13
ಹಿಂಸೆ ಮಾಡಿದ್ದಲ್ಲಿ ಪ್ರಾಣಿ
ಮಾಡಬಾರ್ದು ಅಂತ ಇವನ್ ಡಿಲಿಷನ್ ಕೇಳ್ತಿದಾರೆ.
ಆಯ್ತು, ಆಮೇಲೆ
ಮತ್ತೆ 15
3 ದಿನ ಮುಂಚೆ ಕರೆಕ್ಟ್ ಆಯ್ತು.
ಪರ್ಮಿಷನ್ ಅವ್ರು ಡಾಕ್ಟರ್ ಲೋಕಲ್ ಈ ಕಂಡೀಷನ್ ಅವರು ಇದನ್ನ ಕೇಳ್ತಾರೆ, ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಕೇಳ್ತಾರೆ, ಇವು ಕಮೆಂಟ್ಮೆಂಟ್ ಮಾಡಂತ
ಹೇಳ್ಬಿಡ್ತೀನಿ ಸ್ವಲ್ಪ. ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ಕಂಡೀಷನ್ ನಂಬರ್ 8. ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್
ನಂಬರ್ 8. ಕ್ರೀಡೆಯನ್ನು ಆಯೋಜಿಸುವ ಕ್ರೀಡೆ ನಡೆಯುವ ಭಾಗವಹಿಸುವ ಎಲ್ಲ ಎತ್ತುಗಳ ಪರಿವೀಕ್ಷಣೆ ನಡೆಸಿ ಎತ್ತುಗಳು ಭಾಗಿಸಿ ಉತ್ತಮ ದೇಹ ಸ್ಥಿತಿಯಲ್ಲಿ. ವಾಟ್ಸ್ ರಾಂಗ್ ವಿತ್ ದಿಸ್?
This I am saying.
This is in tune with the Supreme Court order, sir.
That's what I am saying, Lord. This can be provided by the owner of the
Supreme Court. One moment. Supreme Court has recognized this particular, not in so many words, but there is already rules in place antane helidare Supreme Court. If you see para 34.
Yes, Lord. Rules and amended act in place anta helidare. Kindly have a look at this circular. This is not
amended act is in place. Karnataka has not framed any rules like Madras or other states. Now this is akin to what they say. This is the rule. See, Supreme Court judgment is subsequent, but
Lord, kindly bear with me for 2 minutes, Lord. 2 minutes. Kindly see this condition. What I am saying is, as far as the animals or bulls are concerned, the owner of the bull will have access to the bull. And he can get the certificate, not the organizers. I am saying kindly remove the organizers from that condition.
ಅಲ್ಲಿ ವ್ಯಕ್ತಿಗಳಿದ್ದಾರೆ ಮುಂದೆ. ವ್ಯಕ್ತಿಗಳು ಅಂದ್ರೆ ಓನರೇ.
ಅದೇನು ಓನರ್ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲ, ವ್ಯಕ್ತಿಗಳು ಅಂತ ಇದೆ. ಅಲ್ಲ, ಆಯೋಜಕರು.
ವ್ಯಕ್ತಿಗಳು ಅಂದ್ರೆ ಯಾರು? ಅಲ್ಲ, ವ್ಯಕ್ತಿಗಳು ಅಂದ್ರೆ ಯಾರು? Owners will give the certificate, no problem.
That's all, my lord. That clarification can be done.
Ultimately, what order I have passed is correct. No problem. It is in tune with Supreme Court directions. Whatever you have to do, you have to do. ಈ ಕಂಡೀಷನ್ಸ್ ಅಲ್ಲಿ ರಿಲ್ಯಾಕ್ಸಬಲ್ ಕಂಡೀಷನ್ಸ್ ನೀವು ಕೇಳ್ತಾ ಇರೋದ್ರಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ. ಕಂಡೀಷನ್ ನಂಬರ್ 8 ವ್ಯಕ್ತಿಗಳು ಬೇಕಾದ್ರೆ ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ.
ಅಷ್ಟೇ ಕಂಡೀಷನ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ವ್ಯಕ್ತಿಗಳು
ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರೆ.
ನಾವು ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಕಂಡೀಷನ್ ನಂಬರ್ 13. ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಇದನ್ನ ಆಯೋಜಕರ ಮೇಲೆ ಹಾಕ್ಬಿಟ್ರೆ ಬ್ಯಾನೇ ಮಾಡ್ಬಿಡ್ಬೋದು, ಪ್ರೈವೇಟ್ ಮಾಡ್ಬಿಡ್ಬೋದು ಅನ್ನೋದು
ಸುಪ್ರೀಂ ಕೋರ್ಟ್. 1 minute, Sandeep. That is what Supreme Court has said. I will not travel beyond the Supreme Court.
No, my lord. What I am saying is the access. Who can give the certificate, Lord? The person who brings the bull, not the person. Not the villagers.
ಅದು ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ. 13 ಕ್ಲಾರಿಫೈ. ಅಲ್ಲ, ಹಿಂಸೆ ಅವರಿಗೆ ಪ್ರಾಣಿ ಹಿಂಸೆ ತಡೆ ಅದು that is what Supreme Court has said. I will not go beyond that.
Kindly bear with me. ಈ ಪ್ರಾಣಿ ಹಿಂಸೆ ಮಾಡಿದವರಿಗೆ ಅಂಡರ್ ದಿ ಆಕ್ಟ್ there is a offense, Lord. Can the organizers be held responsible? Kindly see the first line. Again, there is organizers. Kindly delete that word.
One moment. ಹಂಗಂದ್ರೆ ಈಗೆಲ್ಲ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
Vicarious liability.
ಪೂರ್ತಿ ಅಲ್ಲ, vicarious liability ಪ್ರಶ್ನೆ ಅಲ್ಲ. See, you bring everything and in your play there, many things happen. So ಅದಕ್ಕೆ owners of the bulls are responsible or you are responsible?
No, this is same.
No, sir.
ಅಲ್ಲ, ಯಾವ ಸನ್ನಿವೇಶದಲ್ಲಿ ಅಂತ ಕ್ಯಾನ್ ಆರ್ಗನೈಸರ್.
One moment. See, this is in tune with what the apex court has said. I will not travel beyond the apex court, and you also should not protest beyond what the apex court has said. How can you say?
Amended act.
8 ಅಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ ಬೇಕಾದ್ರೆ.
ಅದು 13. While we are on 13, 8 I obliged, Lord. While we are on 13, kindly have a look at the amended act. Shashwat, my colleague will pass it on.
Wait, I'll just run through the list. Last ತಗೊಂತೀನಿ 5 ನಿಮಿಷ.
Please.
List ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಂತೀನಿ.
Please. Lord, with your lordship leave, may I just mention a matter, Lord?
Yes, Angad?
Yes, Lord, this is pertaining to the matter which your lordships heard me one day back on 3rd, Lord. Your lordships had directed for listing on 5th. I believe the other side council is also on online, Lord. They just wanted to mention if your lordship can take it on some date convenient because they're also ready to argue.
Who is there? Other side?
Melons,
Anyway,
I appear for the respondent, Melons.
Shall we take it on 12th?
Please, Melons, or the fifth the matter is coming, Melons, connected matter is coming. On that day only, if the 2:30 the
That's why
matter
I
is
said
taken.
5th January. I don't know, but what is it?
Lord, I don't know. They had written to me saying that they're ready to argue on 12th. Now online they come and they're saying something completely different. Their colleague had told me that they're ready to
No,
argue
that's
on
all right.
12th.
So whatever,
I'm
both
not
of you
saying
tell
that
me a
I'm
date.
not
I'll
ready,
go.
Melons.
Don't worry. We'll take it on 5th only. Yes.
5th 2:30
Yes.
I'm
Melons.
obliged. I'm obliged.
Yes, yes. 2:30. Continue my list. 2:30 they have the career.
Serial number 67, Prithvi Shemke, Shivraj Balluli.
Lordship, I appear on behalf of the appellants in serial number 67, Your Lordship.
We'll reserve this. I've heard it. Yes. Kodi. Objections, sir. Kodi. It reserved. Murunu. Nitin Ramesh ಇದು. ಅವಿನಾಶ್ ಯಾವ್ದು ನಿಮ್ದು? ಮೂಡ? ಕೊಡಿ. ಆಯ್ತಾ?
70, 14%.
Will not present. Not come again?
Not come again, my lords. However, she was here yesterday and day before.
Oh. The coordinate bench of this court on 11/9/2025 had passed the following order. On, madam, what's the
25th
enrollment ಆಗಿದೆಯಾ?
She has been enrolled, As of now, she has been suspended. Interim order has been passed.
Suspended why?
There is on 11th.
Alla, suspended why? Oh, that's the order under challenge.
No, that is this is an interim order on 20/11/2025, my lord. There is an interim order by the Bar Council that she has been suspended.
Suspended. ಅದನ್ನೇನು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
The intention is that there is a parallel proceedings.
ಈ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು ಅದರಿಂದ. ಎನಿವೆ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದೆ. This court on 11/9/2025 had passed the following order. On 12/11/2025, the interim order stood extended. Again, the matter comes up on 14/11 and 19/11. The matter is adjourned to 25/11/2025. On 25/11/2025, this court had passed the following order. It was clearly indicated that in the event the petitioner would not be present, and this as that would be the 5th occasion of her absence, the interim order would get automatically vacated, and the petitioner would also run the risk of getting the writ petition itself dismissed, subject to the aforesaid observations. Even today, there is no representation. The petitioner in person is not present. In that light, the interim order subsisting stands vacated, lest the matter on 12th as a last chance for appearance of the petitioner in person. In the event the petitioner in person would not appear on the 12th, appropriate orders would be passed.
My lordship, I have a request to make. Though the suspension order clearly states that she is forbidden from wearing band and the coat, she continues to do so. So
The learned counsel appearing for the respondent submits that at this juncture, the learned counsel appear, ನೀವೇನ್ ಬರೀ ಫೋಟೋ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ?
He is wearing band.
The learned counsel, Srimati Archana Magdum, on instructions would submit that she is no doubt enrolled as an advocate, but the enrollment,
Only because in form, the Lord at 11, your lordship may kindly peruse page number 76,
uh,
of the objection
Objections
filed by the respondent.
76, sir.
76 in that form number, in page number 77.
Uh,
There she states that 11, column 11, ನೀವು ಬೇರೆ ವೃತ್ತಿಯಲ್ಲಿ ತೊಡಗಿದ್ದೀರಾ ಅಲ್ಲಿ she says not applicable.
ಬೇರೆ
ಬೇರೆ ವೃತ್ತಿ
ವೃತ್ತಿಯಲ್ಲಿ ತೊಡಗಿದ್ದೀರಾ ಅಂತ ಕೇಳಿ ಪ್ರಶ್ನೆ.
ಓ, ಅದಕ್ಕೆ.
There is question,
ಹಾ.
not applicable, for which the it has been considered. Subsequently, when the under
Came
the
to
right
know about this.
information, when the right
The
information
learned
was
counsel Srimati Archana Magdam, appearing for the Karnataka State Bar Council on instructions, would submit that the application of the petitioner was processed on account of the falsehood and account of the misinformation that was shown in the application, that she was not in any other avocation. But on coming to know after filing of the after registration of the complaint that she is elsewhere doing other things as well, the enroll.
are pending against her.
Madam?
Many criminal proceedings are
And many criminal proceedings are pending against her. The enrollment has stood suspended, and the order of suspension clearly indicates that the new year
interim order.
interim order.
the suspension, the order of suspension reads as follows. During the period of suspension, the petitioner is debarred from appearing, acting, pleading and practicing in any court. Band ಹಾಕೋಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ.
But whether that order is communicated to her at the
ಅದು ಗೊತ್ತಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ. Let's see, ಅದೇನ್ ಬೇಡ.
network issue.
The petitioner is precluded from practicing in terms of the order of suspension. The said order of suspension has not been challenged. In that light, and they will not been challenged, and the petitioner in person has remained absent throughout and even today. In that light, as a last chance, list this matter on 12th. In the event she would not be present on the said day, appropriate orders would be passed. Yes.
My lordship, it may be taken up as fresh matter on 12th. My lordship.
Yeah, okay, 2:30, further hearing at 2:30. Yes, it is already further hearing.
71.
We should not keep quiet with such people. Action should be taken. Action should be taken, they should be sent home. Criminal case register madilva?
ಮಾಡಿದೆ my lordship. ಮಾಡಿದೆ, she has gotten a stay everywhere.
That will see, yes. ಇಲ್ಲೇ ಎಲ್ಲ ಇರ್ತಾರೆ, ಕೇಳಿಸ್ಕೊಂತ ಇರ್ತಾರಲ್ಲ. Last time ಹೇಳಿದ್ದೆ ಅದನ್ನೇ.
Come and she served coffee.
ಮತ್ತೆ she would be somewhere here or watching online.
71.
Yes.
Represent the state in the matter, my lords. I appear for the petitioner, my lords. This is that Anganwadi beneficiary, my lords, who was denied the benefits due to mandatory implementation of the nation.
Last time Government of India took
additional solicitor.
Yes. Yeah.
My lords, may I have my lord's leave to appear, my lords? I beg to appear for the union.
Yes, madam. I am not able to see you anyway. Yes, madam. Yes.
Can your lordships hear me now, my lords? I am sorry.
I'm able to hear you. Yes, now I'm able to see you as well. Yes.
Grateful, my lords.
Yes.
My lords,
Yes, madam.
we have filed, my lords, 2 affidavits, and we have filed an application for vacation of stay also, my lords. And what I want to, my lords, highlight for your lordship's kind consideration is, my lords, it appears that the reason why she is not getting the benefit appears to be some glitch, my lords, because your lordships have already recorded the statement of my colleague on the last occasion that no funds have been curtailed for any of the states. In fact, my lords, our affidavit, I will show to your lordships that how Karnataka is really a flagship state for us and has been the highest achiever state across the country. And over 99% achievement for, my lords, this new technological upgradation. The sole purpose of the upgradation is to directly reach the beneficiary. My lords are already aware, my lords, that the take-home ration is a very surgical scheme, my lords, fine-tuned scheme to ensure that the well-being of the beneficiaries during the time that they are, my lords, rearing and bringing up the younger generation of the nation, it is well taken care of. This is my colleague would be carrying a note on the scheme, my lords. I'll request your lordships to have a look at it. There are mechanisms in place for errors and my lords, technical difficulties to be cured. We run a helpline for this. We have time to time, my lords, every fortnightly, every monthly, we are having sessions with our workers, my lords, and all issues are resolved. So if there is a issue qua particular person, that must be resolved. In fact, your lordship's interim orders, it appears that she is not getting the benefit still, because in our system she is shown as migrated out. So her and this is in the absence of any relief being curtailed from us. There is no curtailment of funds, there is no curtailment of relief. So, and in fact, we have put data in our counter affidavit, my lords. May I draw
Yes.
the lordship's attention
Yes, madam.
to my lords? If my lords have our
Yes.
statement of objections first,
I'm having it, madam.
please, my lords. Your lordships will see.
Yes.
My lords, I want to take your lordship specifically to the petitioner. At page 2, my lords, para 3, page 2 of our
Yes.
objections, that she is registered in the portion tracker, the digital
Yes.
app of the
Second
Saksham
mail.
Anganwadi scheme. Yes, my lords, I am placing page 3, my lords. Page 2, I'm
Yes,
sorry.
I'm there, madam.
Top of the page.
Yes.
This is about her, my lords, that the petitioner is registered in portion tracker. She already is registered in the digital app of Saksham Anganwadi scheme as lactating mother from April 24 to September 24. Then she re-registered
Yes.
in March 25 again for her next pregnancy and converted to a lactating mother in June 25 with the date of delivery as 6.
Yes.
And she has been marked as opted out of supplementary nutrition program on 29/10/25. So her status is still shown as opted out beneficiary. And we have checked up,
Yes.
my lords, if your lordships will have, would your lordships have our affidavit that was filed yesterday, my lords, additional counter affidavit?
Additional counter affidavit is.
Please, my lords.
Yes.
So if your lordships will have
Yes,
the
ma'am.
annexure, my lords, page 10, there is only one annexure to this affidavit. Her profile is still
Yes.
being shown as migrated out profile. Her name is in the, my lords, we've put it in a box to be identified.
Yes.
So
Yes,
she is still
correct.
shown as migrated out. And please see at page 6 of this very affidavit, my lords.
Yes.
This is the data. Para 9 is the data qua the district of Belgavi.
Yes.
And para 10 is the data qua the Anganwadi where she is registered. Now this Anganwadi, which, my lords, is being facilitated by one Anganwadi worker. Your lordships will see even in October 2025, 100%, 40 Anganwadi beneficiaries in this Anganwadi, the same Anganwadi where she is registered, they have taken benefit. So it's the same worker through whom the benefit has been taken. So either, my lords, there is some issue with the implementation. The issue is not with the policy, I can assure your lordships, my lords. The policy,
All right.
your lordships may kindly have one more thing, my lords. Kindly have para 8 of this additional counter, page 5, my lords.
Yes.
Please see how
Yes.
well state of Karnataka has performed. In fact, we are from the, my lords, union government, we are very proud of the performance of the state of Karnataka. They have been a front runner achievement on, my lords, on these technological initiatives, my lords.
Yes.
So, my lords, that being the position, my lords, there, my respectful submission is, and the note that my colleague would have just handed over to your lordships, it's a 2-page note. Your lordships will see in that I have, my
Yes.
lords, spelled out options that are available. In fact, there is a redressal mechanism which is available in our notification itself. If I may request your lordships to take, my lords, annexure K of the writ petition, which is our notification, starts at page 173, my lords.
Yes.
And specifically, I'm drawing your lordship's attention to page 175, clause 3C of this notification. May I read this, my lords? At page 170,
yes, madam.
clause 3, where
I'm there.
Aadhaar,
Yes.
lordship, I'm grateful, my lords, where Aadhaar authentication
Yes.
fails due to poor biometrics of beneficiary or due to any other reason, the following remedial mechanism shall be adopted. And C, she specifically qua C. In all other cases where biometric or Aadhaar one-time password or time-based one-time password authentication is not possible, benefits under the scheme may be given on the basis of physical Aadhaar letter whose authenticity can be verified through quick response code printed on the Aadhaar letter. Necessary arrangement of quick response code reader shall be provided at the convenient location by the ministry through the implementing agency. So, my lords, what I'm respectfully submitting is no beneficiary should be left behind and cannot be left behind, my lords. We are, after all, my
That's all
lords.
the concern of the court, madam.
I
That's
saw
all the
that,
concern of the court.
I saw your lordship's order, my
Yes,
lords, and that is why I took specific instructions on what is the redressal mechanism we have. And with this, your lordships will see the note that my colleague has handed over. Your lordships will see that
Yes,
there
it's
are
here.
helplines we are running. There are technological solutions that are available, my lords. Specifically, if your lordships will kindly have
Beneficiary interface.
para 9 onwards, my lords. Grievance redressal mechanism under the mission.
Yes.
So, to facilitate grievance redressal to citizen beneficiaries under Mission Saksham Anganwadi and Poshan 2.0 Pradhan Mantri Matra Vandana Yojana, Ministry has established 3-level grievance redressal system. Physical call center with toll-free helpline, which is 1515. This helpline is available in 17 languages, managed through a call center facility having more than 100 agents. Call center is operational since November 22 and upgraded in February 25. Helpline provides an option to raise a complaint at the following 3 levels. One is at the Anganwadi level, Anganwadi worker level. One is the supervisor, and then next is child development project officer level. And the complaint has a window of 7 days to be resolved at each level and escalated to the next higher level. Once the ticket is created, an SMS is sent to the beneficiary with the complaint number. Another SMS is sent to beneficiary at the closure of the complaint. And please see that we have put the details of grievances that we have received. On the national level, how many grievances we have received as on 30th November, how many, at which level wise your lordships will see. Then there is a column qua Karnataka, and then there is a column qua Belgavi district, which is where the petitioner is, my lords. No grievance has been raised qua the petitioner. And then please see beneficiary interface. Beneficiary interface is a web and mobile based platform designed to enable transparent and citizen centric service delivery under Portion Tracker ecosystem. It can be accessed by any beneficiary through the web portal or via the Portion Tracker mobile application. Interface provides for the following key functionalities: self-registration, FRS, which is the facial recognition system with live photo capture for authentication, grievance management, which enables beneficiaries to raise grievances and track the status of previously submitted grievances, service view, take-home ration distribution details, growth monitoring records for children, home visits conducted by Anganwadi workers. Then the third aspect, third mechanism is Portion Tracker website, a digital portal interface where beneficiaries can submit their grievances using the official Portion Tracker website. And lordships will see serial number 10 also. After every grievance, my lords, SMS alerts are sent to the beneficiaries. SMS alerts are sent to them even when the delivery is picked up, so that there is a full system in place, my lords. Then, my lords,
There appears to be a complete remedial measure, grievance redressal,
Yes, my
everything
lord.
in this. Let's
So
see.
my respectful submission is, my lords, your lordships, my lords, reflecting on a scheme, my lords, on which we are ourselves, my lords, very, my lords, we are focused on providing using the technological initiatives to ensure that the beneficiaries, and please see, my lords, what is happening today. A lady who needs the take-home ration, this is online, offline, both modes. So far, my lords, if this is a technological innovation, nobody can take ration in her name. She herself will be the beneficiaries of this supplementary nutrition. And your lordships have recorded in our additional affidavit in para 15, we have said so what your lordships have recorded on the last occasion, that no funds has been curtailed for any of the states. And we are jointly funding this, my lords. The whole architecture of the National Food Security Act really rests on union and the states in equal measure.
Yes.
While we provide the policy initiatives, my lords, and the funds in a large measure, in the case of Karnataka, in equal measure, my lords, the state is actually the implementing agency under the National Food Security Act. And therefore, my lords, if implementation is lacking, your lordships may consider passing a direction for the beneficiary to be given the benefit and to be identified why she is still shown as a migrated out. But
Yes,
lordship may
we'll
consider,
hear
my lords, that the interim order reflecting on the scheme which is otherwise doing very well, your lordships may consider, my lords, in view of the.
I will record his submission, but modification or otherwise will be after hearing them. I'll record the submission, madam. Madam, what's the name?
Aishwarya Bhati, my lords.
Heard the learned Additional Solicitor General of India, Ms. Aishwarya Bhatti. The learned Additional Solicitor would take this court through the objections, the additional affidavit, along with the documents appended to both the objections and the additional affidavit, seeking to demonstrate that there is nothing wrong with the scheme, or there is no funds curtailed for the implementation of the scheme to the state of Karnataka. The learned ASG would impress upon the fact that it is state of Karnataka which is leading in implementation of the scheme, and the facts and figures would reveal such implementation. The learned ASG would further affirm that there are no funds at any point in time curtailed for the implementation towards the implementation of the scheme. Therefore, whatever is noticed in the interim order quay the scheme must not mean that the scheme has some problem. The learned ASG submits the scheme has no problem. It has all the grievance redressal mechanism in the scheme itself. Therefore, the interim order needs to be tweaked or vacated is the submission. Yes, when do you make your submissions? It's as good as hearing the matter.
That's true, my lords. I leave it to my lords. I understand there are about 2 weeks left before vacation. If a lordship's got accommodators on this side or immediately after.
Pre-vacation only, I'll take it. I'll list it on 17th.
Very well.
I'll list it on 17th at 2:30 p.m. to hear further.
I'm grateful.
And whatever observations in the that we will take it off on the next date.
Certainly.
Yes,
In the interim
please,
order,
please.
the scheme. I've already said so now. Yes. Yes.
Please.
List the matter
I'm
on
grateful.
17th at 2:30 p.m. for the
Grateful.
I'm very grateful to your lordships, my lords.
Yes, madam.
I think that interim order need to be extended. I'm not sure. If it is, then it can. Is it till today? I'm not
With
sure.
the aforesaid
I don't have.
observation, aforesaid observations, the interim order stands extended to the next.
I'm grateful.
Yes.
Grateful, my lords.
Please.
2:30 more matters now.
230 more list, serial number 1, Rohit Lathur.
Transfer matter, I think, your lordship, earlier lordship has passed the order, ಇದು KT approach ಆಗ್ಬೇಕಂತ ಹೇಳಿ.
ಏನಕ್ಕೆ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಇದನ್ನ? ಅಲ್ಲೇ ಹೋಗ್ತಾರೆ ಅಂತನ?
ಅವರು ಅವತ್ತು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಕರೆಕ್ಟ್, ಅದು ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಬರ್ಲಿ ತಗೊಳ್ತಾರೆ. withdraw. Then counsel of the petitioner seeks leave of this court to withdraw the petition and avail of such remedy as this court on so and so had passed the following order. Counsel of the petitioner seeks leave of this court to withdraw the petition withdrawn, reserving such liberty.
Please.
Serial number 2, VM Shilvan.
Please, Lordship, in this I challenge the issuance of the possession warrant, Lordship.
TMCPC.
Please, Lordship.
ಸಾಹೇಬ್ರು ಇಲ್ಲಲ್ಲ.
Your Lordship, now contention was raised before the execution court there, stating that the court has no jurisdiction, pecuniary jurisdiction, Lordship. My objection was rejected and
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಸೆಕ್ಷನ್ 47
ಇಲ್ಲ ಇದು 39 section 39 ಪ್ರಕಾರ it has to transfer.
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ jurisdiction ಇಲ್ವಾ? ವೈ?
Pecuniary jurisdiction, because Lordship at the
ಏನ್
time.
pecuniary jurisdiction?
Now Lordship, the suit is one for the possession and rent and also for the means profit, Lordship.
ಆಯ್ತು, ಮೀನ್ ಪ್ರಾಫಿಟ್.
Now Lordship, the value of the execution petition exceeding more than 15 lakhs rupees.
ಆಮೇಲೆ anything else? As on the date of the decree. Not today's value, sir.
Even though Lordship.
No, not today's value.
39, section 39.
I have myself held interpreting that. Not today's value. See, executing court cannot go beyond the decree. Whatever is the amount in the decree, it is being executed. Now, before the executing court, what value is to there? Oh, sir.
No, Lordship, if I am not wrong, Lordship, here there is provision under section 39. The court, here the executing court.
Again, urgency, na?
Possession warrant.
Monday or again.
Hotel is this. Hotel, commercial.
Hotel la? Yen hotel la?
Commercial properties.
List on Monday for the appropriate bench in the fresh matters list. Till such time, no precipitative action shall be taken against the petitioner.
Please. May I request Lordship dispensation of notice to the respond number 2 to.
ಬೇಡ ಬೇಡ, ಎಲ್ಲ ಅಲ್ಲೇ ಕೇಳ್ಕೊಡಿ.
ಸ್ಟೇಗಳಲ್ಲ?
Notice itself is in the form of order and they have not given any opportunity or sought any explanation.
The petitioner is before this court calling in question an order, a notice that
Page 48 minutes.
warrants demolition of the property of the petitioner. The learned counsel for the petitioner submits that the notice is in the nature of an order and there is no prior notice issued to the petitioner. In that light, demolition of any kind shall remain stayed till the next date. Emergent notice to the respondents. Next.
Cell number 4. Yes, Kalsurma.
Yes, Kalsumat.
Please.
The present petitioners hearing.
136(3).
Out. Lord, for the first time in the year 2015, the Forest Department makes a request to the Tahsildar to enter their name based on the notification issued on 15/8/1964. On that basis, Assistant Commissioner and DC set removed the name and directed the entry. No, nothing.
Caution ಮಾಡ್ಬೇಕು straight away.
No, my lordship, it's in the 1964, it is declared as a reserved forest.
ನೋಟಿಸ್ ಕೊಡೋದು ಬೇಡವೆ?
ಅಲ್ಲ, ಅದು ಪಟ್ಟ ಲ್ಯಾಂಡ್ ಅಂತ 64 ದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅದು ಯಾವ ಲ್ಯಾಂಡ್ ಆದ್ರೆ ನೋಟಿಸ್ ಕೊಡೋದು ಬೇಡವೆ?
First time, my lordship.
ಅವರು ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿರೋದಲ್ವಾ ಇದು?
Yes, my lordship.
At the learned counsel appearing for the petition, learned AGA na HCGP na?
AGA, my lordship.
Learned AGA. The learned counsel V.S. Kalsurmat appearing for the petitioner submits that the entry in the revenue records is changed overnight and the name of the forest department is entered without even issuing a notice to these petitioners who are in possession of the property
Since 2008.
Since 2008, and the names are entered on the strength of a particular notification of the year 1964. In the light of the order being in violation of principles of natural justice, I deem it appropriate to grant an interim order of stay of the said order till the next date of hearing. Learned AGA accepts notice.
For all the respondents.
All the respondents. Yes.
Cell number 5. Ganesh Raybagi.
Election na. ಇದು ಮೂವ್ ಮಾಡಿದ್ದಲ್ಲ ಮೇಡಮ್, ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ.
ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ರಿಸಲ್ಟ್ಸ್ ಏನೋ
ಎಲೆಕ್ಷನ್ ಆಗೋ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಇದು
ಇಲ್ಲ ಇಲ್ಲ, ಎಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ.
ವೋಟಿಂಗ್ ರೈಟ್ಸ್.
ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ರಾಕೇಶ್. ನೆಕ್ಸ್ಟ್ ಅಷ್ಟೇ ವೋಟಿಂಗ್ ರೈಟ್ಸ್. ಅವಿನಾಶ್ ಏನಿದು?
DCR.
DC?
Lord, the notice has been issued under section 35 clause 3 of Lord BNSS by the DCR, my lord. My lord, now my lord, the state government.
State notification ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ. Declaring it to be a police station.
Lord, kindly look at the provisions.
Police station ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಗಂಗಾಧರ್.
Lord, kindly look into the provisions mentioned in the my lord.
CRE cell is declared to be a police station. ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಅಲ್ಲ, ನಾನು ಇವಾಗ ಸಾಹೇಬ್ರೆ, ಅದು ನನಗೆ ಮುಂಚೆ ಸಿಕ್ಕಿದ್ರೆ ಮಾಡ್ತಿರೋದೆ. ನೋಡಿ ದಿ ಫಸ್ಟ್ ಮಲೋಡ್ ಅಂಡರ್ ದಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ.
ಅದೇ section 2 CRPC BNSS.
My lord, it is mentioned, the provisions mentioned in there, my lord, 2 section 2 NV. My lord, it only says about the definition of police station. My lord, it does not empower the state government. My lord, it says we have been empowered under section 2(1)(u). My lord, where, my lord, section 2(1)(u) of BNSS says, my lord, may I request your lordship to go through, my lord, the provisions?
I can't stay this notification.
No, my lord, I am not seeking a stay of this. But my humble submission, my lord, in this case.
The AGA is directed to accept notice for the respondent 1, 2. They are private respondents, yaru?
My lord, with 1 minute, my lord, I will make submission. My lord, in this case, my lord, DCRE, my lord, the police constable has issued a notice under section 35(3), my lord. My lord, in this case, the petitioner is a police inspector, my lord. My lord, in the petitioner is petitioner is a police inspector. My lord, he was serving as a police inspector of suburban police station Dharwad. My lord, one lady, my lord, that is respondent number 6. My lord, she lodges a complaint against one person, Suresh Madinor, alleging an offense under 376 clause 2, repeated, my lord, offense to promise to marry. My lord, the investigating officer, the present petitioner, who was a then investigating officer, my lord, gives a notice to the respondent number 6, asking her to give her, my lord, caste certificate. ನಿಮ್ದು ಯಾವ್ದು ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ ಅಂತ. My lord, she does not, my lord, give her caste certificate.
ಇಲ್ಲಿಗೆ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರಾ?
ನಮ್ಮ ಮೇಲೆ ಬೆಲ್ಗಮಲ್ಲಿ ಹೋಗಿ DCRE ಮುಂದೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ. My lord, in fact, she is not the person belonging to the scheduled caste. My lord, she is, my lord, we have, my lord, secured the records from the Gokak, my lord, Tahsildar office, wherein they have specifically stated that she belongs to category 1. ನಮ್ಮ ಹತ್ರ ಇದೆ ಸಾಹೇಬ್ರೆ, ಇಲ್ಲಿದೆ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 39, my lord, annexure J.
ಇದೇ ಆಗೋಯ್ತಿಲ್ಲ. ಎಸ್, ಅವ್ರು ನೋಡಿದ್ರೆ ಯಾರು LLB ತಗೊಂಡು ಎಲ್ಲಾ ಕಡೆ ಇದ್ದಾರೆ.
And my lord, in fact, my lord, she has lodged nearly about 5, my lord, rape cases against different persons. And now
habitual.
Now, my lord, on the basis of, my lord, complaint lodged before the DCRE, my lord, police constable issues a notice to me through WhatsApp.
ನೀವು ಇನ್ಸ್ಪೆಕ್ಟರ್?
It is signed by the
power of law, sir.
My lord, the provisions of law, my lord, under special act.
The petitioner,
please,
is the petitioner, the police inspector of CCB Hubballi Dharwad is at the doors of this court calling in question a notice issued under subsection 3 of section 35 of the BNSS 2023, by which the petitioner is summoned to the CRE cell for the purpose of conduct of investigation. The notice emerges on the 6th respondent initially wanting to register a crime against another accused for offense punishable under section 376(2)(n) of the 376(2)(n) IPC. ಅವಾಗ IPC ನೈತಾ? 376(2)(n) of the IPC.
Crime number 135 of 2025 by Dharwad Suburban.
In crime number 135 of 2025. In order to get to the truth of the matter, the petitioner is said to have asked the 6th respondent to submit her caste status for the reason that the complaint projected that she belongs to scheduled caste or scheduled tribe, and therefore the Atrocities Act also must be alleged. In return, what the petitioner gets is a complaint being registered by the 6th respondent before the CRE cell, and the constable of the CRE cell issuing a notice under section 35(3) of the BNSS 2023 to the petitioner.
Through WhatsApp? From his personal number?
WhatsApp. Ade illegal.
From his personal number, my lord.
Through WhatsApp. In the light of the aforesaid facts, the CRE cell to explain as to how it did entertain the complaint even without looking into the fact whether the complainant belongs to scheduled caste or scheduled tribe at the outset. As the learned counsel Avinash Angadi submits that the petitioner, the complainant, 6th respondent, does not even belong to scheduled caste or scheduled tribe, she belongs to category 1. And therefore, there could be no complaint being registered and a notice issued to the petitioner. in the light of the aforesaid circumstance, the notice, so impugned notice and all further proceedings taken to the notice or to be taken to the notice shall remain stayed.
Bless.
The learned AGA accepts notice for respondent 1 to 5. 1 to 5.
Yes.
The sixth respondent be served by way of hand summons.
ಬೇಡ ಸಾಹೇಬ್ರೆ ಅವ್ರು ಎಲ್ಲಿರ್ತಾರೋ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್. Emergent notice to the sixth respondent returnable by the 12th of
Oblige. Grateful.
ಯಾಕೋ ಪೊಲೀಸರಿಗೆ ಟೈಮ್ ಸರಿ ಇಲ್ಲ ಮೇಲೆ.
ಹೌದು.
ಎಲ್ಲ ಕಡೆ
ಈ ಪ್ರಾಂತದಲ್ಲಿ ಹಾಗೆ ಇರೋದು. ಈ ಪ್ರಾಂತದಲ್ಲಿ ತುಂಬಾ ಇದಾವೆ ಈ ತರ. ನಾನು ನೋಡ್ತಾನೆ ಇದ್ದೀನಿ.
Grateful.
Serial number 8. Serial
4 and 5, my
4
lords.
and 5, only declaration is not for.
Voting rights is already given for
ಡಿಕ್ಲರೇಷನ್ ಹಂಗಾರೆ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಯಾವುದು 4 and 5 ಡಿಸ್ಪೋಸ್ಡ್. ಎಸ್ 5 and 6 ಬೇರೆ ಯಾವ್ದೋ ಮಾಡ್ಬಿಟ್ಟಿರ ಆಮೇಲೆ. ಯಾಕಂದ್ರೆ ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಪಿಟಿಷನರ್ ಇಸ್ ನೋ ಮೋರ್ ಅಂತ ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟು ಅದೇನೋ ಆಗಿ ತಲೆನೋವುಗಳಾಗ್ತವೆ.
Serial number 8. Yes, Karnataka.
Similar to serial number 4, my lord.
8, same as serial number 4.
Please.
Same order, yes. ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ಯಾವುದು ಪಾಸ್ ಅವರಾಗಿಲ್ಲ. ಯಾರು ಹೇಳಿದ್ದು? ಗಂಗಾಧರ್ ಬನ್ನಿ, ಏನ್ ಮಾಡಿ ಹೇಳಿ. ಓ ಅದಾ, ಎಸ್ ಗೊತ್ತಾಯ್ತು. ಸಂದೀಪ್ ಹೇಳಿ ಈಗ.
Kindly have a look at the amended act.
ಆಕ್ಟ್ ಇದೆಯಾ? ನೆಕ್ಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, kindly keep the original act in place, section 11.
Yes, sir.
Section 11, kindly have a look at section 11 of the original act, that PCA.
ಕೊಡಿ ಮೇಡಮ್.
He has a copy of it.
Now,
section 11 is the penalty clause. It defines the offense.
Correct.
Now, kindly come to subsection 3. Subsection 3. Nothing in this section shall apply to. Now, there are A to E, my lord, in the original act. Now, this is amended by Karnataka amendment, and F and G is added. So, subsection 3 to section 11, nothing in this section, that is the penal clause, will apply to F and G. Kindly have a look at F and G. F is conduct of Kambala and G is conduct of bull race. I am covered under G. So, no penal clause.
ನಿಮಿಷ ಯಾವ್ದ್ರಲ್ಲೂ ಸೆಕ್ಷನ್ 11
Section 11, subsection 3, my lord.
Page number 4.
Subsection 3.
Subsection 3, earlier there was already A to E.
ಆಯ್ತು, A to E.
A to E, now F and G is added. F and G is added.
F and G is added.
Yes. So subsection 3 starts with saying nothing in this section, that is nothing in section 11, penal clause.
So you are covered under G to conduct bull and bull with a view to follow the promote tradition, culture, so and so native period of health, safety, security and well-being.
That's right.
ಅಷ್ಟೇ. Safety,
That's
security and well-being act ಪ್ರಕಾರ ಅಷ್ಟೇ.
Now kindly come to section 28A, capital A. Section 28 is there in original act. Now 28 capital A is added by the amended act. 28 is saving clause. Kindly have a look at 28. Nothing contained in this act shall render it an offense to kill any animal and so on so. Now 28A of the amended act. Kindly have a look at amended act. Now 28A reads as 28 capital A at page 5.
This
Nothing
shall apply
contained
to
in
Kambala,
the
Bull. ಆಯ್ತು.
So all that I am saying is, now kindly come back to page 20 of my.
No, this amended act itself was considered by the Supreme Court.
Yes. So therefore, under this number one, no penal clauses can be levied against me. In essence, not. I am only seeking whoever is vicarious liability cannot be put on the organizers. That's all I am saying. Now kindly come back to my annexure B, page 20. At page 21, I cannot be made vicariously liable. The villagers cannot be made vicariously liable. It is being conducted by the villagers, my lord. Now they say, if anybody does anything to the animal, you are held responsible. Number one, F and G, penal clause itself is not
As long, no. I have passed an order. I will only clarify with regard to clause 8. ವ್ಯಕ್ತಿಗಳು ಅಂತಿರೋದು, it could be joint and several. See, ultimately, in terms of the act and the amended act, whatever are the penal provisions, whatever the safeguards that are there, you should follow.
Please.
ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. State cannot issue a notification contrary to the act.
Now they have done it.
No, they won't. See, whatever the apex court found the act also in the order, sir. It said rules are not framed, but there is something on place, sir.
Now act itself says, for conduct of Kambala and bull race, penal clause is
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಈಗ
not applicable.
ಈಗ ಹೋರಿ ಹಬ್ಬ ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದೆ.
Act also enabled to give the permission.
ಆಯ್ತಾ? Now, whatever the deputy commissioner has said or will say, will only be in tune with the act.
Correct.
How can the state go beyond the act? Yes, Gangadhar.
To that extent, it can be tweaked.
Entire state amendment itself been questioned before the
Apex court. ಹೌದು.
And these are the things.
ಅಲ್ಲ, para 34 ಇದೆ ಬರ್ದಿರೋದು.
ಅಲ್ಲ, ಹೌದು. In terms of that only, my lord, we have framed it.
In terms of that only, they will act.
Framed it, my lord.
Sir, the state will not act beyond what the act has said.
Please, ಅಲ್ಲ, you all tested. Even ತಮ್ಗೇನೋ ಒಂದೇ ಒಂದು ಡೌಟ್ ಇರುತ್ತೆ, ನೀವು ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡಿ ವಿತೌಟ್ ಚಾಲೆಂಜಿಂಗ್.
ಅಲ್ಲಿ ಯಾವುದಕ್ಕೂ ಏನೂ ತೊಂದರೆ ಇಲ್ಲ.
We are not asking for quashing. No, let me paraphrase it. I am saying.
ಗಂಗಾಧರ್ ಹೇಳ್ತಾ ಇರೋದು, ನಾವು ಅವ್ರು ಕೇಳಿರೋದ್ರಲ್ಲಿ ಏನಾದ್ರು ತಪ್ಪಿದ್ರೆ ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡಿ ಅಂತಿದ್ದಾರೆ ಅವರು.
Allah, Supreme Court did not say even the organizers should be held responsible. What the act doesn't say. The act doesn't say so.
I'll tell you one thing. Supreme Court did not say that X, Y, Z or 1, 2, 3, 4. It only recognized that there is some piece of regulation, if not legislation, in the state of Karnataka. This is what is there. Again, code 122 idilla adanne vere ಏನು ಇರಲಿಲ್ಲ. So that is recognized, and towards that only it was directed. How can I tinker with the directions of the Supreme Court, sir?
No, Lord, I'm not asking your lordship to tinker with the amended act. All that I'm saying is
even the state, how can they go beyond the amended act? They will not. ಈಗ ನಿಮ್ಗೆ ಹೋರಿ ಹಬ್ಬ ಮಾಡ್ಬೇಕು, ಬುಲ್ಲಕ್ ಕಾರ್ಟ್ಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು ಅಂತ ಇಲ್ಲಿ ಹೇಳಿ, ನಥಿಂಗ್ ಇನ್ ದಿಸ್ ಆಕ್ಟ್ ವಿಲ್ ಅಪ್ಲೈ. ಅಷ್ಟೇ, as simple as that.
ಅದಕ್ಕೆ ಈ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ ಆಯೋಜಕರು ಅನ್ನೋದನ್ನ ಮೈನಸ್ ಮಾಡಿದ್ರೆ ಸಾಕು.
ಸರ್ಕ್ಯುಲರ್ ಈಸ್ ಫಾರ್, ಸಿ, ಇಲ್ಲೂ ಅಷ್ಟೇನೆ. ಯು ಕಾಂಟ್, ನೌ ಯು ಕಮ್ ಟು ಬ್ರೀಡ್ ಆಫ್ ಕ್ಯಾಟಲ್ ಆಸ್ ಆಲ್ಸೋ ದೇರ್ ಸೇಫ್ಟಿ, ಸೆಕ್ಯೂರಿಟಿ, ವೆಲ್ ಬೀಯಿಂಗ್.
ಎಸ್,
ಹೌದಾ?
ಕರೆಕ್ಟ್.
ಆ ಸೇಫ್ಟಿ, ಸೆಕ್ಯೂರಿಟಿ, ವೆಲ್ ಬೀಯಿಂಗ್ ಹೇಳಿರೋದು ಅಷ್ಟೇ. ಅವರು
ಹೇಳಿ ವ್ಯಕ್ತಿಗಳು
ನೀವು ಮಾಡಿ, ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ, ಹಸುಗಳಿಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ಅಷ್ಟೇನೆ, ಇನ್ನೇನಿದೆ?
ಅಲ್ಲ, ಹಸುಗಳು ತೊಂದರೆ ಮಾಡಿದವರಿಗೆ ಶಿಕ್ಷೆ ಕೊಡಿ, ಆದ್ರೆ ವಿಲೇಜರ್ಸ್
ಆರ್ಗನೈಸರ್ಸ್ ಲಯಬಿಲಿಟಿ ಬೇಡ, ಏನಾಗುತ್ತೋ ಆಗ್ಲಿ. ಆರ್ಗನೈಸರ್ಸ್ ಲಯಬಿಲಿಟಿ,
there is, your lordships have rich experience in
concept of vicarious liability, criminal law. That's all right.
Vicarious liability,
but that does not mean that the act which says safety, security, and well-being, not only you, whoever is in that place is definitely liable for safety, security, and well-being of an animal.
Correct.
You can't say animals, somebody will trample upon them and go and will not be held responsible. No, sir.
No, but
animals also will have to be taken care of.
Correct.
Yeah, under the act.
Under the act, yes. So who has to be primarily held responsible? ಅಷ್ಟೇ ಈ ಕ್ವಶನ್ ಇರೋದು. ಸೊ ಕೈಂಡ್ಲಿ ಈಗ ದಯವಿಟ್ಟು 8 ಅಲ್ಲಿ ನೋಡ್ಬಿಡಿ.
ಈಗ ಯು ಆರ್ ಪುಟಿಂಗ್ ದ ಕಾರ್ಟ್ ಬಿಫೋರ್ ದ ಹಾರ್ಸ್. ಇನ್ನು ಈವೆಂಟ್ ಆಗಿಲ್ಲ, ಇನ್ನು ಈವೆಂಟ್ ಅಲ್ಲಿ ಏನೂ ಆಗಿಲ್ಲ, ಆಗ್ಲೇ ಆಗುತ್ತೆ ಅನ್ನೋದು ಯಾಕೆ ನಿಮ್ಗೆ?
ಅವರು ಪದೇ ಪದೇ ವಿಲೇಜರ್ಸ್ ಯಾವಾಗ ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ತಾರೆ, ಇದೇ ತರ ಹೆದರಿಸಿ ನೀವು ಆಯೋಜಕರು ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ ಕೇಸ್ ಮಾಡ್ತೀವಿ, ನೀವು ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಮಾಡ್ತೀವಿ. ದಿಸ್ ಇಸ್ ಹೌ ಇಟ್ ಇಸ್ ಬೀಂಗ್ ಯೂಸ್ಡ್. The act doesn't provide that.
See, all of you, sir, I'll tell you 1 minute, one thing, Sandeep.
Yes, ma'am.
Just because it's an animal and something happens to it, all of you wash off your hands. We will not entertain that. We will not do that at all. Even whether it is a bullock or a cow or whatever animal, its protection is our duty.
Our duty under the act.
Anybody can do anything to the animal. No, we can't be held responsible. And no, in whose event is it is being taken now? Nim event tane adu.
Lord, my event, Lord, I have taken all the responsibility to safely conduct it. ಆದ್ರೆ ಇನ್ನೊಬ್ರು ಬಂದು ಅವನು ಯಾರು ತೊಂದರೆ ಮಾಡಿದ್ರೆ ಆಯೋಜಕರನ್ನು ನಾವು ಜೈಲಿಗೆ ಹಾಕ್ತಿವಿ ಅಂತ ಹೇಳೋದು ತಪ್ಪು ಅಂತ ಅಷ್ಟೇ. ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್.
ಆ ತರ ನೀವು ಆಯೋಜನೆ ಮಾಡಿದ ಮೇಲೆ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಫಾರ್ ದಿ ಅನಿಮಲ್ಸ್. ಯಾರೋ ಬಂದು ಏನೋ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೋದು ಅಂದ್ಬಿಟ್ರೆ
ಇಲ್ಲ, ಯಾರೋ ಬಂದು ಏನೋ ಮಾಡ್ಕೊಳ್ಳೋದು, ಯಾರು ಮಾಡ್ತಾರೆ ಅವ್ರನ್ನ ಶಿಕ್ಷೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ದಟ್ ಇಸ್ ಒನ್ ಮಿಲಾಡ್. ದೆನ್
ಯಾರು ಮಾಡ್ತಾರೆ, ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಸರ್,
15
ಯಾರು ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ತಾನೇ ಆಗ್ಬೇಕಾಗಿರೋದು.
ಹೌದು, ಮಾಡ್ಲಿ.
ಅಂದ್ರೆ
ಅಲ್ಲ, ಮಾಡ್ಲಿ. ಆದ್ರೆ ಇವ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ತಿವಿ ಅಂತ ಹೇಳಿ ಇದನ್ನ ಆತರ ಯೂಸ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ಅಷ್ಟೇ. ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್. ಆಯ್ತು, ಅದು ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಅ ಲುಕ್ ಅಟ್ 15 ಆಲ್ಸೋ. ಅಲ್ಲ, 15 ನೋಡೋಣ.
I will only clarify that it will be only in tune with the act and the amended act as recognized by the apex court. Ashte, that will protect your interest. You hori haba ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ. ಸೋಮವಾರ ಏನಾದ್ರು ತೊಂದರೆ ಆದ್ರೆ ಹೇಳಿ, ಭಾನುವಾರ ತಾನೇ ಇರೋದು.
ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಆಲ್ರೆಡಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನೋಡ್ಬಿಡಿ. ಸರ್ಟಿಫಿಕೇಟ್
8 ವ್ಯಕ್ತಿಗಳು ವಿಷಯವಾಗ
ವ್ಯಕ್ತಿಗಳು ಕೊಡಬೇಕು ಸರ್ಟಿಫಿಕೇಟ್.
Don't think that is even needed.
ಅಲ್ಲ, ಅವರು
ಅದು ಬೇಕಾಗಿಲ್ಲ. ಏನಂತ
ನೀವು ಯಾರು ಆಯೋಜಕರು ಇದೀರೋ ಅವರೇ ಸರ್ಟಿಫಿಕೇಟ್ ತಂದು ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ.
ವ್ಯಕ್ತಿಗಳು ಅಂತ ಇರೋದಲ್ಲಿ ವ್ಯಕ್ತಿಗಳು, ಯು ಕಾಂಟ್ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಯುವರ್ ಸೆಲ್ಫ್ ದೇರ್. ವ್ಯಕ್ತಿಗಳು ಅಂತ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲ, ವ್ಯಕ್ತಿಗಳು ಅಂತ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವೆರಲ್ ಅಂತ ಅರ್ಥ ಅಷ್ಟೇ.
ಪರ್ಸನ್ಸ್ ಅಂದ್ರೆ whoever is responsible for the cattle, my lord. I am conducting. I cannot ಅಲ್ಲ, ನಾನು veterinary doctor.
I will only clarify, Sandeep, I will only clarify one thing, that the circular will have to be read with what the apex court and the act are. Beyond it, the circular is unimplementable. That is obvious. Circular cannot override the act. ಅಷ್ಟೇ, ಅದೊಂದು ಲೈನ್ ಹಾಕ್ತೀನಿ, ಅದ್ ಬಿಟ್ಟು ಯಾವ ವ್ಯಕ್ತಿ ಅವೆಲ್ಲ ಏನಿಲ್ಲ.
ಆಯ್ತು,
it cannot override the act.
One second, 15 ಒಂದು ನೋಡು, kindly have a look at 15.
15
ಅಲ್ಲ, ನಮ್ಮ ಕಂಡೀಷನ್ ಅಲ್ಲಿ
para 21 condition, page 21 para 15. ಇದಕ್ಕೂ ಏನ್ ಹೇಳ್ತಾ ಇದೀವಿ? ವಿಲೇಜರ್ಸ್, once I take the permission from the deputy commissioner, they are expecting me to go to all the departments and give a copy of it. So we requested the deputy commissioner, you have all the wherewithal, kindly circulate your orders to all the authorities in your
15 ಅಲ್ಲಿ 15 we will clarify. Once it is given electronically, it can be sent to all departments. That is all.
Now,
all right. And 8 ಗೆ ಏನು clarification ಬೇಡ, in tune with the act and the amended act as interpreted by the apex court. I will add that.
17 ಒಂದು ನೋಡ್ಬಿಡಿ ಅಲ್ಲಿ. 17
ಓರಿಯೊಬ್ಬ ಇಲ್ಲೇ ಮಾಡ್ತಾರೆ.
A lot of emotions are involved in this, so therefore 17.
ಕಮೋಷನ್ ಆಗ್ಬಾರ್ದು ಅಂತ ತಗೋತಾ ಇರೋದು.
ಕ್ರೀಡೆಯನ್ನು ಆಯೋಜಿಸುವ ಆಯೋಜಕರು, ವ್ಯಕ್ತಿಗಳು, ಸಂಘಗಳು ಎತ್ತಿನ ಓಟ, ಎತ್ತಿನ ಗಾಡಿ ಓಟದ ಪ್ರಾರಂಭದಿಂದ ಅಂತ್ಯದವರೆಗೆ ಚಿತ್ರೀಕರಣ ಮಾಡುವುದು. ಚಿತ್ರೀಕರಣ ಒಂದು ಪ್ರತಿಯನ್ನು ಸ್ಥಳೀಯ ತಾಲೂಕಿನ ತಹಸೀಲ್ದಾರ್ ಕೊಡುವುದು. Villagers, when they are celebrating the festival, there is no question of having some kind of videography to be done by them. No, I cannot do the media. It's all kindly visualize, no, it is being held in a small village.
ಇಲ್ಲ ಅಂದ್ರೂನು ಅಲ್ಲ ಇದು ಏನಿಲ್ಲ ಅಂದ್ರೆ ಒಂದು 100 ಮೊಬೈಲ್ ಫೋನ್ಸ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಏನ್ ಚಿಂತೆ ಇಲ್ಲ.
ಅದಿರ್ಲಿ, ಅದು ಅವ್ರು ಕಲೆಕ್ಟ್ ಮಾಡ್ಲಿ, ನಾವು ಮಾಡೋದು ಬೇಡ. It cannot be as a condition precedent to hold ಅಷ್ಟೇ.
So if this is not enter the act, we will say it will, I will only say the circular or the government order will have to be read in tune with the act. That's all. And as recognized by the apex court. That one line add ಮಾಡ್ತೀನಿ, ಈಗ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
15 and 17 ದಯವಿಟ್ಟು ತಾವು kindly.
15 ಅದು ಹೇಳ್ತೀನಿ. It will be circulated, electronically circulated to all departments.
And videography
ಎಲ್ಲ ತಗೊಂಡು ಹೋಗಿ
ನಮ್ ಕೆಲಸ ನಾವು ಮಾಡ್ಬೇಕು.
and videography exemption.
ಅವರು ಅಡ್ವೊಕೇಟ್ ಹೌದು, ಪೊಲಿಟಿಕಲ್ ಲೀಡರ್ ಹೌದು, ಹಂಗಾಗಿ ಇಷ್ಟ.
No, I am only an advocate before court.
ಇಲ್ಲ ಅದಕ್ಕೆ ಈಗ ಪ್ರೊಟೆಸ್ಟ್ ಅಂತೂ ಇಲ್ವಾ? ಸರಿ,
ಪ್ಲೀಸ್
ಕರೀರಿ ಮೇಡಮ್.
ಒಬ್ಲೈಸ್.
ಬೆಂಗಳೂರು ತಗೊಂಡೆ.
Court officer madam.
Yes madam.
Serial number 69 ಏನಾಗಿದೆ?
ರಿಸರ್ವ್ ಆಯ್ತು ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಅದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕಿತ್ತು ಅದರಲ್ಲಿ.
ಮೇಡಮ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಮೇಡಮ್ 67, 68
67, 68 and 69. All of three are reserved.
ಓಕೆ ಮೇಡಮ್ ಐಒ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ, ಅದೊಂದು ಆಗ್ಬಿಡ್ಲಿಕ್ಕೆ.
ಸರಿ ಮೇಡಮ್ ಹೇಳ್ತೀನಿ.
ಮೇಡಮ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಬೆಂಚ್ 10th ಮ್ಯಾಟರ್ ಮೇಡಮ್ ವಿಸಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಅದು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್.
ಯಾವಾಗ ಅರ್ಜಿನ್ ಯಾವಾಗ ಆಯ್ತು
ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಮೇಡಮ್, ಬ್ಯಾಂಗ್ಳೂರ್ ಪ್ರಿನ್ಸಿಪಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಹಾ, ಸೀರಿಯಲ್ ನಂಬರ್ 6.
Serial number 6, 5th January sir.
Serial number 4 madam.
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡೋದು
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ
Next week sir.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ಇದು ಎಂಟ್ರಿ
ಮಾಡಿ
ಮಾಡೋದು
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್. ಅದು ಅರ್ಜೆಂಟ್ ಆಗಿದ್ದಿಲ್ವಲ್ಲ ಮೇಡಮ್ ಬೆಳಗ್ಗೆ?
ಹೇಳಿ ಸರ್. ರವಿ ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಮೇಡಮ್ ಏನಾಯ್ತು ಬೆಂಗಳೂರು ಬೆಂಚ್?
Serial number 4 in principal bench list. 9th of January interim order extend ಆಗಿದೆ ಸರ್.
ಓ ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ನಲ್ಲಿ ಏನಾದರೂ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Serial number 10 ನಲ್ಲಿ
ಡೇಟ್ ಏನಾದರೂ ಇದೆಯಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರು ಸರ್.
ಅಷ್ಟೇನಾ
ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಎಸ್ ಸರ್.
ಬೆಂಗಳೂರು ಬೆಂಚ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2, ಬೆಂಗಳೂರು ಬೆಂಚ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಏನಾಯ್ತು ಮೇಡಮ್?
Serial number 2, 9th January sir.
Okay madam.